Um, so, good morning, everybody. Thanks for coming. We'll have a full house here, hopefully by the time, because we have turned people away, actually. We're not bragging about that, but what the heck. We've got a great group of speakers today. I'm going to let Lindsay introduce herself, and I thank her for this great venue because she and her husband Ethan are members here, and I'm just a wannabe who actually did cross the river from St. Paul today to make it over here, but I'm not telling people that. So anyway, Lindsay, do you want to say a few words and introduce our friend Pete?
Well, I'll let you introduce Pete, but thank you everyone for coming today let me see if I make sure I get this right. Torts, Sports, Trial, and Insurance 1, our first year. So thanks all for registering in advance. Also, I would encourage you at some point in the room kind of adjacent to us, we have all our sponsors. If you need to take a phone call, please make it in that room also. We have a bar in there for the social hour and a deck, so you can use that space as well. Restrooms are down the hall to the left. Anything else?
No, but also, if you don't leave with something today, a gift card, bottle of wine, a pound of coffee, some other things we have to give away, really that's on you because you got to be bold. So if you leave early, take a pound of coffee or a bottle of wine. And don't be bashful about asking for it. It's sitting out there.
And don't be greedy.
But we don't want to take it. We don't want to take any home. At least I don't. Okay, so our first speaker is Pete Thrain with Stinson. Pete and I go way back to working together when I was working with State Farm in the legislative team. Pete is top shelf, probably the most knowledgeable insurance regulation lawyer in Minnesota, along with Dale Thornjoe, who's here somewhere. There's Dale and Pete and a group of us. If you're a plaintiff's lawyer and you don't like 60418 because you don't think it's punitive enough against the industry, you can thank the likes of Pete and Dale and some of us because we did a really good job on that. Back when that was my role because it's all about being an advocate, right? So wherever you're advocating, whatever side you're on, that's what you do. That's why we like this event to be both sides of the bar because everybody's got a voice and everybody has something to say. Pete Thrain, come on up, Pete. You can kick us off, but Pete is the leg rag guru. And that's the introduction. All right.
Well, thank you and good morning. It's a pleasure to be with you. And Brett, thank you for putting on this program. I have to say I've met some great folks here, and I've actually referred some businesses as a result of this, so thank you for the introductions for doing that. Again, I'm Pete Thrain. I'm with the Stinson firm, and I work with a group of lawyers in our firm, and we handle insurance transactions, regulation, and governance, again, for insurance businesses. And we also work with our legislative team. We have 5 people full-time at the Capitol. And between the two of us, our two groups, we've worked on insurance regulation in Minnesota for a long, long time. And we've been involved in most of the major insurance regulatory initiatives at the Capitol for a long, long time. Each year seems to have kind of a theme when it comes to insurance regulation, legislation. This year's theme has been storms and weather. And the numbers tell the story here. Here is the NAIC, National Association of Insurance Commissioners, data on homeowners insurance premium, loss ratio, losses, and return on net worth. And you can see from these statistics that Minnesota, particularly recently, has had a number of substantially bad years from an insurance standpoint. Now, not all of those losses are weather losses, but the bulk of them are. And when you see volatility, the volatility is in the weather losses. Fire losses tend to be very stable over time. The other thing I would point out, obviously, is that return on net worth, there's been a loss over the last 5 years. 2023, anecdotally, shouldn't be any better. And so we are having some bad weather issues in Minnesota now. As I said, roughly 50% of those losses are attributable to weather claims. 20% to 25% tend to be attributable to freezing and water damage, and only 25%, depending upon the year, tends to be from fire claims. You know, there's a thought that this is fire insurance. It's kind of stopped being fire insurance over the last several years. It now tends to be storm and water insurance. So what's some more statistics here? So in 2023, we had the 2022 as the last statistics. In 2023, we had 387 major hail events, which is third in the United States, and then we had 77 tornadoes. Put them together, and I think we're going to see a 2023 in terms of losses that's not unlike 2022, maybe not quite as extensive, but very similar. On the same hand, we've seen an awful lot of inflation. 10 years ago, the cost of a hail claim was roughly $15,000. A square shingles cost $355. Now, that has then, hang on, that's now doubled to about $30,000. And again, Minnesota's homeowners premium, think about this, in 1998 was $455 a year, and now it's $1,411 a year. I mean, we've seen an awful lot of inflation. Again, that's been driven largely by storm and weather losses. I think the interesting statistic is in 1998, Minnesota was the 35th highest homeowners premium, and by 2021, we are now the 12th highest. So this weather phenomena is not necessarily a countrywide issue, but it's something we're seeing here in Minnesota. And these statistics are from the National Oceanic and Atmospheric Association and from the III. So obviously, a ton of this is driven by weather losses and weather losses alone. Sort of in my view, Minnesota insurance regulation is a contributing factor to this. That Minnesota regulation tends to exacerbate these costs. Under current law, Minnesota insurance regulation restricts underwriting and pricing of a homeowner's insurance policy. A homeowner's insurance policy cannot be terminated, cannot be non-renewed for a weather loss. The premium cannot be increased for an individual policyholder based on a weather loss. And then a deductible cannot be added or imposed as a result of a weather loss. Consequences of which are that there is really no incentive for a policyholder to try and mitigate their homeowner's losses. I know I feel that, I'm sure you do as well. If a storm goes through, somebody goes pounding on our door in our neighborhood that says we can get you a free roof. My wife says, well, why don't we get a free roof? I said, well, we don't need a free roof. And, well, we don't have to pay for it. And I said, well, we'll all pay for it in the form of higher premiums. And so, you know, in my view, this combination of regulation creates what I would call a weather hazard, pardon me, a moral hazard, simply because there's no incentive to avoid any kind of claim mitigating behavior. Now, this series of regulations is based on sort of a premise that homeowners' losses, weather losses, are total fortuity, that there's no activity that a homeowner can do that would mitigate those losses. If you live where a storm hits, the dollars paid, that's something totally beyond your control. Now, I think we can argue whether or not that matters, but it turns out that there are some statistics that sort of mitigate against that. Now, I've got some old statistics, and that says that 4% of homeowners insurance policyholders have had 2 or more wind hail losses in a 5-year period, and the loss ratio on these policies was over 400%. And then 0.3 of the homeowners insurance policyholders had 3 or more wind losses in a 5-year period. An awful lot of the wind losses and the hail losses appear to be driven by a small group of policyholders that have multiple claims. Now, whether that's they live in a storm-prone area or not, hard to say. Whether these policyholders are susceptible to some of these storm chasing activities, hard to say. The other thing that's interesting is that having weather loss is predictive of a future claim, so that a person with one weather claim in the last 5 years was 40% more likely to have a claim in the next 3 years. And so the assumptions that were built into the Minnesota insurance regulation, I question whether they're true, and I think our homeowners insurance problem in Minnesota has been exacerbated by the current law. Now, to the great credit of our public policymakers, state insurance regulators, and the state legislature, they're beginning to recognize that homeowners insurance premiums are a significant political issue, that the incidence of weather claims and the handcuffs that Minnesota law places on insurers in trying to manage those claims, starting to begin getting some sensitivity to that. You recall the Everett Dirksen, the senator from Illinois, who used to say that the more I feel the heat, the more I see the light. Well, legislators and regulators are starting to feel the heat. As a result, there's starting to be some cracks in the facade of Minnesota's insurance, very restrictive weather regulation. So there's some pending legislation. We think it would have been signed by the governor by now, but with things happening at the Capitol politically the way they are, it's still pending. I expect this legislation to pass. There is essentially one bill that contains pretty much all of the insurance regulatory measures in them. That's Senate File 4097. That's a conference committee report. It's been adopted by the Senate. It's awaiting action in the House, at which point it will go to the governor. I would expect the next few days, it needs to get done by Sunday night. I would expect that that would get processed in the Senate, and I would expect the governor to enact it, but it's not yet enacted, although high probability. So they've done two meaningful changes. Number one, it permits an insurer to non-renew a homeowner's insurance policy after 3 weather losses in a 5-year period. Now, that's a very small number of policyholders, but very expensive group of policyholders. And conceivably, if there's a threat or a risk of that, that may impact claiming behavior. And I think even more interestingly enough, it permits imposing a deductible on a homeowner's policy after a weather loss. And it's a deductible that's for the weather-related exposure in one of 2 ways, either a flat deductible or, more interestingly, I think, a percentage-based deductible, and that is that a percentage of the loss, of the weather loss, then becomes part of the policyholder's responsibility. It does not address the pricing of homeowners' policies based upon an individual weather loss. Maybe that's to come. This is an important first step, and I guess I give credit to the Minnesota legislature and the regulators for appreciating the needs to address this in light of these homeowners issues we're experiencing. Now, the other thing that's happened sort of on the claims side of it is that there's some legislation to address some residential contracting issues. I think that we all, actually today as I was driving here today, I heard 2 advertisements for roof replacement. I drove by a truck that said, "We are the storm repair specialists." If you look at those numbers, $4 billion in homeowners losses, a substantial portion of which is weather-related losses. I think you can see that roof repair has become big business in Minnesota, that there are many, many high-integrity contractors in this area, but there are certainly some members of that industry that engage in some pretty aggressive practices. One practice that was tried about 5 years ago was when the contractor would say, "I'll pay your deductible." Well, the legislature prohibited that about 5 years ago. Clever operators found ways to work around that by saying that I will give you a payment if you let me inspect your property. I will give you a payment if you make an insurance claim, I will compensate you for making the claim. Or if you refer me to another customer, I will compensate you for that. And that would be roughly, comes out just magically about the amount of the policyholder's deductible. So in this legislation, again, extends the deductible prohibition to include those practices. And here's probably the most significant. You hear an awful lot of the contractors say, "I will handle your insurance claim with your insurance company for you. I will act as effectively your public adjuster in talking with your insurance company." This legislation prohibits that. And so, again, this is another step in the right direction, sort of focusing on those contractors that have business practices that are pretty aggressive. So here's another issue that you may have run into. It's a very interesting problem with different insurance policy coverage provisions. And that deals with the coverage for a townhome policy or a condominium policy, whereby the question is, the townhome has a loss, there's an uninsured portion, an assessment is made on the members of the homeowners association to fund the uninsured portion of that loss. And the question is, what policy covers that loss? Is it the policy in force at the time of the event, the weather event, the loss occurred? or is it the policy in force at the time the assessment is levied? And there were differences among insurance companies, and that created lots of issues in these townhomes associations. So Minnesota law essentially is being enacted now to sort of make it clear that so long as the policyholder at the time of the loss and the policyholder at the time of the assessment is the same policyholder, the policy at the time of the loss is what covers the loss, and that's going to be uniform regardless of what the contract says. In the event that there's a difference between the policyholder at the time of the loss and the time of the assessment, then in that case, it's the policy at the time of the assessment that covers the loss. And so that should bring some clarity to this and eliminate a lot of complications. This was very controversial at the Capitol. The Minnesota Department of Commerce received many, many complaints on this, and so the legislature responded, I think, in a thoughtful way to address that circumstance. In addition, last year, there was a price gouging legislation that was enacted in Minnesota. If the governor declares a certain kind of a catastrophe, there's some regulation and limits on sort of the remediation costs. It was focused principally on contractors. This legislation then extends that to tree trimmers and restoration companies. Anecdotally, the stories the legislature heard about tree trimming costs being 2-3 times what the cost would be following a catastrophe than they were prior to the catastrophe, and so now that has been extended as well. Hang on, come on. And there's a couple other miscellaneous provisions in there. I don't know if any of you represent or work with township mutual insurance companies, but you may be aware that those reinsurance companies have lost a ton of their reinsurance capacity. They're small companies. They're based in a particular county or a township. They insure folks' property insurance principally only within that territory. They then reinsured their liability losses with a couple companies. Because of the storm losses and because of the activity here, those reinsurers have pulled back on offering that coverage to township mutuals in Minnesota, which caused a crisis of capacity. These companies don't have a huge amount of surplus. They certainly can't offer liability coverage. They don't have the capacity to write this. As a result, a lot of these little companies are in trouble. And so the legislature responded by sort of allowing these companies to merge, and they did that by expanding their ability, their geographic presence, which was up to 30 counties. In the past, it was limited to about 10 counties was the maximum these counties could write in. And so if you had a company in this area and a company in that area and they had their candidates to merge, they couldn't because they had differing footprints. The legislature now permits that to happen. And finally, there's a provision in this law, I think that's really important, and it permits territorial rating. You may not be aware of this, but Minnesota law is very restrictive on how insurance companies put their territories together in order to sort of adjust the rates by geographic location. The legislation has been adopted to permit that, but for the top 15 cities, the 15th largest cities of Minnesota will have to be each one rating territory, and then the balance of the state can be rated accordingly. So let me just breeze through a couple pieces of other things that you may be interested in. If anybody here represents bail bond providers or avail themselves of bail bonds, Minnesota law has been enacted, a comprehensive rewrite of the regulation of bail bonds. It's new Chapter 60M. I didn't read it. It's long. It looks fairly comprehensive. And if you're in that business, you're going to want to know about that. If you're involved in the surplus lines brokers now no longer have to do a diligent search. They can, if the risk is presented by a retail agent, the surplus lines agent can place the business without a diligent search. And finally, and this is fairly significant, there is a piece of legislation that deals with the insurable interest following the death of death of a homeowner to say that the estate continues to have an insurable interest in the property under a death deed. I don't know much more about that. Somebody else handled that, but I think that's fairly significant. With that, Brett, I think I can wrap it up. Thanks very much.
All right, next up, I'm honored to introduce my colleague, Andy Sherwood. Andy Sherwood is a trial attorney at Keller, Woods & Thompson. You probably also recognize him as being in-house staff counsel at Progressive for many years, but you started your career, Andy, as a plaintiff's attorney, which I appreciate. Andy will be speaking today on our offense.
Good morning. I guess I want to start by thanking Lindsay and Brett, wherever he is. There he is. for giving me the exciting opportunity to talk about radio frequency neurotomy cases from an insurance defense perspective and a plaintiff personal injury perspective. Based on my background in working at Progressive Insurance Company for almost 19 years, part of my discussion will probably have a bit of an insurance defense slant, but seeing all the, I see a lot of plaintiff personal injury attorneys out there, a lot of faces of people I had cases against, including Jeff Sieben, who actually helped with this presentation. I do want to present this case this presentation from more of a plaintiff perspective and focus on how do we, if you have an RFN case, motivate an insurance company to take what typically starts out as a soft tissue injury case, a case that, and again, we're going to kind of use insurance company terms, maybe has a reasonable settlement value of less than $10,000, and maybe elevate that case into a value that maybe exceeds $100,000. How do you motivate an insurance company to do that and offer that type of money when you get to mediation? Or if the insurance company doesn't want to do that and they want to try the case, how do you motivate a jury to buy into what effectively is an injury case involving an injury that you can't see, that you can't diagnose with an imaging study? On the subject of whether or not you can build an RFN case into a six-figure case, that is provided you're not dealing with a situation where you have a big vehicle, small policy. More on that maybe from Eric. He's a trucking company, or truck insurance litigation specialist. He might talk about that particular subject. So of course you have to have the insurance coverage to get that big settlement in these types of cases. So let's talk about how you evaluate an RFN case by talking about what an RFN is. If you look at the medical records from your clients, if they go the route of a pain management specialist, you might see the term radiofrequency neurotomy, or RFN, as an option to treat typically chronic neck pain. You might also see the term radiofrequency ablation or rhizotomy. These are all the same terms to talk about the same treatment, that is, to treat chronic neck pain from what is typically described as a facet joint injury. In, I think, effectively advocating for your client and motivating an insurance company to offer fair value for these types of cases, to take what typically starts as a soft tissue injury case and bring the value of that case up to a higher value. I think it's important to understand the medical science behind radiofrequency neurotomies and understand the type of injury this form of injection therapy is meant to treat, and that is a facet joint injury. One of the articles that I've seen come up during my doctor depositions on these cases, going back as far as when I was trying these cases for Progressive and using Dr. Irfan Altafallah as my medical expert. Those of you who have had RFN cases know Dr. Altafallah is a very popular defense expert for these types of cases. He's a neurologist at the Minneapolis Clinic of Neurology. I know that during my direct examinations, during those doctor depositions, an article has come up, the title of the article, and Jeff Sieben was kind enough to forward this article to me because this article came up during a case we had in early 2022, an RFN case, where Jeff used Dr. Steve Sabers as his medical expert. The article is entitled Cervical Zygapophyseal Joint Pain. It's kind of a mouthful. It's the title is, it's a Neurosurgery Quarterly 1998 article. I think most doctors that deal in physical medicine and rehabilitation or treat chronic pain from, well, the term zygapophyseal, it's another term for a facet joint pain, they will agree that this is a very solid foundation in understanding what a facet joint injury is and why an RFN treatment can remedy that type of chronic pain. The article is written by Nikolai Bogduk and Susan Lord from a British University of Newcastle. So some of the terms in this article are not terms we typically use here in the United States, but the concepts in this article give you a very good understanding as to why someone may want to undergo an RFN to treat chronic pain. Namely, it goes over the nature of a facet joint injury and how it causes chronic pain, namely, or more often than not, in the neck. And one of the major takeaways from this article, it discusses the diagnosis of this type of injury. Namely, this is not, a facet joint injury is not an injury you can see with an imaging study. You can't see it with an MRI exam, you can't see it with the CT exam, or an x-ray. So that's the challenge that doctors face and plaintiff attorneys face is if in fact someone has a facet joint injury that might be amenable to radiofrequency neurotomy as a form of injection therapy to treat that chronic pain, how do you diagnose this injury? What the article states is because you can't see this spinal injury with an imaging study, you've got to go through what's called a comparative block methodology using, and again, I'm sure a lot of you have heard this term if you've handled RFN cases, a medial branch block. To understand how a medial branch block can diagnose a nerve a facet injury, you have to understand a little bit about the nature of the injury itself. A facet joint injury typically involves the facet joint, which the way it's explained in the article is you have these small articulations in the vertebrae of the spine that connect, that cause or allow the vertebrae to move. These articulations are richly innervated. There are nerves that come out of these articulations, and these nerves can cause pain if a person suffers injury to their neck from, say, a motor vehicle accident. So now that we know that the nature of the injury is a nerve injury, how do we diagnose the injury and discover whether or not a patient or plaintiff is a candidate for radiofrequency neurotomy treatment? You use this medial branch comparative block methodology where the injection specialist or pain management specialist injects the area where, or the nerve that's suspected to cause the pain, injects that nerve with an anesthetic, and then that is anesthetic, after that procedure, the patient reports to the doctor whatever type of pain relief they have from that anesthetic. That pain relief, that reported pain relief has to be concordant or consistent with the type of anesthetic used. And if that person has a concordant or consistent report of pain relief from that anesthetic, you know that maybe you found the nerve that's causing the pain. Now, the problem with only doing one cervical medial branch block is that you do have this issue with what Dr. Altafala has termed patient bias, or another way of putting it is you might get a false positive. And this can be especially problematic if you're dealing with a patient that has a personal injury claim that maybe in the back of their mind as they're going through this process, they're thinking, hey, this procedure, if it works, this could maybe result in more money for me for my personal injury lawsuit. So maybe I'm motivated to believe that this treatment's working for me and that I can move on with this form of, frankly, very invasive therapy to get rid of the pain, get better, but also maybe get a bigger recovery on my personal injury lawsuit. I guess this is the insurance defense part of me speaking right now. So in order to avoid that patient bias or false positive, you want to do a second medial branch block with a different anesthetic. And what you want to see from that different anesthetic is, again, a concordant or consistent pain relief response that would be different than the first. And if that second medial branch block provides consistent pain relief based on that different anesthetic, now you have a higher degree of certainty that the nerve that was treated with the anesthetic is the nerve that's causing the pain. And now you know that that's the nerve that you want to ablate or sever to get rid of that pain. This is where we get to the part of what is a radiofrequency neurotomy treatment, what does it actually do? I'm probably talking to a lot of attorneys right now that have handled these cases that have a good idea what an RFN is, but we'll talk about what it actually does during this presentation. So you look at the actual word or term itself, radiofrequency. Again, what happens is you have this needle that vibrates rapidly at a radio frequency that heats up the needle that's injected into the spine at the location of the pain-causing nerve. And then what that superheated needle does, and of course this is done with a local anesthetic, is it cauterizes or severs the nerve that's causing the pain. And if that in fact is the nerve that's causing the pain, and that nerve is cauterized or severed, again, common sense tells you the pain should go away. So that's the treatment in a nutshell. When I handle these RFN cases, I think about if I had to try this case from the plaintiff's perspective. I have tried these cases or these types of cases on the defense side, but from the plaintiff's side, I've never tried a plaintiff RFN case. I think to myself, RFN therapy, superheated needle, cauterizing a nerve that you can't see on an MRI exam, that's a really esoteric concept. And this gets us to evaluating these types of cases. And again, when I say esoteric, I think, hey, I'm going to have a group of jurors that probably have no idea what a facet joint injury is. They don't know what an RFN is. And so you're going to explain to them, hey, here's this injury you can't see that is treated with, frankly, a very expensive procedure. I just mediated a case with Brett earlier this week where my client looked at his bills. He's getting bilateral RFNs at a cost of $10,000 per side. Again, convincing a jury to award that type of money, you really have to crystallize that this is a real thing for your client. And to convince a jury to award damages that could range from tens to hundreds of thousands of dollars in past and future medical treatment to manage these chronic neck issues. So here's how we crystallize these issues, and let's talk about at the mediation stage to first off convince a claim representative, yes, this is a real injury, yes, this is likely going to result in a big jury award value, so pay fair money for this type of claim. I'm going to talk about the things you want to look for in properly evaluating the case to make sure you have that type of case, or conversely, you may have a client who thinks they have a really high value case, they're receiving this invasive therapy, but maybe their RFN therapy is not working out the way you would hope, or in a fashion that you can convince a jury, hey, this is a real thing, award my client a lot of money for this treatment. So, a proper evaluation of these types of cases also can help to temper your client's expectations when you get to mediation and negotiate settlement of these cases. So what I look at when I look at whether or not I have a good or strong RFN case versus maybe not so good in RFN cases, typically, like I said before, these cases start off as soft tissue injury cases where the plaintiff, the patient, they're in an accident, they have neck pain, it persists, they maybe go to an ER, they have imaging done of their neck, their back, x-rays initially don't show any broken bones in the spine. The patient might go see a chiropractor, as people often do, to deal with what is presumed to be muscle pain in the neck. That might not work over time. Chiropractic care may provide short-term pain relief. You move on to maybe physical therapy, where the plaintiff is doing the work. They're trying to get better with this presumed muscle injury to the neck. The physical therapy doesn't work. Then you see a progression to maybe a neurologist. And then maybe from there, the neurologist says, well, maybe there's something wrong with the discs in your spine. Maybe there's a herniation. Maybe there's inflammation. You might be a surgery candidate. I'm going to refer you for MRI exams. The MRI exams come back, and experienced neurologist or maybe even a neurosurgeon comes into play, looks at the film from the MRI exam and says, hey, I see some degenerative disc disease, but I don't see a disc that's actually, maybe an extrusion that would warrant a surgery or a discectomy, removal of the disc to, remove the pain that's being caused for the plaintiff. So you rule out the fact that the person might be a surgery candidate. What I'm trying to say is an RFN treatment or therapy, it should be a treatment of last resort, because it is such a esoteric and conceptually difficult thing to understand. And I think from a plaintiff's perspective, and also certainly in convincing an insurance company to maybe pay more than they want to on what they believe to be a soft tissue injury case, you really have to show that, hey, there was a lot of workup to get to the point where now you're resorting to sticking a superheated needle in somebody's neck to resolve this pain, which frankly, I don't think there are many people out there that would want to undergo that type of procedure. It just, from an aesthetic standpoint, doesn't seem like a very comfortable situation to have to be involved in. So again, what you want to be able to present to the mediator, to present to defense counsel and insurance company rep is, hey, we're here, we've got the RFN therapy happening, it's an expensive procedure, it's a procedure that can be repeated. I guess one of the things the lead I kind of buried here is the medical science tells us that once you cauterize that nerve or sever that nerve to get rid of the pain, what can happen typically is that nerve grows back, typically within a year after the procedure, and thereafter the treatment can be repeated over and over again. Again, the medical bills go up because the procedure is a very expensive procedure, but again, it's a way to say, hey, this is a repeatable procedure, it's an expensive procedure, it provides long-term pain relief up to a year, and also, by the way, it's going to cost my client maybe $20,000 to $30,000 a year for maybe 4 or 5 years down the road to maintain and manage this chronic pain with this type of procedure. So you want to see that workup. You want to be able to tell the insurance company, my clients tried everything they can to get rid of this pain and nothing's worked. And now they're resorting to this procedure that frankly they don't want to do, but it's the best thing, the best option they have to get rid of this chronic pain. It's the way that they can get rid of the chronic pain for the longest period of time. So I think that's an important aspect you want to show or demonstrate to a mediator and an insurance company about the strength of the value of your claim for, again, ostensibly future radiofrequency neurotomy to manage the chronic pain. Other elements that you want to look at in your case, you want to make sure or verify whether or not the pain specialist that's treating your client is actually doing that comparative block methodology in diagnosing the facet joint injury. I often see doctors, I'm not going to name names, but you'll see doctors that only do the one medial branch block, the one anesthetic. And I think the reason they do it is health insurance companies typically require that type of process before they'll pay for an RFN if in fact you get a situation where no fault's exhausted and health insurance company or health insurance steps in to pay the medical treatment. If you have a case where the pain management specialist only does the single medial branch block, then as a defense attorney, I'm going to use this Bogduck article through my defense expert to say, hey, only the one medial branch block, only the one anesthetic. Hey, that raises the possibility we've got patient bias in this case. We've got secondary gain. And maybe this person really isn't actually a candidate for this really expensive procedure. Maybe what they're dealing with is maybe they're not injured at all, or it's basically back to a muscle-based injury. So you want to make sure or see or verify whether or not you've got that comparative block diagnosis procedure before you evaluate the strength of that or the overall strength of your RFN case. Having said those two things, I want to shift to the defense perspective on these types of cases, where you're in a phase of the case where you've gone through mediation. Maybe you've done a really good job telling your claim rep, hey, I think this is a good case. I think there's a reasonable chance of jury awards, future damages for these RFN treatments. Let's bump up this evaluation. The insurance company is not buying it. The claim representative is not offering what plaintiff's going to accept to settle the case. You find yourself on the verge of trial. Well, even before that, you're looking at your expert disclosures deadline, your IME deadline. You're thinking, what type of expert do I want to use to defend this type of case at trial? Early on, when I was defending these cases for Progressive, I thought, hey, the best experts, and I think a lot of defense attorneys think this way, is to use a doctor that actually does the procedure. Burton, my understanding with him was he was one of the sort of forerunners in bringing RFN therapy to Minnesota as a form of treatment for chronic pain. So he had a very detailed and experienced understanding as to how you explain what a facet joint injury is and why RFN treatment would be something you'd use to treat this kind of chronic pain. And in preparing his deposition for his testimony, got 2 minutes, he talked about the expert on the other side of the case. It happened to be a doctor from what was then called Center for Diagnostic Imaging, now it's called Reyes Radiology. And he had this sort of smile on his face, and he talked about how a lot of these doctors, these physicians that get involved in RFN therapy at places like Baby Summit, Reyes Radiology, Minnesota Institute for Pain Management, he described these doctors that are not neurologists as needle jockeys. It was kind of a sort of a derogatory term for saying, hey, they know what they're doing. They can mechanically stick a needle in someone's neck, but they don't understand the medical science behind the procedure. And therefore, maybe they're involved in a situation where they're not providing proper care, they're not properly diagnosing what's causing the chronic pain. So this got me thinking, and it made me realize this is why many defense attorneys use Dr. Altafel as an expert. Dr. Altafel doesn't actually do the RFN procedure, but he is a neurologist. And I thought, well, you know, if you're going to fight or defend against a nerve injury, what essentially is a nerve injury, use a person experienced, a doctor experienced in handling nerve injuries and treating and diagnosing nerve injuries. I had a case with Altafel where on cross-examination, plaintiff counsel asked him, well, doctor, isn't it true you don't actually perform this procedure? You don't perform an RFN procedure in your practice? And Altafel's response was really simple. He basically said, well, yeah, I don't do it, but I'm as qualified as anybody to diagnose this type of injury and recommend treatment for it because I'm a nerve doctor. That's what I treat. I treat nerve injuries. And in that case did go to trial, I think that bit of testimony, while it probably didn't direct the entire outcome of that trial, but I think it provided compelling medical expert testimony to provide a little bit more foundation, a little bit better sort of understanding, or like I should say a better foundation for an argument to say, hey, what plaintiff is doing, they're going the wrong direction. This is not a nerve injury case. It's not an RFN case. Dr. Altafel explained to you why it isn't the case. He's a neurologist. He's the best person to diagnose and treat these types of injuries. And so again, when you think about the type of medical expert you want to use in these cases, I would say, hey, maybe you go the neurosurgery route if you want to spend that kind of money, or maybe a neurologist when you defend these types of cases. I think my time is up. So again, I'm going to thank Brett and Lindsay for giving me this opportunity to speak at this seminar. I do want to briefly mention I'm very much looking forward to Ben Utek's Q&A, because NIL money, that's a big thing for me. I want to know, maybe he has some answers about Ben Johnson. If you follow Golden Gopher basketball, Ben Johnson's team was decimated by the dreaded transfer portal and the promise of NIL money at other schools. I think Dinkytown Athletics, whatever the NIL fund is here in Minnesota, is having a hard time getting money for their athletes, and I hope Ben can maybe shed some light on how Ben Johnson can rebuild that program and maybe make for a better team. Thanks, Brett. Oh, sure, yeah, go ahead.
So, please repeat the question so that they're listening.
Oh, yeah.
Did you receive any NIL money when you were in college at Wisconsin?
So that's an unfair question. I'm a Golden Gopher, and no, I wasn't that valuable a student athlete there to warrant that type of money. But thanks, Brett. I appreciate it. Thank you.
Thanks, Andy. Next, we have Shane Hammond. Shane is a shareholder at Arthur Chapman. She handles all aspects of insurance defense cases, from automobile and no-fault to coverage and general liability claims. She also serves on the board of directors for the MDLA, the Minnesota's Claims Litigation Management Chapter, and the Twin Cities Claims Association. Welcome, Shane.
Good morning, everyone. Thank you, Lindsay, for that nice introduction. I'll try to speed things up because I think Brett's getting a little impatient because we're a little behind. So what I'm going to talk about today is not controversial. Brett always says, don't talk about anything controversial, Shane. We don't want, fights starting in the audience. So what I'm going to talk about kind of is how we can all get along and kind of key things for both plaintiffs' attorneys and defense attorneys, so that we can move our cases forward, we can get the desired results we want, or we can try the cases that need to be tried. I can't really see there, okay. So first slide, what's the, okay, perfect. So pre-suit things to kind of keep in mind. Obviously, this is kind of for both sides. Whether you practice on the plaintiff side, the defense side, get as much information as you can from potential witnesses, from the police. Does the police have body-worn camera, video footage? Usually they have that for more high-speed accidents, potential issues with liability. Is there an accident reconstruction report that will be coming at some juncture? Do you need to hire your own accident reconstructionist? On the insurance company side, are there potential coverage issues? Do you need an examination under oath? I know sometimes on the plaintiff side, when a potential plaintiff or a plaintiff in a case or an insured is being asked to provide an examination under oath, kind of the antennas go up on the plaintiff side. It's not always bad, right? An insurance company wants to determine if there's coverage, determine what happened, find out additional information, because maybe the police hasn't issued their final report yet, and so this helps to streamline things that you may need. From both sides to get photographs, get property damage information. I know on the defense side, one thing that can be very aggravating is you have photos in your file, and maybe there's a lot of damage, maybe there's not a lot of damage, and what you have is zoomed in photos of a bumper that shows a scratch on it. Okay, well, where's the whole bumper, right? If there's a lot of property damage, you're kind of zoomed in on where the vast majority of the property damage is, but show the four corners of the vehicle. Check with your clients, both sides, plaintiff and defense, because a lot of plaintiffs will take photographs at the scene of the accident, and that can provide helpful information to both sides. So get that information from your client. And obviously, as we're building our case, we're determining what experts we want to use, what experts could be helpful for our case. And I'm going to show a video clip from a 30-year-old movie, My Cousin Vinny. I'm sure we've all seen it, right? And it shows that there's still relevance to what we're watching on films. Obviously, Hollywood condenses everything, right? everything happens within a 2-hour segment, whereas in real life, these cases take a lot of time. But I think what this video shows is a good lesson for all attorneys, that a lot of times experts, so when Andy was talking about Dr. Altafala or Dr. Sabers, those doctors are experts in their particular field, right? And a lot of times us as attorneys, we think that we're the expert on everything, right? We know everything about auto accident cases and products liability cases and slip and fall cases, but we hire those experts to help us so that we can handle our cases, we can move forward with the defenses we have. So I'm gonna play this video and then we can chat about it. Is that working?
What you do in your father's garage?
Tune-ups, oil changes, brake relining, engine rebuilds, rebuild some trannies, rear end.
Okay. But does being an ex-mechanic necessarily qualify you as being expert on tire marks?
No. Thank you. Goodbye.
Sit down and stay there until you're told to leave.
Your Honor, Ms. Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trotter wishes to voir dire a witness as to the extent of her expertise in this area, I'm sure he's going to be more than satisfied.
Okay.
All right. Now, Ms. Vito, being an expert on general automotive knowledge, can you tell me what would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic inch engine and a 4-barrel carburetor?
It's a bullshit question.
Does that mean that you can't answer it?
It's a bullshit question. It's impossible to answer.
Impossible because you don't know the answer.
Nobody could answer that question.
Your Honor, I move to disqualify Ms. Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Watch this.
Because Chevy didn't make a 327 in 55. The 327 didn't come out till 62. And it wasn't offered in the Bel Air with a 4-barrel carb till 64. However, in 1964, the correct ignition timing would be 4 degrees before top dead center.
Well, she's acceptable, Your Honor.
So sorry about the swearing in there, but we're all adults. So you can see how obviously in that particular scenario, that expert had infinite wisdom about a particular area. And you can see kind of the body language that was relayed by both sides. The defense attorney didn't think that this person had expert knowledge, but the plaintiff's attorney knew that this person did have expert knowledge. So a lot of that goes to listening to each other, right? You can disagree about something. You can disagree about the value of a case. You could disagree about whether you're fighting liability or just damages. But you can still listen to each other because you find out so much more when you work together, talk about what the potential issues on the case are and how to work through those potential issues. Moving on to kind of other pre-suit issues. Obviously, an insurance company, when you get notice of a claim, acknowledge that claim within 10 days. If there's communication that you receive from an insured, from a claimant, from a plaintiff's attorney that reasonably requires a response, make sure that you're responding. If you can't complete your investigation within 30 days, let the other side know what additional information you need. Do you need statements? Do you need an examination under oath? Do you need that state patrol report? Make sure that's done in a documented format, because this helps plaintiff's attorneys know what's going on. This also helps a defense attorney, if they step in at a later juncture, know what's going on in a particular case. I'll say this, I do handle some Minnesota no-fault files. There has been kind of an uptick in potential coverage issues, exclusions to Minnesota PIP are always, things to consider. Was this a racing event? Was this an intentional act whereby a PIP would be excluded? Was there conversion of a motor vehicle? And the cases are generally very specific pertaining to that. But there's also residency issues, right? If someone's an adult but they're living with someone else, do they own or insure a motor vehicle? Where does that coverage flow? If parents are divorced, what does the custody arrangement discuss as far as how that child splits time between mom and dad? Is there discussion? A lot of times I just looked at a custody and a divorce decree, and there was no discussion, obviously, about how auto insurance would flow, but there was a discussion about the child would split time equally between mom and dad, that there was physical and joint custody for that child. And so the two insurance companies worked out a pro rata sharing basis. And again, on the no-fault side, you might have to exercise your right for examinations under oath. I will say that with no-fault claims, before you file for an arbitration, just reach out to the insurance company and ask for an updated PIP log. If you've got bills from the time of the accident, an ambulance report, maybe those bills never made their way to the no-fault carrier. Send the bills, send the records, pick up the phone, talk to that no-fault adjuster, because a lot of these cases that I'm seeing that end up in arbitration, they don't need to end up in arbitration, because if you pick up the phone, you can resolve some of those issues. Your client can continue to have no-fault benefits, and you don't have to incur that added extra expense with no-fault claims. So this is, so I talked about that. Moving on to kind of some other civility things in the legal profession. Provide documentation, on the plaintiff's side, provide documentation that the insurance company is requesting. If they want an ongoing status of the case, if they want authorizations, because that helps build their case on the defense side. That helps the insurance company set reserves. They know what they need to request. They know what type of injury claim this is. They know if they're going to have, issues with a low limit policy. So provide that documentation. And if you're providing a demand, make sure that you've provided, the medical lien information. You've discussed any sort of wage loss claims. You've provided the documentation for wage loss. If there's a pre-existing condition that your client has that's been, increased because of injuries, make sure that you're providing that prior documentation, because that will help move the case forward. On the defense side, of course, disclose the policy limits. Let the plaintiff's attorney or the injured party know what the limits are that are available to protect your client. If someone's asking for photographs, property damage information, provide that information. If a PIP log is requested, provide that on the defense side. And advise the plaintiff's attorney what it is that you need. Sometimes some insurance companies will reach out to a defense attorney to get involved in a case kind of pre-suit. That's a good thing, right? That's a good thing, because sometimes when I become involved in a case pre-suit and I reach out to plaintiff's attorney and discuss what it is I need, they kind of quickly shut the door. And I'm the mouthpiece to the insurance company, so that's a good thing. Things to when you're putting your case into suit. Obviously, maybe if something has stalled so that you can't get that case resolved, you've made offers, you've made demands, the case just isn't going anywhere, is a pre-suit mediation something that would work to bridge the gap? If not, and you go ahead and put that case into suit, please make sure you send a copy to the insurance company, and make sure that you also advise the person you're serving where they need to send that summons and complaint to. The last contact information to the applicable adjuster: name, address, email address, telephone number. This isn't really a game of gotcha, right? You want to get to that, you want to having a defense attorney on that file. You don't want to have to deal with a default motion, so that really helps to move things forward. And then obviously, once the case goes into suit, there's things you also have to discuss, putting together your joint discovery plan, talking about the medical care and treatment, what records you need, what wage loss documentation you need, is liability in dispute, is liability not in dispute, what other issues potentially do you have, what's your timing for discovery. I think we really have to think about how long it'll take for discovery completion, because nowadays, when you request medical records, whether you're on the plaintiff side or defense side, it takes a long time to get those records, right? They're using outside vendors, and you're getting prepayments. You got to pay the prepayments, and then several months later, the records arrive. So is there a way that attorneys can help each other out and share in those expenses? And then moving forward, how many independent medical examinations will the defense need? Does the plaintiff have their narrative report? And then also, who do you need for experts? Do you have an expert that will discuss liability, an accident reconstructionist, a biomechanical expert, or is liability not really an issue and you're mostly dealing with the medical causation issues? Also, make sure that if there's any travel concerns for clients, sometimes I represent clients who might live in a different state for college, or might be traveling abroad for some reason, and so I'll need to advise plaintiff's attorney of that. Of course, things are a lot more streamlined because we can use Zoom for a lot of these, so that is a nice added incentive. But keep that stuff in mind. Venue, rocket dockets, what happens in rocket docket venues is, if you're in Hastings and both parties generally agree and you execute a stipulation that both sides are in agreement to remove this case from a rocket docket, the court will generally sign an order allowing that to happen. But what I've seen also is now the court wants to have a case management conference, wants you to talk about your case, wants you to go over the dates in your scheduling order. So it's a little easier to get those cases removed from the rocket docket in Hastings, whereas in Olmsted County, I had a case once where the plaintiff's attorney and I both agreed it was not a case for a rocket docket proceeding, and we had to have a case management conference, and the court just did not want to remove it from the rocket docket, and finally it kind of, the 29 minutes of our 30-minute phone conference, she relented because I think she had to get off the phone for another hearing. So have those communications beforehand. If you're going to file a case from the plaintiff side or the defense side, reach across the aisle. I'm going to go ahead and file the case. What else can I provide to you? Or talk about it when you're doing your joint discovery plan. When would it be good to file this case? Because that helps everything run much smoother, right? Because whatever case we're talking about is just one of the cases we have. We have many more cases that are going on. With regards to, I know other people are going to talk about mediation, and Andy touched on it too. Mediation is usually your best tool to get a lot of these cases resolved. But when you have that, mediation is important. Do you have everything that you need? Do you have the medical liens? Do you have the witness testimony? When you select a mediator, will that mediator have buy-in on the process? And all of us know how our clients, so on my side, I know, okay, does my adjuster need more process? Is my adjuster new? Does my adjuster need to contact their supervisor fairly frequently in the mediation? So that might dictate who I would want to use for a mediation. On the plaintiff side, you know how much process your client needs. Will your client listen to a neutral third person? Is your client someone that wants to bring a spouse to the mediation, and the spouse will kind of dictate the mediation? So make sure that you're picking a mediator that will have a vested interest in your case and have buy-in to make sure that you get your case resolved. If you do that, both sides will then come to an amicable resolution. Of course, on my side, I always make sure that my adjuster, I have both work phone number or a cell phone number, the manager's phone number, email address, and that everybody is on the same page as far as when the mediation is, if it's going to be via phone, if I'm connecting with them via phone, if I'm connecting with them via Zoom. That just helps to avoid any sort of issues and make parties, kind of upset during the mediation process. Because I know I've been in those situations where I can't get a hold of my adjuster, and I've told the mediator that, and the mediator says to the other party, Shane's can't get a hold of her adjuster, and that's what the holdup is. So that will really help streamline things. And so I'm going to move on to the next video I'm going to play, and then I just have one more slide, and we'll be done as my 2 minutes are coming.
Freddie. Freddie Bender, this is Rex Rexroth, and you are the lovely Marilyn.
Please, Miss Rex Ross. And you must be Mr. Massey.
Please, Miles. Sit down. Oh, Freddie, I was sorry to hear about the Goldberger Award. Pastry?
We did very well. We did very well.
Not to worry, Mrs. Rexroth. You're ably represented. I'm sure Freddie's just too modest to tell you he used to clerk for Clarence Thomas. Pastry, going begging.
Don't try to bait me, Miles. Now, if you have a proposal to make, let's hear it.
Well, at this point, my client is still prepared to consider reconciliation.
My client's ruled that out.
My client is prepared to entertain an amicable dissolution of the marriage without prejudice.
That's a fart in a stiff wind.
My client proposes a 30-day cooling-off period.
My client feels sufficiently dispassionate.
My client asks that you not initiate proceedings pending his setting certain affairs in order.
Well, what's so goddamn funny?
Please, let me handle this. All right. So much for the icebreakers. What are you after, Freddie?
My client is prepared to settle for 50% of the marital assets.
Why only 50, Freddie? Why not 100? While we're dreaming, why not 150? Are you familiar with Kirshner?
Kirshner does not apply.
Bring this to trial. We'll see if Kirshner applies.
What's Kirshner?
Please, let me handle this.
Kirshner was in Kentucky.
Kirshner was in Kentucky?
Kirshner was in Kentucky.
All right, Freddie, forget Kirshner. What's your bottom line?
Primary residence, 30% of remaining assets.
What are you, nuts? Have you forgotten Kirshner? Freddie, it's a negotiation.
See you at the preliminary.
Freddie, we're all friends here. It's a negotiation. Hey, Freddie, fine. We'll eat the pastry. I thought that went well.
So I think what that video shows us is managing expectations, right? Maybe having some of those tough conversations with opposing counsel outside the presence of a client or a claims professional who might be wondering what all of this banter back and forth is, because someone's always watching, right? Whether it's a client, a mediator, they're watching our interactions and how we handle these cases. So hopefully you've learned a few good new tips, or you've got to see a couple of video clips from legal movies that hopefully kind of have some relevance to today. So thank you very much.
Okay. Thank you, Shane. Shane, thank you. If you're a former caddy at Interlachen, please stand up. Nope, stay standing. We're scattergood. Well, that was bad timing. Scattered left the room. Go see if Scattergood's in that room over there. Maybe he's in the bathroom. We won't check. All right, so we'll do his later. Joe, come on up. So I had a conversation with Mr. Crumley last week talking about the event, and he was lamenting his days at Interlachen and all the abuse he took from members like Lindsay and her husband and others. And well, that was, I guess, an older time. Older folks, right?
They were wonderful.
And then all the great tips that he gave them and how he made their lives better. So we decided that we would give you one of the first prizes of the day, which happens to be an Interlachen. Well, thank you. There you go. Congratulations, Joe. All right. All right, next up, JP Gatto. JP is going to talk about bad faith, and JP, as we were talking earlier, back in the corner with Pete Thrain. So JP was on the defense of this issue with HKM back in the day when we were working on these things, and he used to be my defense bad faith speaker at this event. Now he's on the plaintiff side, so he's seen both sides, and what better presenter on the issue than JP Gatto? Come on up. Thanks for doing this.
Where's my, is this little clipper? Thanks, Brett. If I'm a little hoarse, I was at the game last night, so I apologize. All right, so as Brett said, I used to do this on the defense side, and he asked me to flip it and do it again on the plaintiff side, but, you know, it's the same thing anyway. So let's see if we can... There we go. All right. So we're going to talk about first-party and third-party bad faith. We're going to focus principally on first party because I think that's the most interesting developments the last few years. But essentially, we're going to confine it to the personal injury setting. And the first party setting in the personal injury space is typically underinsured or uninsured motorist cases where there's more than likely a low limit, large verdict, and we'll get to that in a second. 2008, it was codified in Minnesota as a cause of action. Prior to that, there was no common law right of first party bad faith. So 604.18 is the operative statute we're going to talk about. Third-party bad faith is a different animal altogether. That's your tortfeasor versus insurer type of situation, usually an excess verdict situation where somebody's hung out to dry after a big verdict against them by their carrier. The common case cited is the Shore v. Dairyland case, which is very old. It's an '83 case, year after I was born. So not a whole lot there that I want to get into, but we'll talk about that at the end. We're not talking about the Unfair Claims Practices Act, different statute 72A.201, which lists all sorts of stuff that insurers must do when they're presented with a claim, settlement offers, et cetera. That statute is very helpful in terms of identifying what claims adjusters and insurers must do. But it's enforced by the Commissioner of Insurance, so if there's a violation of it, the only really thing you can do is contact the Commissioner of Insurance. You can use citations to it in terms of proving bad faith or defending against it, but that's not the statute that we're really going to be focusing on. For first-party claims, again, it's 604.18, and the statute, this is too many words to read, but essentially it says that if an insurer, when presented with a first-party claim, doesn't act reasonably to conduct an evaluation, and if they also fail to act reasonably and also disregard whatever evaluation they do conduct, then they can be exposed for bad faith. It's a two-part test, so you have an objective evaluation to begin with, and the evaluation is pretty obvious. It's, did you do anything to evaluate the claim? What did you do to evaluate the claim? How did you evaluate the claim? And what your findings were. Do they make sense in the context of what the claim is? So for example, if you are being presented with a personal injury claim where there's a motor vehicle crash with an uninsured motorist and your insured has been catastrophically injured, lost a limb, has a traumatic brain injury, and the limit of the policy is $30,000, did you decide that claim doesn't have a $30,000 value? And anybody, I think, would say that that's not an objectively reasonable thing to do. So that's part one of the analysis. Is that objectively reasonable? The second part of the test is by far and away the more litigated part of the statute, and it's the more interesting part of the statute. What is a reasonable insurer to do subjectively when they conduct their evaluation, okay? So in other words, not only must there be some indication that they failed to do an objective test, but that they then completely disregarded or acted recklessly in view of their objective evaluation. So for example, the same scenario I just described, the insurer, claims adjuster decides, yes, of course, this case is much, much more valuable than the limit, but somebody else up the chain says, well, forget about that, we don't care. We're going to go ahead and put this plaintiff's attorney or this claimant to the screws and make them prove their claim. Well, that's not a reasonable thing to do under the considered circumstances, and so that can be a second-prong violation. The thing about 604.18 that's a little interesting is the dichotomy between how you present these claims versus a state case and a federal case. We do most of these cases in state courts for personal injury cases. And in the state of Minnesota, you cannot assert a bad faith claim as part of the original complaint. It can only be asserted in a motion to amend, similar to a punitive damage claim, and it typically only comes after there has been some underlying finding that would give the appearance of potential bad faith. So in most cases, a jury verdict. Once that verdict comes down, and typically a scenario where the verdict is much higher than the limit, then a motion to amend can be made wherein the party seeking the amendment must prove that there's a prima facie case of bad faith. Both the objective test and the reasonableness subjective test have been violated. Essentially, it's a mini trial type of scenario where the judge is going to consider all the evidence presented, expert evidence on both sides, affidavits from both sides. They're going to dig into what the facts underlying the case are all about and then make a decision. Of course, in federal courts with Rule 15 and the recent cases we've seen as far as pleading standards, it's very different. There isn't going to be this sort of deep dive at the motion to amend stage in the federal cases. You're going to plead it. You're probably going to get it granted if you have any indication that there's bad faith, which typically would be the case if you've got a big verdict and a low limit and nothing's been tendered. And then once that happens, the court will allow some additional discovery and then try the case. The trial is a court trial. It is not a jury trial. So that is kind of unique in the state setting insofar as if you prove you have the basis for a motion to amend and it's granted, that you've already had your kind of mini trial. If you get it amended and you get it granted, 9 out of 10 times you're going to get some finding from the court that there's been bad faith. The court's, like I said, going to consider everything at that point in time. So it is a very interesting type of scenario. If your motion is granted, bad faith is going to be determined, the judge is going to make a call, and then you have the option, if you win, to somehow make your case as to what your damages are. And what you're going to show is fee sheets, memorandum of law articulating what you did, affidavits identifying what you did, invoices about what your experts cost, so on and so forth. There are lots of first-party cases, but these are just a few that I threw up there to show you how difficult first-party bad faith claims can be, because there's a lot of ways in which insurers can do a reasonable evaluation and avoid application of the statute. So if they hire some experts, or there's a question in an arson case about causation as to a fire, or if there is obvious jury verdicts that suggest the evaluation that the insurer made was appropriate, it's going to be difficult to demonstrate that there was bad faith. So it's a difficult claim to make. The other unique aspect of the statute is there is a damages cap. The statute says that if you demonstrate bad faith, you are entitled to damages of 1/2 of the available proceeds between the offer that was made up to 10 days before trial and, quote, the end proceed, which we'll talk about in a second as it relates to Wilbur, capped at $250,000. So in other words, if you have a policy limit of $30,000 and a pre-suit offer of $20,000 was made 10 days before trial, and you go to trial and an award of $100,000 is issued, the question for Wilbur was, what does available proceeds mean? Does that mean the $100,000 verdict or the $30,000 limit on the policy that was at issue? And Wilbur, which was decided, I think 2013 or 14, by the Supreme Court, ruled that it is the insurance policy limit that is the available proceed under the language of the statute. So in other words, that $100,000 verdict doesn't really matter. The available proceeds is the $30,000 limit on the policy. They compare that to the $20,000 offered. You get 1/2 of that difference, or $5,000. In addition to that, you are allowed to seek attorney's fees for proving your bad faith claim capped at $100,000. So this means the second you make your motion to amend to the point where you have a bad faith finding, that is the span of time in which you can collect attorney's fees. You do get prejudgment, post-judgment interest on these things. No punitive damages. The punitive element is the statute itself. So this Wilbur case is unchanged, and frankly, I'm surprised that there hasn't been more litigation about it and discussion about it, and I have a suspicion there's going to be some movement in this respect, because it is a unique situation insofar as an insurer who has a first-party low-limit case doesn't really have much incentive in view of the bad faith statute to offer up the limit if they can just get half the proceeds between their low limit and whatever is being offered before they go to trial. There is also, lots of first-party cases out there that are not in the personal injury sphere that have used this statute. A lot of first-party insurance coverage type claims. They provide some helpful guidance, but strangely, there hasn't been a ton of litigation in the personal injury world. So we'll see what happens over the next handful of years. Third-party claims generate in this state in the common law from Short v. Dairyland, the 1983 case. And in that case, you had a bad car crash, you had a death, you had obvious fault, you had a very low limit insurance policy that was demanded before really the case even started, and the insurer refused to pay it, and refused to pay it up to and through trial when they were hit with a verdict that was 10 times whatever the insurance limit was. And the question was, can you seek recovery of the excess portion of the verdict from the insurer if you are the injured party and the tortfeasor is standing there naked because they don't have coverage and they don't have the ability to pay the excess verdict? The follow-up, the rule that was issued by the Supreme Court following that case was absolutely you can, if you can show that the insurer failed to act, quote, reasonably. And of course, that's the famous reasonableness buzzword that we hear in all sorts of tests and all sorts of cases. But it in this context is even more vague because, well, what does it mean to be reasonable? What are the reasonable grounds that an insurer has to fail to tender a limit when demanded? But in that case, the court said the underlying facts were so obvious and the limit was so low in comparison to what ultimately was the verdict that go ahead, collect that excess verdict from the carrier. So that extra contractual piece was huge. The next case that kind of addressed this issue, and really the only one that's really touched on it, is the Sundath case from, I can't remember what year that was, but in any event, very similar scenario, bad crash, bad injuries, obvious fault, an insurance limit that was higher than it was in the short case, but certainly not high enough to ultimately justify what was the verdict of $2 million. And it was demanded beforehand, and the court once again says, if you can prove that there was a lack of reasonable basis to not tender the limit, you can go ahead and seek those extra contractual damages. Since then, there has been a complete dearth of case law articulating what it means in a third-party context to have bad faith. What we have basically come to understand, at least from my side of the aisle now, and when I was on the other side of the aisle, was that the first prerequisite to any bad faith claim is you have to give the insurer an opportunity to pay the limit. If you've got a big case and you know that the limit is not going to be sufficient to overcome the damages, you can't just hold back and say, well, I'm going to come after you for bad faith if you don't offer me your limits sua sponte. You got to make the actual ask. You got to put it in writing. You got to give them a chance. You got to give them a time limit. And you have to give them some facts upon which they can make their evaluation. In other words, you can't hide medical records, you can't hide medical bills, you got to give them something. There also is a understanding that really what it means to be reasonable is completely and totally undefined, and it's going to take somebody having one of these types of cases going all the way through trial, through a bad faith claim, maybe perhaps up to Court of Appeals, Supreme Court decision to understand and articulate what that means. When I was defending cases, a lot of my partners in this sphere would tell you that, well, really it's any reasonable basis will allow you to avoid bad faith. And what was that? Did we hire an attorney outside of the defense firm to evaluate the case, and did that attorney provide guidance that would suggest the evaluation was appropriate? That could be a reasonable basis. Were we not provided key medical records, or even somewhat key medical records that didn't allow us to do a full evaluation? That might be a reasonable basis. Can we find a jury verdict from anywhere, even remotely close to our jurisdiction, where there is damage award similar to this? That could be a reasonable basis. Do we just have a difference of opinion? Do we have experts who suggest that the plaintiff's experts are wrong? That could be a reasonable basis. So it's unclear, because now that I stand on this side of the aisle, I have a very different view of, well, you can go find anybody to say anything. That's the skeptic in me and the skeptical nature of our practice. But I don't know. I mean, we're going to have to see how that all plays itself out. At the end of the day, it's a unique sort of twist in the law that we're going to have to navigate over the next handful of years. I'm trying to move this along to get you guys back on track, but long and the short of it is we're still in a bit of a morass, I think, with respect to both kinds of bad faith. I think there needs to be a little bit more action on both fronts, and perhaps there may be some legislative work to be done on it. But as of right now, they're both alive. Whether they're well, I think, is another question entirely. All right, well, go Wolves. Thanks.
Okay, Rich? Turns out he was in the bathroom, but just an update for everyone. Come on up, we have an award for you. First of all, you were a former caddy here, correct? Okay, come on up, we've got an award. And did you know that Joe Crumley was as well? Yes, because while you were out, Joe received his award. So to our former caddy, here, toss it. Oh. Yes.
Thank you.
So this is our former caddy award to Rich Scattergood for all the hard work he did over the years.
I had a bigger impact on when I worked on the grounds crew.
Grounds crew as well. All right. Next up is Alan. Oh, Mackenzie. There she is. All right. Next up is Mackenzie Campbell from Door Drill in western Wisconsin, the place that when I was a young lawyer, I learned that's where all the good plaintiffs' lawyers were, at Door Drill. So now Mackenzie lives actually way out here in the West Metro on Lake Minnetonka, but she commutes to Richmond. And I've learned she's an excellent lawyer and very smart and knows her case law. Is actually in some of the case law herself, handling cases. So she's going to tell us about what we're about to embark on with our new pain and suffering statute. Is that accurate? Perfect. All right.
All right. Can everybody hear me okay? I see a few familiar faces in the audience, but yes, I am the Wisconsinite that Brett continues to ask to come speak at these things. I'm also licensed in Minnesota. That's where I started my career, but do most of my work over in Wisconsin and a fair amount of appellate work as well. So that's why I am here. I'm at a firm that's been around for about 150 years. So we have had the conscious pain and suffering claims for wrongful death cases since I can remember, and frankly, since I think the 1920s was the earliest case I could find. So thought I could bring a couple of tips and tricks that my firm has learned over the years in handling these cases, and some particular nuances that I don't think have quite been vetted out in Minnesota yet, but we'll see if they get there. Most of you know the statutory amendment that has come in. I just highlighted the additional language. The one thing that I wanted to point out here is that this statute really doesn't actually say conscious pain and suffering, and I know in other jurisdictions where that has been the case, there has been some litigation as to what is meant by all damages. And so I'm not sure if that's going to play out or not. I would suspect someone's going to take up that torch if they haven't already, but we'll have to wait and see. These are the elements that, at least in Wisconsin, we typically look at as an injury causing death, consciousness, and then the decedent experienced pain and or suffering before death. I have a little asterisk next to consciousness because that particular element is incredibly litigated, and it's maybe a little misleading to say that. This is the jury instruction that we typically give in Wisconsin about the conscious pain and suffering claims. These civil jury instructions are usually publicly available with the Wisconsin Law Library, so if you are looking for a guide and don't have one yet, it's a really good resource to look at to maybe present something to a judge. If you actually go through the law library version of them, you can actually get the notes and annotations that the judges have in their judicial bench book. So I encourage you to do that instead of just going onto another free resource. Some of those annotations are actually very helpful and give some nuanced arguments that judges are going to want to hear and maybe will help you. So the law library is really where you want to get those from, and the librarians are very, very helpful. So the consciousness requirement. This is one that is litigated a lot. I think the term consciousness is actually probably a little bit of a misnomer. Both the Minnesota and Wisconsin statutes are silent on this, and there's some interesting case law that talks about it, but I thought some interesting quotes were one who was a victim who was rendered unconscious and never regains consciousness cannot be awarded damages for pain and suffering, and I don't actually think that would hold up today, and I'll talk a little bit more about that, but I think that that's something that probably wouldn't be upheld on appeal in today's world. And then this is an interesting case that just came down from the Eastern District of Wisconsin, and I'm not sure if anybody else here practices in the federal circuits, but it was interesting because it's a burden of proof issue. And the court specifically said the absence of evidence that he suffered an injury consistent with the loss of consciousness is sufficient to sustain that inference that they were entitled to conscious pain and suffering. And so it was interesting in that they didn't actually have to present evidence that the decedent was conscious for a period of time, but that he never sustained an injury that would produce that loss. So I'm not sure if that would be the case if we were in the Wisconsin State Court, just if you know anything about those courts. But in Minnesota, I think it would probably be okay. But the lack of proof of something was enough to sustain that inference. So just a tip there. This is the part I really wanted to get to today, is the difference between consciousness and awareness. Those are two different things that over time, at least at my firm, we've learned to really differentiate, because you can have someone who is conscious, but you can also have someone who may not appear to be conscious, but they are aware. And because the statutes are silent on actually consciousness as a term, this may provide you with a way to either fight recovery or get recovery. And these are just a couple of examples that I found. A male was injured as a passenger in a motor vehicle accident. He was hospitalized in a skilled nursing facility. And I will say this is a case that came out of our office. Hospitalized in a nursing facility for many months. He was thought to be nonverbal with very little understanding of his surroundings. His consciousness was sporadic. So not quite a vegetable, but we were all pretty of the impression that he didn't have an understanding of what was going on around him. A nurse had a discussion with him about his wife. It was not a happy conversation. And although the man did not talk or acknowledge the nurse, tears started sliding down his cheek as she had this conversation with him. And no one really knew that this had been going on until one of my partners in the firm had a conversation directly with this nurse. And she told him about this conversation that she had had with the then decedent. He ended up dying later that year. Same physical presentation, all his medical notes had indicated basically was unconscious for most of the time, going in and out, but he had an awareness. And the case settled shortly after the evidence came to light of the conversation with that nurse, because the tears, even though he didn't use any words, the tears were enough to present that inference of awareness, maybe not necessarily direct consciousness of what's going around him, but an awareness. So just an example of how that can kind of play out. Duration. I want to talk about duration of consciousness, because I know sometimes the default is to think that the longer the duration, the higher the case value. And I don't know, at least in Wisconsin, that that's been the case at all. And so it does matter, but in two different ways. So the duration of time between the event causing death and the death itself is one aspect of duration that you need to focus on, but the other one is the duration of the periods of consciousness. We all know people can go in and out of consciousness depending on the injuries that they've sustained, but sometimes there are longer periods of consciousness or shorter periods of consciousness or awareness. This is an interesting note, and again, this is a very old case that I don't know that it would hold up today, but it's important because we've got so many medical advances as far as medication and pain management and different things, and so I'm curious to see how it would play out. But there's a case that says 3 hours of conscious pain and suffering deadened by opiates cannot stand. That was a reversal of a verdict. And I'm not sure if that would play out today in the same way, but it's an interesting thought. So I haven't had any direct experience with that sort of argument, but I certainly think someone will at some point take that up. The other thing that has started to come to light in these cases is the difference between physical pain and suffering and mental pain and suffering. And there's a larger group of people who are willing to accept that there's a mental impact of these injuries. Specifically, we're seeing with juries pre and post-COVID. There's a difference in how they view mental pain and suffering and anguish. And so I think that that's something that if you are going to litigate these claims, you need to be aware of these two things, because I think that medication could certainly play an impact, whether it be someone who's self-medicating or, in some way, shape, or form, or if there's going to be something with a medication that's been prescribed by a provider. These are just a couple different examples of the comment I made about duration and how the duration itself isn't directly linked to the compensation that's been awarded by a jury. You've got a couple of different verdicts there at different points in time. The last one, the $5 million verdict, is an interesting one. It's obviously a minor, but 30 to 60 seconds of pre-death fear and apprehension alone was a $5 million verdict, but there was no evidence of further consciousness post-motor vehicle accident. So to some extent, it's an incredibly short duration as far as the case, but what's also interesting about that is simply fear and apprehension of death. And I'll talk to you a little bit about how you might present such a case when you don't have maybe a lot of evidence on it. So common experts. These are the experts that my office will typically hire to deal with these cases, to deal with both the physical aspects of the case, the mental aspects of the case, and then if we're talking about a fear and apprehension case, a psychologist. This is really important to talk about the psychological and physiological aspects of the pain and suffering claim and what you might be experiencing. Specifically, you've got a fear of impending death or injury. If you've got a person who's got a fear of death, what does that fear do physiologically to their body? How does it present? What sorts of physical symptoms might they be experiencing? Mental, what do they have? A medical doctor is usually where people focus a lot of their time and effort, consciousness and awareness of surroundings. Sometimes it's not clear from the medical records because you have only brief snippets in time. You're going to want to make sure you have conversations with the people who are at the individual's bedside if they are in a medical facility. And frankly, don't focus on the doctors. Talk to the nurses, talk to the CNA, talk to the people who are actually going to be spending time with these people in the room. The doctors are there for a very short period of time, and so you're going to get better information talking to other people if they are willing to do so. Daubert challenges are very, very frequent, at least in Wisconsin. Daubert challenges are both on paper and evidentiary. You can have one or both, depending on what the judge prefers. But these are frequently done in cases like this, usually saying the doctor doesn't have a basis to testify about what the individual would be dealing with. But most of the time, you can provide a good basis for it. A lot of the doctors that we see who are on personal injury cases will also testify in these types of cases. And then the other expert that's a little more esoteric than some of the others would be a conspicuity and human factors. Has anyone used a conspicuity expert before? Anywhere? Yeah. So they're a little more rare, but they can provide some information to a jury about what could actually be seen by the decedent. And in fear and impending death cases, it's really, really important that you get this evidence in if there is an issue. I can recall in our office we had a case where there was a bridge and an object, and we ended up using an accident reconstructionist to download the data, and you could see that the wheel had been turned, I think, 3 or 4 degrees to see that they had knowledge of the fact that there was going to be an accident. And then we used a conspicuity expert to develop the line of sight that they would have been able to do and then backtrack the reaction time. So the one example that I'm going to give right now, this is actually a current case, in a fear of impending death one, is also you get some testimony from the individuals themselves, or if it's a multi-party vehicle crash. There was a woman who made a statement to a family member and said, "Brace yourself, this is going to hurt." And thus far, that's the only evidence we have of the fear of impending death, but it's pretty significant. So, where should you spend your effort? This is in no way, shape, or form an exhaustive list, but this is what the individuals in my office have found to be the most helpful in these types of cases where this is a large element of your damages. First thing, you gotta identify periods of consciousness or unconsciousness pre-death. So you've gotta make sure you have an understanding of when those occurred if it's not consistent or constant. 2, you've gotta identify evidence of awareness versus consciousness. If you don't do this, you are going to be stuck in lots of motion in limiting practice. 3, you need to prepare to introduce or challenge evidence of both types of duration. Again, this is very, very important. You need to have those experts lined up. You need to make sure that they are prepared with all the different bad parts about the medical records, good parts about the medical records, and they can talk about this. So you need to have both the duration of time between the accident and death where the decedent was conscious and the duration of time for each period of consciousness. 4, you need to prepare for a Daubert challenge in most of these cases. It's rare that I don't have one. Normally I do. Normally it is evidentiary. I don't know in Minnesota if that's the same process that they're going to end up using for something like this, but you should be prepared to do it if you're going to litigate this. And then lastly, I tell people don't forget about potential evidence of fear of impending death, even where something says it is an instantaneous death. It may not be, and you may have some evidence in your file, and I say this as primarily a plaintiff's attorney, but I do some defense work. You need to make sure that if there is any evidence of that fear of impending death, that you don't discount it, because as we've seen from some of those verdicts that came out, it can be incredibly powerful. And then, as always, I'm the Wisconsinite, so if you ever have any questions about Wisconsin cases or how these cases are litigated, please don't hesitate to reach out. I'm always happy to help and share where I can.
So we have the PGA going on this week, right? I just received a text that Scotty Scheffler is looking for someone to help get him out of jail. And I told him we were all busy here, but there is probably a place to call down there. And they're down in Kentucky at Louisville, right? What's that? He made it. All right, for those of you with money on Scotty, there we go. All right, up next is Alan King and with the Getz Eklund firm, and Alan's going to wow us with reptilian depositions. All right, so Alan, have at it. Thank you.
Thank you very much. Good morning. Thank you, Brent and Lindsay, for having me here today. I'm just curious, just at the outset, how many of you are familiar with the term on the screen there, the reptilian depositions? Okay, so a good number of people. This is something that I first learned about, I guess, 8 or 9 years ago from my law partner, Mike Rowley, and he was talking to us. I think we were in a partners meeting or something, and he mentioned this. And until you are doing it or until you are the recipient of it, it's something that's kind of hard to explain, but I'm going to kind of go through with you sort of what the dynamics are with this sort of deposition taking, and I suppose it could be used in trial as well, although I would suspect that there would be a lot of objections that would get sustained and that it would get cut off relatively quickly. I am a defense attorney, and as you can see from the title, it is sort of a defense-oriented presentation. That being said, I think it's important for both sides, plaintiffs and defendants, to be aware of this and to be aware of the dynamics that are going on in these types of questions. Let's see, there it is. Okay. So, what is the reptile theory? It is an appeal to emotions, and it goes to the primitive portion of the brain focused on safety and survival rather than a rational evaluation of the evidence. That is probably the best description I've ever seen of that. And they call it the reptile theory because of the primitive portion of the brain which snakes and reptiles largely rely on. It likely goes back to 2009. I did some research, and it's not really clear where this started or even what region. But essentially what happens with this line of questioning is there are these absolute hypothetical questions which can only really be answered by a yes or no in the way that they're formed. And then once the witness agrees with the general principle, the follow-up questions will address the specific case. So the person that is taking the deposition will lock the deponent into these answers, and then they'll bring it into the facts of the case, forcing the witness to either contradict themselves or to come up with some other way to sort of extricate themselves from the situation. It encouraged jurors to punish safety violators, ultimately influencing the verdict outcome. So how does this tactic work? Overly simplistic constructs, overly simplistic questions. Wouldn't you agree with me that you should always fill in a blank? That you should always slow down and be attentive when you're approaching a four-way intersection? Well, yes, I think we would all have to say that. It's used to anger the jury and generate emotion. I'm not aware of any of this sort of questioning being done in court in front of a jury, but it is happening in depositions, particularly bodily injury depositions. When Lindsay asked me to speak today, I had recently encountered this, and it's not frequent, but it is happening, and I think the most important thing is that you be prepared for it, and even more importantly, that you prepare your client for it, because they're the ones that are going to be out there answering the questions, and if they don't know what to expect, things are probably going to go south very quickly. Keywords to listen for: public safety, community harm, duty to protect, follow all rules. These are things that, we would all aspire to. These are things that are pro-social concepts. Wouldn't you agree with me that, for example, keeping a proper lookout when driving is imperative for the safety of the public? Now, who's going to disagree with that? I added an example of a car accident. And this is sort of the same thing that I just talked about. You would agree with me that failure to continually scan the roadway while driving needlessly endangers the public? I don't think that should be needlessly. Scan the roadway while driving endangers the public. Once this starts, and you'll recognize it because it's not based on the facts of the case, there will be a line of these types of questions, and they will go on and on and on. And what they are doing is they are almost forcing the deponent to commit to these answers, and so they can subsequently turn these answers against them. Oh, sorry. This is, let's see. Oh, I'm going forward. Let's see. Oh, here's one in medical malpractice. Doctor, you would agree with me that ensuring patient safety at all times is your top priority as a physician. You would also agree with me that when hospitals are severely understaffed, patient safety becomes more difficult to prioritize. Again, these are questions that a doctor getting deposed is almost certainly going to say, well, yes, but that's where the preparation comes in, and that's what the next slide is about. The attorney's role. So again, I'm saying plaintiff's counsel. Disarm it by letting plaintiff's counsel know that you are aware of their strategy. That is probably the most important thing. If you can recognize what's going on, and if your clients or the deponents know what's going on, there's a relatively simple way to disarm this, and it involves not giving out the easy answer, which is yes, yes, yes. Prepare your client for the reptilian style of questioning, role play it. You just never know when it's going to come up. Prepare your clients to show them how easy it is to fall into the trap of agreeing to the safety questions and for how persistent opposing counsel can be. Opposing counsel is relying on the easy yes responses to their safety line of questions. And then when you refute these, subsequent questions become impotent and ineffective. Defense attorneys out there objecting to the form of the question, There's the Minnesota Rule of Evidence 701, which speaks to lay witnesses and what they may testify to. You know, they're really there as fact witnesses. They're not there to be offering, opinions, except for these exceptions there. And in motion to eliminate, if you feel like that's going to come up in trial, I would definitely motion and eliminate this issue, although I would suspect that this wouldn't be as effective in front of a jury. It just would maybe not give the right impression. Educate the witness about the reptile questions. This is how you prepare your client. Number 2, probably the most important thing here, direct the witness to never answer with absolute yeses or nos. And this is the thing that is so important. Everything, as us lawyers know, depends on the circumstances. So rather than saying yes, 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 which are these absolutes, well, it depends. It depends on how heavy the traffic is at that intersection, or what the lighting is, or things of that nature. Provide an alternative version and focus on the actual facts of the accident itself, or if it's a med mal case, the procedure or something like that. Demand precision. So in other words, you're going to sort of take control of the deposition and respond with, your own terms and your own situations, or even the facts as they are, rather than these abstract hypotheticals. Is there any questions on this? All right, well, thank you very much.
Thanks, Alan. Next up, we have Christy Paulson, Powerhouse Mediations. I'm sure you've all seen her growing practice. And here she is. Thanks, Christy. You can take this off, too, if you want to walk around. Thanks.
Well, good morning, everyone. It is so nice to be here. So my topic today is AI for trial lawyers. So as Lindsay said, I'm Christy Paulson with Powerhouse Mediation, and I just want to start and talk about AI. So, which is a good thing, I guess, when I think about that, because my topic is AI and trial lawyers. So AI is absolutely everywhere. We cannot get away from it. But what I think we want to remember is that AI is not new. It's one of those things we like to think of that, okay, I'm going to put this in here because I'm moving around too much. I like to think of the fact like AI suddenly appeared in January of 2023. That is kind of when ChatGPT emerged and we started hearing more and more and more about it. But AI itself has been here for a long time. If you think back, the internet is actually a form of AI. And we talk about or think about how that has revolutionized things, how we have gone from computers. I still remember my very first computer. I bought it when I was in graduate school. It was the coolest thing, I thought, but it took a truck to deliver it and 3 people to carry it in because it was that big and that heavy. And now when we look at what we are using tiny little phones, we are using watches. AI, things like Alexa and Siri, which my Siri is probably going to go off now and say, I am not aware of the answer, but those are things that are common, that we are familiar with. We know, we knew how to use them. I always think back to a few years ago, the Black Friday sale. I remember when Alexa was the big thing. They had this Black Friday sale, and so I thought, oh, this will be so cool. I'll buy these little boxes, have them throughout my house. I can announce to my children, come have dinner. And, I hooked them up, and I thought, this is really cool. The holidays were coming, and I had a little girl at the time that was probably about 10, and she didn't seem overly excited about anything as we were, as she was unwrapping her holiday presents, her Christmas presents. And finally she says to me, well, where are the pink skates? And I thought, well, what pink skates? She goes, well, the pink skates that Alexa told me you ordered. What I then figured out is she was a little bit smarter than I, because I was ordering, but she had figured out that if you went to this little box and you said, Alexa, I see a box was delivered to our front door today. Please tell me what was in that box. Alexa would rat you out, and it would say, you know, here's what was delivered today, a Barbie doll, a pink pair of skates, and so she definitely knew. But as we sit here today and we talk about AI, it is exploding, and there are all kinds of things on the horizon, and that's what we're going to talk about. We are really at a stage where when we talk about generative AI, and I'm going to talk about the differences in a minute, we are really pioneers. We are beginning the journey into a really, really exciting field. What is AI? So AI really is the simulation. So AI is a deep learning system that is designed to mimic human intelligence by using computers, by using machines. And the goal is really to make it more efficient, to make it more streamlined, to make it more effective. We see that in a variety of systems. Chatbots. We're familiar with those. If you need help getting connected to an address, a chatbot will pop up and say, you know, what can I help you with? Is there anything I can do for you today? Natural language processing, we're familiar with that. If you call, you know, I called my bank this morning and right away it was like, okay, are you calling for a credit card issue? Are you calling to speak to a representative? You know, I mean, the button that you can push that you know you're never gonna get somebody, but those are all AI systems that are designed to help facilitate the recommended lists. I sat down last night to watch a show on Netflix with my daughter, and up popped based on your viewing, here are your recommended selections. We're very used to that with our phone. You Google something once, and suddenly you are getting all kinds of advertisements, you know, whether it's for a purple purse or a yellow pair of shoes or a hat with a feather. If you Google it once, it's going to recommend it, it's going to find it, it's going to make it better. And certainly cars. I mean, the smart car is just part of it. It's developing. We're familiar with that technology in cars. So certainly it's something that we're familiar with. The generative AI is what we are really talking about when we're talking about what hit in 2023. That is the language models, and ChatGPT is probably one of the most popular ones. But that is the system of AI that takes language, uses it, and makes it better by continuing to learn, by continuing to enhance it, by continuing to develop. There are a whole variety of programs out there. Like I said, ChatGPT is probably one of our most popular that we're familiar with. But there's, you know, Harvey, CoCounsel, Westlaw has this program, Lexis. So they are very, very popular. News release this week with ChatGPT, they have released a new program called GPT-4o, and that one is one that is doing a couple of things. One, it is making the AI generative process extremely fast, lightning fast, in fact. And secondly, it is beginning to move beyond the verbal, the written language, to using pictures, to using eventually video, but certainly using images. So it's really going to be developing. So I think as we sit here and we think about AI, the big question in our minds is AI going to make us obsolete? But when you think about AI, AI in and of itself is informed, it is data-driven. I mean, what is not to love about data if you're a lawyer? And it's efficient. Those are all characteristics that as lawyers we should embrace and we should want to use. And so I think that it certainly is not going to be something that is going to replace us, but if we embrace it, it certainly can help enhance us and make us more efficient. Okay, let's just talk about the elephant in the room, though. This is hard to escape when you're talking about AI, because it certainly does bring that up. The elephant is AI lies. And that is something that we have all heard about, you know, that the misinformation, the lawyer that, you know, presented a brief to the court that was inaccurate, that, you know, there were problems with it. And the fact that we talk about AI lying, I mean, that just gets our trial lawyer blood burning, right? I mean, we are ready to put ChatGPT on the stand and cross-examine it because it's a lying system, right? Okay, couple of things with this. First of all, there's two types of AI systems, and that's important to remember. One is the open AI system. That is the system in which public information is fed into it, and it is just crawling out there. It is looking for anything it can grab. So that means it's grabbing everything from magazine articles to blog posts to news articles to legal cases. It's just grabbing information, source after source, and using it. The source may or may not be valid. That's the issue, and that's what we're hearing about. The second type of systems are the closed AI systems, and those are the ones that generally are not free, but they are more controlled, and the information is being fed into them, and it is regulated. So you have a little bit higher rate of accuracy because, and those are the types like Westlaw, Lexis. They're feeding the cases into it and regulating what goes in. So it's not, my blog post from last week that's going into that closed system, for example. The systems themselves warn you. They say, yeah, we do lie. Not intentionally, but they're saying that based on this, it may produce inaccurate information, may not be accurate about facts, places, people, could produce harmful content. In fact, it tells you it may not be the most current because, again, it may not pull the most accurate. It's not guaranteeing that. And, recently the New York Times had an article talking about ChatGPT that I think is also kind of, it said, it can actually be based on hate truths, untruths, and they classified it as other garbage. But I think that's something you have to keep in mind. There's a second elephant that is in the room when it comes to lawyers that we have to think about. And that is mostly like, I don't want to. I don't want to know about AI. I don't want to use it. I don't want to have to learn this. It's moving so fast. But I think there's a lot of reasons to know about it. Now, it is expansive. There is a lot out there, and you don't have to use all of it all the time. But I do think you have an obligation to know about it and to know how to use it and be familiar and to certainly take a look at some of the ways that you can use it. So what we're going to do today is I'm going to take and walk you through just a few ways that you can use AI in your trial practices to help you. We're going to talk about how you can use it pre-trial wise, how you can use it at trial, a little bit about settlement and ADR, because where would I be with Powerhouse Mediation in my posts if I didn't cover that a little bit, and also talk a little bit about some of the concerns and ethics that deal with this. Again, one thing I want to say is I'm going to identify a lot of different programs and that sort of thing. I'm not making endorsements of any of these. Some of them I have tried, some I haven't. What I want you to know is the vast amount of information that is out there and available. The other caveat I'm going to say is that it might all change by tomorrow. That's always the danger of talking about AI, is that what is hip, happening, cool, and relevant and on the horizon today may not exist tomorrow. It may have been, there may be something better, it may be replaced. So those are always factors. But AI and the use of the courts, right now, there is a lot of discussion about should there be standing orders? Should we have some sort of uniformity in the regularity of how this is used? Right now, there's a move. Some of the states are doing this. Just telling you this because one of the things that I think this is a discussion that right now, I watched the Sedona conference. They met in DC in April, had 2 sessions on this. This is very much one of their topics. Ironically, their propensity right now is to say there should not be a standing order, that it's moving too fast, there's too much variance, there's too much, differences within the thing. So it'll be interesting to see what they come out with. But again, there's a lot on the horizon. So how can you use this when you're talking about pretrial methods? Well, certainly there's a whole variety. When you think about getting ready for trial, we're dealing with all kinds of documents, all kinds of discovery. We've got witnesses, pleadings, letters, depositions. The list just goes on. It is really ripe for what AI loves to do. When you look at some of the benefits of AI and think about it, one of the first ones I think really that comes to the heart of it is it can make you more efficient. It can really help to manage the documents and how you're going to handle the efficiency. Think about those boxes of documents, those boxes of medical records, the volumes of depositions. These are programs that if you try them and use them right, you can feed that in, and it is so instantaneous. It is amazing to watch how, boom, in the snap of a finger, it will give you a summary. It will provide the information. And the thing about generative AI, again, is remember, this is language-based. So you get to, if you don't like it, you get to go back and ask for more, or you get to tell it to do something different. So if I ask it to summarize the medical records and it presents a summary, I might say, well, okay, but I really want to know the instances in which the client went in and complained about pain at the C2 level. Or I want to know about the number of visits that the client went to seek chiropractic care. Or it can be, you can focus it, you can develop it, you can do lists. I can say I want to see, I want a list of the providers that are mentioned within the records that are not contained in, and I mean, it's just endless options that you can do that. Now, a couple of concerns. Obviously, privacy. Huge. We've got obligations to safeguard, to protect confidentiality. Certainly those come in. Open AI systems, would I recommend you feed those in there? Absolutely not. That is like putting it out on the open highway. You don't know once you feed it in where it's going. There's no way to protect it. We have obligations as lawyers to do that. But what we're seeing is some of the closed systems certainly are focused on that. They're adding safeguards. They are protecting the data. So you can certainly find ways to streamline that to make you more efficient. A lot of the programs we're familiar with, but what I want to talk about is a lot of the programs that are out there that you may not be familiar with. And I'm going to run through these pretty quickly, but I just want you to see that there's a little bit more out there than you tend to think about. Document management, how can you streamline? I mean, if you take a look right here, I just did a quick little poll of, I just thought, well, let's come up with 5 or 6 examples. And you can see, these are programs that you may or may not be familiar with, but I can guarantee you there's a list of about 20 more that go out there. So again, there's just a whole volume. Legal research, we're familiar with these. We've been using Lexis, Westlaw, FindLaw. We've been using those for a long time. But again, these are moving into the generative AI realm and definitely enhancing their systems. Ways, again, to streamline document analysis. Again, programs that you may or not be familiar with, but they are targeting trial lawyers. They're targeting the process. These are closed systems, again, that they're developing. And depending on what you want to do, they're certainly worth taking a look at. Chatbots, again, this is something that is beginning to develop. Now, I think the problem is, at least for me, when I think about a chatbot, I immediately get, like, my blood pressure goes up a little bit because there are those annoying little things that pop up and you can't get rid of. But when you look at the actual ability now that we have to construct chatbots, they don't have to be that little annoying pop-up. There's a lot of ways that they can be used to help streamline, get information, fill out forms, all sorts of things that could be very helpful with the clients that we deal with along with the process. And certainly, again, just want you to see that there's a wide variety of programs. Certainly, have to mention ChatGPT. That is one that is, I think most of us are familiar with. And again, it just works really lightning fast, but it's not the only one out there. Certainly, there's others. Perplexity is one that recently is being developed, and I think it's, again, it's focusing and developing. So there's things out there that are certainly worth looking. I want to talk a little bit about how can you use this at trial. A couple of ways that come to mind. One is to use it as a predictor. Now, do I think this is dangerous right now, especially if I think predictors, it's dangerous. But I think it's powerful and compelling if you're looking at it. And I think as the systems perfect, as they become more closed, it's going to give us some really strong data to use. If you can use your statistics, what are my chances of winning or losing? What might what might be a verdict range? What are some potential arguments or issues that might be raised? Again, these are all things that we do all the time in preparing for trial. But here's a machine or a system that might help us. And again, it's not meant to replace us. It's meant to enhance and, to have ways that you can use it. And again, Think about, if you had statements like this, there's a 97% chance of prevailing, 92% chance that your verdict may be over as, maybe a 7-figure verdict. The judge in this particular case has granted summary judgment 20 of 21 times in the past year. Again, it gives you those statistics to use. Now, predictors, dangerous right now? Absolutely. Why? Because they can be wrong. But again, if you're not relying on them for the fact, they certainly can help you and enhance. Ways you can use this in jury selection. I just popped in a quick little chat, and I just basically said, hey, I'm trying this case in St. Cloud. It's a wrongful death case, 27-year-old, 2 children, was working, was earning $150,000. She was Asian, played piano, loved to read books. Give me 10 jury questions, and I'm going to tell you that, boom, this is what I got. Just instantly, here are 10 questions you could ask jurors. Now, am I going to ask them? Do I recommend you do this and take that in and just go, okay, number 1, number 2? No, but they are great ways to begin to develop your case themes, develop your ideas. It's fast, and it gets that writer's block. It gets you going on this. Storytelling. We all love to tell stories. That's what trial lawyers do. What are some ways that you can do this? Well, if you use data-driven persuasion, you use images, you use, that information, it can be really, really, helpful. So in this one, I just simply asked, again, I said, hey, I've got this case, and you're going to get these slides. You can see this. It's a little hard to read from a distance, I realize, but I just said, I'm starting this trial. Here's the facts. I need some themes. Give me 3 potential themes. Boom. It gave me 3 ideas. I want to talk a little bit about visual image, and I think that this is something that we're going to see an explosion of, especially as OpenAI begins to develop and move. But this is something that is really, really persuasive. You read these words, my client was in a car crash. We've talked about this. But if you see an image of it, it gives you a definite visual, a definite idea. Reading the words, you might have pictured somebody at the stop sign getting tapped. Here you're looking at the image. We are visual learners. So are those jurors in the juror box. 65% of people identify as a visual learner, so they will remember more and longer what you show them. Now, let's talk about AI and visuals. So it's gotten to the point that you can simply type in what you want and it will pop up. So I use Canva a lot. And so I typed in, I want to see a panda surfing a wave. This is what immediately popped up. So I've got a panda surfing a wave. Helpful to trial lawyers? No, but it shows you how fast it can be done. But again, a couple things, mistakes. So in the first one I said, I want a trial lawyer that is juggling a bunch of things. What it popped up with, I thought it was interesting. It picked, a person that could identify as a trial lawyer. But juggling a lot of things, this person really juggles a lot, because if you look at it, he's got 3 hands. So, we might wish, but not necessarily. The other thing you need to remember with visual is the potential for manipulation. So here I took a picture, and this was the original picture, just so you can see what it looked like. I went into Canva, and I used a tool called a magic eraser. And if you look on the right, you can see what I did. I just simply took my mouse, scrolled over the stop sign. Now imagine that you're in a deposition or you're in a, mediation with Brett, and you say, well, I am absolutely sure this was the picture. And there it is, because within a second, where's that stop sign? Nope, there wasn't a stop sign there. My client couldn't have possibly run the stop sign. It's that fast. That is the big risk that we are coming into now as trial lawyers, is this manipulation of imaging, manipulation of documents, and deep fakes. That is kind of the new thing. March 1st of this year, there was a case, the Frazier versus Southeast Georgia Health System case, came down with a ruling that looked at a video in a case. It was a medical malpractice case. Plaintiff's counsel had a video of the purported procedure, and it was determined that it had been manipulated. It was not the procedure that they were representing it to be. It had been done at a later time, involving later, artificial intelligence and all that. The judge dismissed the case on that basis. It's one of the, we've heard a lot about these deep fakes, but this is one of the first cases I think that, the consequences are very real. Do this, here it goes. That's what the judge did, is dismissed it. Video. talking about deep fakes. We are moving into an era of video that it is making it very easy to change and to manipulate. You know, we've always been aware of things like the day in the life videos and the value of the pictures, but here now you can type in a sentence. And this is, I mean, these are two that I did. You know, one was I just said, I want you to show me an art gallery filled with pictures, and boom, it made a video. I can't show you the video from here, but I mean, it did that. The other one, you can see it's a video. You know, I wanted a car. I said I wanted to be in a car behind this, you know, watching this car. And boom, within like seconds, it created a video for me. And again, is it real? Am I in the car actually filming this? That's going to be the questions that are going to be facing us as we go through this, because this is the AI magic that exists now. Again, AI, I mean, think about the potential uses in closing arguments. You know, here again, I simply said, I have this case, I described the case, I said who my client was, and I said, give me a closing argument. And boom, ChatGPT immediately produced a closing argument. Again, would I take this piece of paper and read off of it? Absolutely not. But if I'm thinking, what might I say in a closing argument, it might give me some ideas. And I could then take and say, you know what, I don't really like that. I'd like you to focus more on the wage loss. And boom, it's going to give me something else. And I might say, well, but I'm in rural Minnesota, and so I need to have these. And boom, it's going to keep doing it that fast. AI is constantly changing, and that's part of what we have to remember. Ethical duties. You have a duty to be competent when it comes to technology, and our rules, our ethics rules, Rule 1.1 says you need to be competent when it comes to, obviously, the practice of law, but this has been held to apply to technology. And again, where we see it is comment 8. And comment 8 of our rules say you need to maintain the ability and you need to know the technology. Confidentiality, I think, is your second ethical rule that comes in. You have an obligation to protect the privacy of the information and to protect the confidentiality. As you're using this, as you're developing systems, as you're accepting information from clients who may have used it, you need to ask about these questions and make sure that you are doing this. Now, AI is not a perfect system. And so is it going to replace trial lawyers? Absolutely not. Why? Because it lacks emotional understanding. It lacks context. It lacks all the things that we as trial lawyers can give that AI. I don't think it's going to replace. But what we need to remember is AI is real. It's being developed by people. It's being used by people. It's here to enhance and make people more efficient, and people are going to use it. So as you sit here, taking the elephant out of the room, the choice is really yours. I think you can embrace AI and find the use and understand it, or you may just be left out in the cold, because I think others are going to do that. And so it's not a question of, am I going to be replaced by AI? It's a question of, am I going to be replaced by somebody that's using AI and knows it better? Thank you very much for your time. It has been a pleasure to share with you today.
Thanks, Christy. 20 years ago, almost, not quite 20 years ago, when I started working for Paul Thompson in the back there were two young female associates, or I think, Julia, you may have been a law clerk too at the time. Quick friends, we've been friends ever since. We have Julia Lyons here, who's at Larson King now, and Whitney Teal, who is our next speaker, who is one of the best work comp defense attorneys in the state at F. Ford. Thanks, Whitney.
Thanks, Lindsay. I actually sat in. I think Lindsay was the first interview I've ever sat in and did myself. And when we hired her as a law clerk at Woodson Thompson, it was probably one of my best hires. Where is this little guy? Speaking of learning technology, all right, I'm here to give you 20 minutes on what your work comp friends have been doing for the last couple of years here. Before I get into my slides, we do have some legislative updates. Governor Walz last week signed a new work comp bill. A lot of it's just technical cleanup provisions from our Office of Administrative Hearings. That's my courtroom. But two provisions are kind of interesting. One is attorney fees. So a lot of the reason, work comp, people do work comp and liability is the attorney fee provisions. So right now you get 20% of the first 130 if you're a petitioner attorney, max fee of $26,000. Our new law doubled that. So now we have 20% of the first $275,000 that gets brought in for a max fee of $55,000. So my work comp friends on the other side of the aisle have a lot easier way to get attorneys. There's always ways to petition for excess fees, ROAF fees, hidden fees, and 191 fees, but it's a burden of proof issue. With the contingency fees, you just have to file your retainer and you get them. The other thing I think, which was a long time coming, one of the benefits in work comp, if you are permanently disabled in a wheelchair, you can get home remodeling services, and those have been capped at $75,000 for probably the last 20 years. We finally kind of fixed that, and we upped it to $150 starting October 1, 2024. So 2 good provisions. One, making it more able to represent employees and get paid for it, and second, for those employees who are permanently disabled to get their houses fixed to purchase or new. But really, for the last year, for work comp, what we've been doing, we've been dealing with some assaults, some PTSD, and some repetitive stress injuries. There's a couple other legislative updates from last year. This one I love because my friend Mike Scully said it was because of him. He had a client who passed away, and the insurance company, after he passed away, wanted the guy had lost his arm, so he had an artificial arm, and the insurance company tried to get the arm back from his kids. So they didn't, but now we have this rule in our statute saying you can't do that. Eyes, orthotics, canes you get to keep. So this is the kind of shenanigans we get on the work comp side. Permanent partial disability. So if you don't do work comp, we have a super detailed permanency rule showing how much money all your body parts get. So if you lose your finger, which finger, how much money that is. We upped that significantly last year. It was probably a long time overdue. So now these people who have these permanent injuries do get a lot more money that they probably were entitled to. We've cleaned up our procedures a lot. So claim petitions actually need to have some support. That's our complaint. And they actually need, the petitioner's attorneys need to get us authorizations within 14 days instead of 30. Getting medical records, it's tough, it's hard, and in work comp we move fast, so it really delays our things. So the quicker we get those authorizations, the quicker we all go off to the races, because we're supposed to try our cases within 9 months of them getting filed. In return, my independent medical examiner deadlines are getting tighter. I can't blow them, basically. What it means, if I need an extension, I got to ask for it before the deadline runs, or I don't get my report. But getting into kind of our case law, and this is kind of the fun stuff and what I wanted to really talk about for the updates. So for the last year, our Supreme Court cases have dealt with assaults, PTSD, and repetitive stress injuries. So repetitive stress injuries are called Gillette injuries because the case from 1970 or 50, whatever, was a woman named Gillette, and she was working at the precursor of Dayton's, walking around a lot, had a foot injury, but didn't have a specific injury, but after walking for a decade, they found it was compensable. So we call repetitive stress injuries Gillette injuries. And that was kind of readdressed in this Walmart case from last year. So this is kind of the fun shenanigans we get on the work comp side. Ms. Schmidt in 1993 had a left knee surgery. She was hired by Walmart in 2005, 13 years later. At Walmart, she was a cashier. She did some management. She was walking, squatting, lifting up to 50 pounds, climbing ladders. In 2011, Ms. Schmidt had some left knee pain. She told her doctor, well, it hurts when I squat and kneel, and I squat and kneel a lot at work. Now, 2 legal principles now come into play here. On repetitive stress injuries, a lot of times we fight about, okay, so what is the date of injury? And 2, when does the employee legally have to give the employer notice of the work comp case? And so, in 2011, when she's telling her doctor, hey, I squat a lot at work and this is really hurting my knee, as a defense attorney, I said that's your trigger for notice. You got your 30, we have a notice provision in work comp. You should give notice within 14 days, but really within 30 days, and for sure by 180 days. And there's, different reasons why different dates apply. But she doesn't give notice. She continues to work at Walmart. She does not lose any time from work. In 2015, she finally has that total knee replacement on her left knee. Her surgery is on October 27, 2015. She takes some time off of work now from Walmart, but Walmart's able to accommodate the restrictions, because they always do. And then she's still having problems. Years and years go by. She's still treating. She's still having problems at work. She has a revision of that total knee in January 2019. On March 1, 2019, she meets with an attorney, and that attorney gives Walmart notice of a possible Gillette or repetitive stress injury the same day. Walmart denies it for various reasons, but one is, hey, you didn't give us notice. You had this total knee done, 4 years ago, and this is the first we're hearing about it. You didn't give notice within 180 days, so too bad, so sad. What the court found was the employee didn't have to give notice until first she knew that her work was causing her injuries, which she did, but also that it was possible to be a compensable work comp claim. And the comp judge found it wasn't possible for her to know it was compensable until she had that discussion with that attorney on March 1, 2019. Then the second thing we kind of look at in these work comp claims is, what is the ascertainable date of injury? What is your date of injury? And sometimes it's when you first have pain, sometimes when you first see the doctor, first get restrictions, first have surgery, etc. Here they found the date of injury was the date of her total knee. So they found a compensable injury back in, 8 years later and she was awarded benefits. There's a lot of litigation. Walmart wasn't happy with this decision, went up to the Supreme Court, and the Supreme Court supported the comp judge. So I think the takeaway on this is Gillette injuries are difficult to defend for notice, and it's really, looking at when the employee should have known it was compensable, and a lot of times it's not until they have that conversation with the attorney, because it's just not a typical work comp claim. Something doesn't happen to you. It's minute trauma over time. All right, the next couple cases are PTSD. So for those of you who are not familiar with our work comp legislative changes in PTSD, in January 1, 2013, that's when we kind of decided, the legislature decided that while we do not allow mental injuries to be compensable, so if I have a physical injury and because of my physical injury I get depressed because I can't function, that depression medication is compensable because it's a consequence of my physical injury. Likewise, if my work stress is causing me, it has to be extraordinary, it has to be over and above, but if my work stress causes me a physical disablement, such as an ulcer or a heart attack, that can also be compensable. Before the legislative changes, though, in 2013, like a mental injury was not compensable. Minnesota was one of the minority of the states not recognizing any of that. One of the cases I think was the catalyst was the Red Lake shooting case. One of my friends, Mike Garbo, represented one of the teachers from that case, and he did some really interesting creative legal work. She wasn't physically hurt, but what she saw was horrific. And he actually had brain MRIs to show a physiological difference in her brain. And he actually had the judge, I think it was Judge Mesna at the time, awarded benefits. It got settled on appeal. But after that case and we all were looking at it as a work comp bar, the law got changed because some things need to be a compensable work injury, such as PTSD, even if you don't have a physical injury. So that was one of, there was a lot of different things coming, but that was one of the catalysts for these law changes in 2013. These claims are denied almost 99% of the time. There is a statistical analysis the Department of Labor puts out every year, and it's a lot of information because we're comp lawyers, we love numbers and statistical analysis. And one of the things they keep track of is whether or not PTSD claims are being admitted or denied, and they're being denied. So one of the things that the legislature then changed in 2019 is there's now a presumption for pretty much first responders that if you have PTSD, then we presume it's work-related. That me as the defense attorney, I have the right to rebut that presumption. So that's kind of the landscape of the land as far as PTSD and work comp claims. But there are still a lot of questions for us that practice this area law as to where are the limits and the boundaries of this law. So we're getting a lot of appellate decisions right now as we're trying to all figure that out. And this was one. So this is a sheriff, so he's entitled to the presumption, who was put on leave in February of 2019 because he used some physical force against a minor suspect. While he was on leave, there were suicide ideations, a lot of mental health issues, and he was diagnosed with PTSD. By March 30, 2021, though, he no longer was diagnosed with PTSD. To have PTSD, there's specific criteria in the Diagnostic Statistical Manual that you have to meet. So after a few years, he no longer had PTSD. He had acute stress disorder, depression, a lot of other things, but did not have PTSD. So the litigated issue in this case was really, when you don't have PTSD anymore, do you still have a work comp claim? Now, arguably, these other mental health diagnoses were a consequence of his PTSD. So you get into this consequential injury analysis, which the court really didn't take up. So that's still one of our questions for our work comp petitioners, is how far can the consequential injury rules and liabilities and exposures, and we'll probably be litigating that in the next few years. But what the court said here is, well, once you don't have PTSD, you no longer have a work comp claim, and so your benefits stop. And so right now, that's the law on that. But again, I think there's some room for consequential injury arguments on this that didn't get really flushed out as far as I saw in the decision. But for me, when I represent the counties and governments, that's one of my line of defenses now. Now, one, if you have PTSD, I didn't cause it. Two, well, if you had PTSD, you didn't provide notice, or you really didn't. And three, well, yeah, maybe you had PTSD, but you don't have it anymore. And so another thing that we all fight about. All right, this is another PTSD case. I don't have a ton of time, so I'm gonna go over that one. And this is Juneteenth. So this is a case where Judge Lund denied the PTSD claim, and it got reversed on appeal for technicalities and expert reports. And again, this is just another thing we're still trying to figure out, what questions do we have to ask our experts on these PTSD claims? So we have to have psychologists or psychiatrists, first of all, on these. But the second is, here the employer's expert found the employee didn't have PTSD on the date of the exam, and the judge adopted that opinion and denying the claim. It got reversed because the question isn't, does the employee have PTSD on the date of the exam, but did the employee have PTSD on the date of injury? So if your date of injury is sometimes 2 years before your independent medical exam, you have to make sure your examiner is really doing that forensic analysis and saying, did the employee have PTSD on whatever date was alleged in the claim petition? So that's kind of our takeaway on that one, is how to ask those questions of our experts. Moving on from PTSD into our assault case. This is a fun case. So I'm going to spend the last few minutes talking about this. So if you don't know work comp assault rules, they're pretty basic here. If I am shot because I'm speaking at a CLE, that's compensable. If I am shot because I'm cheating on my coworker with her husband, that's not compensable. And if I'm shot and I'm at work and no one knows why I'm shot, it's also compensable because the burden of proof on the assault exception is on the employer-insurer. And if me, representing the employer, can't prove why the assault happened, I lose my burden. It's found compensable. So in Doubletree, so Doubletree was the employer and Profit. Profit worked at the Doubletree doing some cleaning. Another guy named Richard also worked, last name Richard, also worked at Doubletree. Profit and Richard, they knew each other before, they'd worked together before, they were social media friends, they had each other's phone numbers. Richards once attended a birthday party for Profit previously. Profit had invited all the coworkers, and they attended. So there was a relationship outside of work that was established pretty easily here. What happened on the date of the injury was Richard first went to Profit's house saying, hey, I need to see your dad. And daughter says, my dad's not here, he's at work. So then Richard goes to Doubletree. Richard says, hey, I'm friends with Profit, give me a discounted room and here's my credit card. He wasn't supposed to get a discounted room, but did anyway. And his credit card was declined, so he shouldn't have gotten that room key, but did anyway. He got that room key, swiped it, found where Profit was, which was a different room, and then attacked him with, the opinion says, a military-style entrenchment device or something. Basically, it was a really sharp pen, it sounded like, but the guy was hospitalized with some internal organ damage. It was a bad assault. When the police asked Richards, well, why did you attack Profit? Richards said, well, he killed my uncle. Profit didn't kill Richard's uncle. Richard's uncle died of a heart attack 2 months ago. But it turned out after, the criminal trial went on that Richard is an undiagnosed schizophrenic, and, that is why he attacked Profit, because of delusions in his own mind. Profit claimed workers' comp. He's at work, right? He got stabbed at work by a coworker. Seemed like a clear-cut work comp case. There's a lot of analysis that went into this case. The petitioner's attorney really went into, well, what does intent mean? We have some suicide work comp cases. We've talked about that. You know, there's a lot of statutory analysis in here. But really what the Minnesota Supreme Court said was, look, work comp, we're a statutory basis of law. We don't have common law. If you look at the assault exception, there's nothing about, you know, whether or not someone's mentally disabled and can they formulate intent. We're not going to get into that here. What we do know is, though, Richard's reasons for the injury were delusional. They were non-work-related delusions, not work-related delusions. Therefore, this was not a compensable case. Now, all of you liability attorneys out there, I'm guessing there's probably some cause of action against Doubletree for giving the guy the room key when they shouldn't have. He was also acting strange. The front desk worker noted that, you know, Richard was acting strange when he asked for it. So I'm guessing maybe there's still some cause of action for profit here, but work comp is not the correct venue. So I think the assault exception really comes into the exclusivity of the Work Comp Act. We get into some fun cases now and then because the employee actually wants it not to be work comp, but my employer wants it to be. And if my insurer kind of has a global insurance policy with them, we want to keep it in comp because we don't want to deal with pain and suffering. But this is kind of the most recent assault case for the Minnesota work comp system, and it's just kind of a fun fact pattern here. So I think that's all I have. Thank you. And thanks, Lindsay, for letting me talk.
So it's time for name, image, and likeness. And the way we're going to handle this is Melissa Stahl is going to give us a little introduction on what she and her partner George Soul, and maybe, do you have other partners now? Just you and George?
We have another partner. Yeah.
Okay, she and her partners did a deal with the women's basketball team at our great university here. I'm wearing, I'm sporting it. So Melissa's going to talk about that. Then Taryn Sharma, who is with the Frederickson firm, who also runs the Name, Image, and Likeness Clinic at the University of Minnesota Law School, which who knew we had that, but we do. And then we have Jeremiah Carter, who is Name, Image, and Likeness, transfer portal, keeping our athletes in Minnesota, bringing them back. This is the person that we are relying on to take us to the next great thing. We're going to the Final Four again, and it's going to count this time. For those of us where it didn't count theoretically, but it does in my world, but you know how that goes. So this is going to be great. Think of your questions, because when we get done with some presentations so that everybody understands this, we're going to have plenty of time for questions and answers. I've been preparing questions for a month, so if we don't have enough, I have enough to fill everything we wanted to know, and we're afraid to ask. And so I think this is going to be really good. Hopefully, then, assuming all things go as planned, Ben Utecht, who, for those of you who are Minnesotans, know that he was a great football player for the Gophers, an NFL player, a World Series or a Super Bowl champion. And he should be coming to join our Q&A panel. So this should be really good. I'm hoping. It's not very well planned, but then that's just me. So that's how I do things. So Melissa, let's go.
I'm not Melissa, but I'll get going. So yeah, we took the liberty of planning for you, so don't worry about it. We're all set. All right. So first, you just want to give an opportunity here for folks to introduce themselves, and then we'll get going. So, Melissa, you want to start?
Yeah, as Brett said, my name is Melissa Stahl. I am a partner at Soul and Stahl here in Minneapolis. We do a lot of products liability defense litigation, some medical negligence litigation, and commercial litigation here in Minnesota and nationwide. None of that is why I'm on this panel. I am on the panel today because our firm, as Brett said, has entered into a sponsorship NIL deal with 4 of the outstanding University of Minnesota Gopher women's basketball players.
Thanks. Hi, everyone. My name is Terrence Sharma. I'm a 2022 graduate of the University of Minnesota Law School, and while I was a student there, I worked with Jeremiah and some others to help found our name, image, and likeness clinic, which is housed at my firm, Frederickson & Byron, where I'm an M&A associate. In addition to doing M&A stuff, I get an opportunity to work with our great student athletes, both at the university and at universities across the country. We get to work with collectives and brands that are hoping to enter this space. So this has been a really exciting 2 years now that we've been able to work on this, and so excited to talk about it today.
All right. Thanks, Aaron. Yep. My name is Jeremiah Carter. I'm the Senior Associate Athletic Director for NIL Policy and Risk Management. I've been at the university for a little over 10 years, mostly in compliance. Unlike everybody up here and probably everybody else in the room, I am not a practicing attorney, nor did I go to law school, so I don't know that I'm actually qualified to teach you all anything. But I do have a lot of expertise in this area. And more importantly, I feel actually really comfortable in a room full of attorneys. I played football and then coached football at Minnesota. After that, I spent 6 years at the NCAA helping to write rules. And all throughout that time, I was consistently mistaken for being an attorney because I worked at the NCAA. I then came back to Minnesota and ran the compliance department for 9 years, where, again, consistently it was, well, Jeremiah, you went to law school. It's like, no, I did not. To be clear, nobody mistaking me for an attorney was actually an attorney. It's just everybody else. You all know better. But the reason why we're talking about name, image, and likeness, the reason why we have an hour's worth of presentation that barely scratches the surface and then a longer Q&A afterwards, frankly, is because of NCAA rules and the way that they've really kind of convoluted things over time. So it's with that background and preface, I wanted to share with you one of my favorite quotes about the NCAA. All right, this quote comes from a guy named Mike Leach. For those of you who don't know, Mike Leach was a really high caliber football coach. He coached at 3 different Power 5 schools. He was the conference coach of the year in 3 different conferences. He was the national coach of the year twice. And before he became a head football coach, he got his JD from Pepperdine Law School. Okay, a little bit of a non-traditional path. He gave legendary press conferences. Wait until I'm done talking, but Google him, watch some of his press conferences. It's great. Advice for newlyweds, favorite Halloween candy, all sorts of great stuff. But he was asked about potential NCAA rules violation on his team. And his response was this, quote, a lot of these NCAA manuals and rules, they're not written by lawyers, they're written by people pretending to be lawyers. And the only thing more annoying than a lawyer is somebody pretending to be a lawyer. And I've got a law degree, so I know something about it. Without all these pretend lawyers, all of a sudden that manual would be about 1/3 the size of it is now. So as a former pretend lawyer for the NCAA, I'm going to talk to you about this. All right. So we're going to run through kind of the background a little bit. I think it's important to understand how we got to where we are, and then the different phases of NIL, and then really what our challenges are moving forward. So to start, basic understanding, NIL is just anything where a student athlete is able to use their name, image, their likeness, their appearance for a commercial product in some way and receive payment for it. This is completely different from what the NCAA had allowed from day one in the 100+ year history of the NCAA, where this was completely prohibited. When I was a student athlete at Minnesota, you weren't allowed to do any commercial endorsements in any way. It really came about because they were concerned that they would be unable to keep boosters and other groups out of kind of making this into pay for play. So what caused the NCAA to change course on NIL? if there's only one thing that you take away from my presentation today, it is going to be this. It was not the Alston Supreme Court decision that made the NCAA change their mind on NIL, all right? Just to emphasize, it was not the Alston Supreme Court decision. And one more time, I've heard judges say that it's the Alston Court decision. I've heard Congress people, and I've heard coaches, I've heard ADs. It was not that decision that led to it. It happened to coincidentally, the decision in that case, and it was a 9-0 Supreme Court case in Alston, and a blistering concurring opinion from one of the justices that really kind of signaled the end of amateurism as we know it. But ultimately, what forced the NCAA to change their position was state action, state legal action. So California was the first. They passed the Fair Pay to Play Act, which actually prohibited pay to play, but that's beside the point. But it essentially said no organization can prevent college athletes from making money using their name, image, and likeness. When they passed it, it had a far off effective date, but then some other states looked at that and said, you know what, that's a pretty good idea. We're going to do that in our state. And finally, you got to the point where Florida said, yeah, we're not waiting a year or two to implement this. You have 6 months, figure it out. So July 1, 2021 was the effective date of that Florida law. A couple of other states jumped in that, and then all of a sudden the NCAA was at a point where they had no choice. They needed to deregulate this or try and sue every single state at the same time. So July 1, we all of a sudden were able to do NIL, name, image, and likeness. Student athletes didn't really know what to do with it. Companies didn't really know what to do with it, and at the time, boosters didn't really know what to do with it anyway. So the first phase that kind of went through November of that year was kind of the standard, brands trying to feel out what will this mean, right? You had a couple national brands. That's a wide receiver at Arkansas and his dog with I think it was like PetSmart. Barstool Sports said we're just going to sign up every single student athlete to an NIL deal where we pay them nothing, but they get to be a Barstool athlete. You had creative things like here you have an NHL team paying a college football athlete to promote NHL games. Why? Because they wanted kids at that university to come to NHL games, right? Kind of makes sense. And of course, what would NIL be without trucks and cars and dealerships, right? Now, those have been happening for a long time. They just used to be against the rules, so it was how good you could cover it. But this is, kind of the first month or two, it was kind of some, testing value, right? Now, immediately on the heels of that, we also had entities saying, well, let's test out what the NCAA is actually going to prevent, right? So the first one that we saw where it was, the NCAA's bright red line was, you can do NIL, but it cannot be a substitute for pay for play, because that's our bright red line. So the first kind of test of that was this gym owner, MMA gym owner in Miami said, well, whatever, I'll pay every single football player at the University of Miami to promote my gym, and I will pay them $500 to promote my gym. As a former backup offensive lineman, what I would say, or what these backup offensive linemen would say, is not getting anybody to an MMA gym, let alone making it worth $500. But that's what you could do, right? So that was kind of the first big test, right? Then we had BYU football. They brought in a company, and that company said, well, for promoting I think it was like a nutrition company, for promoting our nutrition company, every walk-on the team, we will make sure that you have, we pay your tuition. You'll have a scholarship, right? Again, is that pay for play? Is that a way around scholarship rules, or is that actual NIL? Then we really started to get out there. Again, I think this is like a whopping 4 weeks after the NCAA changed their rule, where a mortgage lender who happened to be an alum and huge fan of Michigan State said, I'll pay every single football and basketball player $500 a month, every month, to promote my mortgage company. Now, name, image, and likeness is supposed to be like influencer activity. Listen to me, you need to trust me with this product, right? Paying $500 a month to have 18 to 22-year-olds who have never owned a house or taken out a mortgage try and convince people to use a mortgage company, money well spent, I don't know. But their football and basketball team, they were hoping were going to get better. That was the point. So with that, the NCAA pushed back a little bit, but it really didn't do anything. So we got to November of 2021, and all of a sudden, it was the first open recruiting period for football. And that completely changed what was going on. All of a sudden, we had these things called collectives start to pop up. At the very beginning, collectives were, we're a group of fans or boosters, and we are going to pay for a specific, in some cases for a specific team at a university, or in some cases even a specific position, right? So it was just this kind of concentrated interest group that said, we're gonna be able to, hopefully pump some money and provide some NIL opportunities for student athletes in these sports. Rising Spear with Florida State was one of the first ones. Another one popped up. This was at Tennessee. This was called the Spire Group. They're basically like a sports agency, specializing only with students at Tennessee. Horns with Heart, you can probably guess what school that is. They started out just working with offensive linemen, so very close to my heart, but then they moved on and expanded and ended up working with more student athletes. Gator Collective, you can probably figure out what school that was with. So they all became associated with a specific school, and the boosters were kind of pooling their money for the specific purpose of getting it to student athletes while somehow trying to avoid the pay-for-play restrictions that the NCAA rules put in place. And then right on the heels of that, when all of a sudden it became clear to a lot of coaches in football that, hey, these recruits that I used to be able to talk to are now asking me how much money is going to be available if they choose to come to my school, that quickly changed the entire landscape of, okay, maybe we need to have one of these collectives, right? There's a reported $8 million contract signed with a football recruit. There was, the NCAA board came out and said that they were, concerned that what these $8 million deals, things like this, are actually recruiting violations. Well, the NCAA board could, kind of say whatever they wanted to about concerns. They could try and talk about guidelines, but it very, very quickly moved from there, where it was just talking about, providing real NIL opportunities to, what really is no longer about NIL, it's about something broader. So a lot of states were kind of pushing then to change their NIL laws or expand their NIL laws so that they could hopefully provide a little bit of a competitive advantage to the schools in their state so that they could maybe do some things, set aside NCAA rules that other schools couldn't set aside in other states. We got to the point where kind of we are now, where we just have a patchwork of state laws. What you are allowed to do from a name, image, and likeness perspective depends on what state you are in. The state of Minnesota does not have a law, which for a long time was beneficial to us because we had no artificial restrictions. But now that it's kind of pushed beyond that and it's starting to allow more and more things, that started to hurt a little bit from a competitive standpoint. So where we've gone now, and where we are at that has caused really kind of what you've seen, especially the last 6 months, there were two main things that led to this. So the first one was a West Virginia court that issued an injunction that said student athletes can transfer as many times as they want to and be immediately eligible. Previous rule was you can only transfer one time. So with that injunction, that really allowed student athletes to explore their options a lot more. Right on the heels of that, in February, you had the Tennessee and Virginia attorney generals essentially sue the NCAA, saying you cannot restrict a collective from talking to anybody they want to, offering whatever they want to during the recruiting process. So it had been you weren't allowed to actually make offers during the recruiting process. Most schools were doing it, or most collectives were doing it, but the NCAA was at least trying to keep a lid on it. You get to the point where this injunction comes in, and now essentially what that said is there are no recruiting rules for collectives. NCAA, you cannot stop a collective from sending a contract to a current player on another team and making them an offer. That really has led to a completely unrestricted free market in this area. So with that, I am going to I'll run through a couple of the actual guidance here, and then I'll bring up I think Taran's up next. All right. So some of what we can do and can't do. So where the guidelines are, right? And this is really kind of a mix of NCAA guidelines and university policy. So we are allowed to help in certain ways where we're allowed to provide some benefits to student athletes. We're allowed to do some of the work for them as a university. But for the most part, they have to be on their own to conduct these NIL deals. We're allowed to do some things that promote it. We're allowed to purchase, as a university staff member, I can purchase something that's de minimis in value, but I can't, for instance, I've seen a couple of times, Coach Fleck should just write half his paycheck over to the collective, and then that'll solve all of our problems. Well, at this point, at least, NCAA rules don't allow that. We're allowed to do some kind of literacy, branding, and work with local businesses as well. But there are some limits to what we can do to assist student athletes. So really the NCAA's kind of bright red lines are a student athlete can't be paid for promoting an athletic competition that they are participating in, whether it's the university competition or if they're doing an outside competition. They can't be paid directly to promote, directly or indirectly to promote that. Didn't take long for people to figure out how to get around that, but athletic department staff can't enter into NIL deals, so we're not paying them directly. And conferences and universities are not permitted to pay student athletes directly. The big disclaimer with all of this is this information is accurate as of March 17th at 12:30 or 11:30, whatever time it is. Check back with me in a day, 2 days, 3 days. This could all be completely different. That's how quick it's moving. The biggest thing is the way that the NCAA has treated third parties has been really inconsistent and challenging. So as an example, 3 different groups here. Multimedia rights holders. Ours is called Gopher Sports Properties. Every major university athletic department has one. They are the ones who we sell our rights as a university so that they can go out and sell our marks and logos. So every time you see an advertisement at Huntington Bank Stadium or the dasher boards that go around our men's and women's hockey arenas, or you hear an ad during one of our football games on the radio, those are sold by a multimedia rights company. Ours is called Gopher Sports Properties. Well, we share common goals and interests, and the NCAA says, well, you're kind of like the institution, so you can't pay them directly. The next one, you have the University of Minnesota Foundation, right? Where they're a separate entity, right? They're a 501c3. They exist only to support the University of Minnesota, and our goals are very closely aligned, but they're a separate entity. They are treated exactly the same as the university in the NCAA's eyes. And then you have collectives, right? Collectives, for us, it's one called Dinkytown Athletes. They are a legally separate entity, but they only exist to support University of Minnesota student athletes. So there we have 3 separate groups that are completely separate entities legally, But in some cases, they're being treated exactly the same as the university by NCAA rules. In some cases, they're being they're a wholly separate group that can do whatever they want to. So with that, now I'm going to bring up Tara.
Thanks so much, Jeremiah. And for anyone that is a Gopher fan at all, I think that there should be some sort of gratitude, because not every athletic department is going to have someone as plugged in as Jeremiah is, with his experiences and the amount of knowledge that he has specifically for this rapidly changing environment. So I think that we're really lucky, if you root for the Gophers, to have someone like him with us. So. Like I said earlier, my name is Terrence Sharma. I'm a co-founder of our Sports and NIL Clinic at the University of Minnesota, and I'm an attorney at Frederickson and Byron. So just real quick, just a show of hands, how many of you were aware that we even had a clinic, or that these types of programs where we could provide pro bono legal services to student athletes even existed? Yeah, just a couple. Yeah, so one, we need to do a better job at marketing. But two, I think that really speaks to how much isn't known about this space, even though, it's a big deal to us, that from the outside, it seems really easy to just say, college sports are changing, and I don't like the way that they're changing, and we can blame NIL for that. But I hope that you can gather from the things that Jeremiah was talking about, especially in terms of timeline, how many different elements contributed to where we are right now. And my belief is that this is sort of an interim period, and things will change. Things will probably go back to a similar situation in terms of consistency as what you're used to. But that's not where we're at right now. And so what we're here to do is to educate you on where we are and what we're working through right now, and hopefully we'll end up in a better place, a more equitable place. So I'll talk about how I got here to this position, and then what services we're able to provide, why this is important right now, and most importantly, why you should care. So are we on the? Yeah, so big thing, first of all, what services are we able to provide? So the clinic was founded in the spring of 22, and we got a lot of help from Jeremiah, specifically from the Office of the General Counsel, to make sure that we were compliant with all sorts of NCAA rules and regulations. And so that was really important. A key factor in our clinic is that we are also separate from the university. Our clinic is housed at my firm, Frederickson and Byron, like I mentioned, and the firm provides those services pro bono. And we're also not limited to only student athletes. We're not limited to only student athletes at the U. It's for all students who can take advantage of these rights to celebrity. And so we've also worked with people who, for instance, their apartment building is interested in having them in an ad. And we've been able to work with them as well, even though they weren't student athletes. And when I say that we were able to work with them, I mean that we review contracts. We're able to advise on whether something is really market, because we've seen a lot of these contracts now. And as generally deal lawyers, we're able to say, this is something that you need in this contract. This is not well written. And with a new space, a space where there are so many players in there, and just participants, you need to make sure that everything is on the up and up, especially when something as important as eligibility is at stake, because this is a way for a lot of these kids to be able to attend college, and the ability to earn off of their name, image, and likeness is important for them to be able to provide for themselves and for their families as well. So we're able to review those contracts. We're also really lucky that we've been able to work with brands, drafting contracts, form agreements that are going to be compliant, again, that are not going to put any sort of athlete that the companies are trying to partner with in jeopardy of losing their eligibility. And we've also been able to work with collectives in the same way, and just ensuring that everyone is maintaining compliance. And that's our big focus, is that we want to make sure that nothing untoward is going to happen that's going to jeopardize the future of these guys and girls. So why is this important? Well, the fact of the matter is that this is the way that college sports is now. I grew up loving college sports. I grew up a big Duke basketball fan, and guys would stay for 4 years, and that was really great. You would get an opportunity to really learn and grow with a specific team. And I think that this, being on top of this, is the best way that we have to be able to preserve that. And you saw that there was some turnover with the basketball team this year, but we were also able to bring back a lot of our great players, and that's because we are focused on being ahead of the curve when it comes to NIL. And so that's been a great collaborative effort between the teams, the coaches, the athletic department, and also our collectives and donors. And so I think that for all of you, you should care, because we all want to see a winning product. People say that it's only sports and it's not that serious, and that's one way of looking at things. But I think that sports are such an important fabric to our community, to our country. And when you have successful sports teams that you can be proud of, both on and off the field, I think that contributes a lot to how we feel about ourselves and where we live. And so the work that people like Jeremiah are doing, that the collective is doing, I think contributes in some way to that. So I was lucky enough to build a relationship with a shareholder at Frederickson and Byron, Chris Pham, who helped start our sports law practice a few years before I even showed up in Minnesota. And so building that relationship with him, we were able to work together with the university to found the Sports and NIL Clinic, and we've now worked with dozens of student athletes and brands and collectives, and I think that it's only going to continue to grow. We're able to enroll 4 students at the University of Minnesota Law School every year. It's a very competitive class to get into, and we've had 2 cohorts come through, and both of the 2Ls that were with us, the second-year law students, have then cycled on to become student directors. And so I think that speaks to us growing a real pipeline of students that are interested in this space. And so I'm really excited to see it grow, and happy to answer any questions that you have. Melissa? Yeah, all right.
So, Melissa coming up here next. One thing I just wanted to bounce back to real quick, just on the, so the one on the right, you might have a hard time seeing it, but this is what prompted the first time that Taran and I had a conversation, was because we came across this language in a contract contract terms and agreements that one of our student athletes was agreeing to. And again, pretend lawyer. But I was horrified when I saw student athletes agreeing that in exchange, in this case, it was in exchange for a t-shirt, they were signing over their worldwide, royalty-free, perpetual, alterable use of their name, image, and likeness in perpetuity. Now, whether or not that would hold up in court, I have no idea. But I know that when I saw that, and I asked a student athlete, hey, do you know what you signed over in exchange for a t-shirt? And they said, no, I scrolled through and I hit yes and I moved on. I'm like, oh man, we need help, right? At 18, I wouldn't have known what that was. I barely know what it is now, but I know not to sign it without an attorney, so. Okay, with that, welcome up, Melissa.
All right, thank you. So The biggest questions I get about Soul Install's sponsorship of Gopher athletes are, why did you do it? How was the deal made? And how's it working out? So why we did it, we saw this as a little bit of an unusual opportunity to advertise. As I said, we're a national products liability commercial litigation firm. We are not the type of firm that typically advertised on, the banners at the hockey games or putting up our name on a billboard. The clients that we typically work with have chief legal officers, in-house counsel that are making their hiring decisions based on word of mouth, people they've worked for before, people they hear at conferences talking about products liability, not necessarily law firms that are advertising at sporting events. So we'd never done anything like this before, but we're huge sports fans. My partner George Soul and I are just sports fans. We like going to games. He's had season tickets at various events. I've had season tickets at the Gopher volleyball games, take my kids to hockey and basketball games all the time. And this fall, George said to me, what if we think about, an NIL deal? And at first I kind of thought it seemed a little goofy and kind of off-brand, but the more we talked about it, the more it really fit with our brand. We thought that it was a great chance to highlight our community involvement. It was a great chance to support an institution that gives back to our community so much. And we wanted specifically to work with female athletes. As a female trial lawyer, that is a cause that's close to my heart. I don't see a lot of other female lawyers usually in the courtroom, even now. And so I'm always interested in building up other women. So we looked into it a little bit, quickly figured out that going to the collective, Dinkytown Athletes, was the way to go. And from there, it was a really smooth process. We said what we wanted. We wanted to sponsor some female athletes, either volleyball players or basketball players, ideally, and some women, maybe if they had an interest in law. We thought that would be a great connection. And just asked Dinkytown what that would look like. So it was basically a series of emails and phone calls, and in no time at all, we landed on 4 of the local Minnesota women's basketball players that had all came in as first years together, all stayed after Coach Whalen left together, and all have committed to the program. So we have Amaya Battle, Nia Holloway, Mara Braun, and Mallory Heyer. All Metro high school athletes, all really impressive young women. And what we wanted out of it wasn't Instagram posts or, flashing our Soul Install hoodies. We wanted more of a connection with the athletes. And so we realized that we were formulating this deal in a little bit of a different way. So we said, we want to meet with them. We want to talk to them about their athletic endeavors and their education and their future plans. For those of us who know Soul Install, we throw a couple parties every year, and we asked if they would come to the parties, mingle with lawyers and judges and colleagues and friends that we have at our firm, and just more wanted that connection. Some of the athletes that we work with have deals with, like a bacon company, and they take their picture with the bacon and they post it on Instagram, and that's a whole different deal. So we acknowledged from the outset we were looking for something a little different, and Dinkytown was super receptive to that. The athletes were really receptive to it, and we, like I said, we wanted to meet them. So the first picture on the right there is the first time we met them, and the The gal on the left is my daughter Emma, and might be the most happy of anyone in this deal that we have sponsored these athletes, because she gets to tag along and talk with these awesome student athletes. So that's how it all came to be. Working with Dinkytown was really easy. The athletes have kind of a handler that help communicate back and forth, and it's all been really, really smooth. I think that the great thing about this for our firm, so how that deal came to be, what we got out of it, and then how it's working out, are the three questions I highlighted at the outset. And all of it has been very smooth. I sound a little bit like an advertisement for NIL deals with these athletes, but it's worked out really well. I think that we would do it again in a heartbeat, and it's been really fun to feel that connection to the university. It's been fun to get to know these student athletes, and I think that it has sparked the interest that we were looking for as a law firm. A client just this week asked me about it and asked about the deal, and it's a Fortune 500 company, and he said, it's perfect. It's perfectly on brand for you guys. You're a small firm, you're really involved in the community, you're giving back all the time, and if I see your name up on a banner, that doesn't mean nearly as much, as knowing that this was a really intentional act by the firm to engage in the community that way. And we will hand it back to Jeremiah to talk about some other deals that look a little different than my law firm deals.
Thank you. So yeah, that obviously is one version of NIL. NIL looks lots and lots of different ways, right? So sometimes it doesn't involve university marks and logos, and it's just because it's a large, athletic, good-looking person that they want in an advertisement. This is a defensive lineman that plays for the University of Minnesota. Hammer Strength is actually based down in, I think it's like Shakopee or Lakeville, something like that. And they said, hey, we need to, need to take some ads of student athletes doing this, and that's what they got. But as you can see from that one, it's not branded, right? You'd have no idea that it's a University of Minnesota student athlete in the ad, but he got paid for it, right? We also have ones like this, right? Here's Mara Braun, who, as you can see, with Affinity Plus, she's going to get a lot more expensive to work with. But, here we have, pictured in her uniform with the Block M, with the proud sponsor. This required this Affinity Plus to be a sponsor of the U of M to be able to have marks and logos in it. So there are definitely ones where there are marks and logos and ones where there aren't marks and logos. Here's another example. This is an early one for us. So Big Ten Network just happened to capture this split moment. Mohamed Ibrahim is a tremendous running back for us for a long time. Just happened to catch on the sideline that after a touchdown, he didn't just do this after touchdowns, but his energy chew of choice during a game was Gushers, right? The fruit snacks. So it just happened to catch this, and really good picture of Gushers. This clip ended up going viral. It was on ESPN. They tweeted that out, and it ended up getting a couple million views within 24 hours. Well, Gushers happens to be owned by General Mills, which is a Twin Cities based company, and that turned into a quick deal. Now, he didn't make enough money to not go to the NFL the next year, but it was enough to put a little money in his pocket for the weekend, and we ended up with Mo Gushers, which the 24 Mo pack. These were very hard to find, by the way. They had it in like one store, but I'll take it. All right. So then that with the corporate pieces, that's been a big part of it. But the main thing that NIL is right now, especially at institutions the size of Minnesota, the main thing is collectives. This was an early Sports Illustrated cover where collectives, they're saying we're a necessary evil, we exist because we have to exist, because the universities aren't able to do this stuff directly. So the number of collectives have just completely exploded in the last 2 years. You went from those first kind of 6 that I showed you were some of the first ones, the Gator Collective, Horns with Heart, Spire Group. Those were there. They were very laser focused on maybe on a position or a single sport. And once all of the schools like Minnesota figured out, oh shoot, we need one of these, otherwise we are really, really going to get left behind, there's just been an explosion in the number of them. There's now over 200 registered collectives in the country. They operate in all sorts of different ways, but really they're always dedicated to one institution. It's not just big schools. You have smaller Division I schools and you have Division II schools that also have collectives at this point. Really, the definition of the loose definition of a collective is a group of donors or fans who have kind of organized themselves around the common goal of providing NIL opportunities for student athletes at a specific school. Some of them have been launched as registered nonprofits. We'll talk about that a little bit more in just a second. Many of them have registered themselves as LLCs, as corporate entities. None of them are run by universities because under NCAA rules today, you can't do that. So Dinkytown Athletes, which you heard Melissa talk about several times, is the University of Minnesota's, it's the official collective of the University of Minnesota. That's actually a paid designation. They have to pay the going rate, just like Affinity Plus has to pay to be the proud sponsor of Golden Gopher Athletics and use our marks. So does Dinkytown Athletes under NCAA rules. They were established in fall of 22. And they really are organized around 3 things: providing NIL opportunities for student athletes, whether that means negotiating them and working through them for student athletes, or if there's not enough of them there to recruit and retain the best, they have to find a way to create those opportunities. They do have a membership program where a lot of what they do with student athletes, when I say that Dinkytown is manufacturing NIL opportunities that maybe aren't there from a commercial company, the nice thing is, as a commercial company, Dinkytown Athletes, they can pay student athletes directly to promote Dinkytown Athletes, right? And that's perfectly legal under NCAA rules. So they have memberships that student athletes are able to fulfill obligations for. And then lastly is really these corporate sponsorships, corporate deals like what you heard Melissa describe. Really the membership donations and sponsorships are the key to kind of long-term stability here in the amount that they're going to have long-term stability. So there's 4 main branches of their business that are all intended to work together. First one is really kind of donations. That's memberships, and then donors can sign up as well. A big question that we get from donors is, well, I don't have a business, so how is it that I can contribute in some way? How can I provide NIL opportunities in some way? And that is what a collective helps to do. They provide that vehicle for delivering NIL opportunities in a compliant way under NCAA rules, and also helps to protect student athletes in the deals that they do. They've worked with Taran many times over the years, last couple of years, to help to provide opportunities and make sure that their contracts and that they're not putting the student athlete in any sort of situation where they're being taken advantage of, or it ends up being hopefully not a bad deal for them financially. There we go. Next one they do is work with businesses. Obviously here they kind of act as a talent agency. The reason why you would want to do that It allows a business, if Dinkytown Athletes did not exist to represent those student athletes, you worked with 4, right? So that would have required Melissa to go in to something like a marketplace or somewhere else where student athletes have listed themselves, make contact with 4 separate student athletes, make the deal, negotiate the deal with 4 separate student athletes, and then in the end, pay 4 separate student athletes. That's a pretty big barrier, I can tell you, to businesses wanting to operate in this world. They do not want to do that individual back and forth. First of all, if you can get a student athlete to respond to an email within a month, you are way ahead of time, right? Don't use email. You can get them through TikTok maybe, do a direct message through Instagram, then you got a shot. But email, not happening. So, this is a way where a business can just work with one point of contact who can go and help arrange the deal. So, kind of the last 2 sections here, working with supporters, they do a lot of this with the donors and the members to make sure that those activities are there for student athletes. And then the last way that Dinkytown brings in money is through passive income with businesses. Those are things like you may have seen, they have a partnership with Grey Duck, who manufactures a beer that supports Dinkytown athletes. Now, student athletes aren't allowed to promote the alcohol, but Dinkytown Athletes as an entity is able to promote it, and they get a share of proceeds. That helps to fund some of the activities that they do and some of the contracts and things that they're able to offer student athletes. So looking at the future with NIL before we wrap it up and get to the Q&A portion here. So before the Virginia and Tennessee injunction that I talked about a little bit ago, collectives technically weren't allowed to do anything during the recruiting process. They weren't even allowed to talk to recruits, let alone proactively reach out to them. Because of that injunction, that restriction completely went away, and they can do pretty much anything. I can tell you for a fact that members of our men's basketball team in February, while our season was going on, were getting contract offers sent to them by collectives associated with other schools, saying if you transfer to our school next year, this is the amount that you will get paid, okay? Now, previously under NCAA rules, if a student athlete was not in the transfer portal, the other school wasn't allowed to contact them in any way, shape, or form. And by extension, the collective was not able to contact them in any way, shape, or form. The ruling came in February. The first contract offers came in February, okay? They probably came before that. They just didn't tell us about them because it was against the rules. But, now they can really do whatever. And being able to transfer multiple times, that has really pushed pushed the balance sheet of a collective where they need to have a lot more money to be able to retain first and foremost, and then also recruit student athletes to their programs. So our biggest challenges now are the tampering piece, right? It would be pretty hard to focus on the season if I'm focused about what I'm playing, where I'm playing next year, how much money I'm going to make next year, what's my offer going to be. We need to stabilize the market. When we are trying to figure out, working with the collective to try and figure out how much money our team will need for next year. We can't flip into the Sears catalog and know how much a certain player is going to cost. It takes what it takes, right? And more importantly, if you buy something out of the Sears catalog, another customer can't call Sears and say, hey, that thing you sold to that company, I'll pay you twice as much for it. And then Sears comes to your house and takes it, and then they transfer to another school. The last piece is really, also university involvement, right? We have to be at an arm's length right now. My phrase is, we have to keep them at an arm's length, our collective, but they still need to be within reach, right? Because we have to be able to work really, really closely with them to make sure that we are, we are having the teams that we need to be competitive. So what is coming? What is going to do that? So legal cases are one. The House Oliver case, that's probably one. If you haven't seen it in the news very recently, keep watching the news, especially next week. May or may not have news coming out. You can come back to me next week, let me know if I lied to you. So there, you're talking about a settlement in the $2 to $3 billion range for college athletics. That's a lot of money for college athletics to come up with over a short period of time. The second piece of that you may have read about is what does a collective bargaining agreement, what does that look like moving forward? Even if the NCAA and power conferences settle the House lawsuit, which they absolutely need to do, what does that look like moving forward? What does revenue sharing look like moving forward so we get rid of that legal liability of antitrust violations? Employment. So should student athletes be employees? Should they not be employees? I would say anybody, has anybody here worked at the University of Minnesota? Okay. Try and hire somebody at the University of Minnesota. More importantly, try and fire somebody at the University of Minnesota. Employment status does not make sense from student athletes. I say that as a former student athlete. I've been a student athlete at the University of Minnesota. I've been an employee at the University of Minnesota. Student athlete is a much, much better deal. So we have to find a way essentially to pay and do revenue sharing without triggering student athlete employment status. As an example, we have 87 international student athletes. It's against the law for them to be employees. It's a violation of their student visa. So student athletes become employees, do we have to send them all home? Right? Or we can just, we can get the federal government to change immigration law. It shouldn't be a challenge at all. So kind of the last two, right? So state laws have continued to push it. There's a law that's passed, takes effect July 1 in Virginia that says a school is allowed to directly compensate a student athlete for their name, image, and likeness. That July 1 deadline is looming. The NCAA is either going to have to sue to stop it, which is unlikely, or they're going to have to find a way to capitulate there. Some sort of federal resolution is, I guess, possible. It would require Democrats and Republicans to come together to pass that bill. The only thing the Democrats and Republicans agree on is that they hate the NCAA, so I don't know that those protections are going to come. Without that, I don't know where the resolution comes. With those issues, a legal settlement in the House case is probably only the first step to actually solving this issue. The next steps are, that we need to be concerned about and that are going to be a challenge to us are, number one, just got to remember what order I got them in here. Yep. So employment status is one. What about Title IX, right? If we're talking about revenue sharing, who knows what percentage of revenue is attributed to our football program? So overall, $150 million budget next year, close to that for the University of Minnesota. What percentage of that revenue is attributed to football? Guesses? 60? 90%. 90% of our budget comes from television, football, and ticket sales, right? That's also the separation between programs. The top 20 budgets in Division I, all of the schools on that list, Minnesota's not in there, but all of the schools on that list have two things in common. They have a football stadium that seats 70,000 or more, and they sell it out. That's the difference, right? So, when we're talking about applying Title IX, does it have to be, if there's a revenue sharing deal, does it have to be equal pay going to both places? If I'm a football student athlete responsible for 90% of the revenue coming into the athletic department and I'm getting 50% or less, that might be a challenge, right? So salary caps, right? How do we make sure that everybody has access to the same resources? That's another question that we're dealing with, right? There is still, even in the Big Ten, there's a huge revenue gap, right? Ohio State makes more money off of one home football game than the University of Minnesota makes the entire year off of football games, right? Between parking revenue, ticket revenue, concessions, one football game, they have 7 of them, we have 7 of them too. It takes us all 7 to make up the revenue that they do in one, right? So how do we make sure that there is some sort of evenness across programs so we have equal access to talent in some way to keep our product, which ultimately is entertainment, right? Keep that product competitive. That's something that we're gonna have to work through. It's not going to happen without federal government intervention or collective bargaining, which has its own set of challenges. So with that, appreciate your time. I have the pleasure of inviting up my former teammate here, Ben Utek. Got to make an entrance, man, through the doors. There we go, all right. So 4 of us are going to be up here, and I think you're going to give Ben a chance to introduce himself and then fire some questions at us.
So come on up, Ben, and we'll give you the mic, and you can introduce yourself. Nice to see you. So the procedure we're going to do is Ben's going to introduce himself, and these 2 guys are going to get reacquainted, played together, I think, right? And then we're going to do Q&A. And Jeremiah assures me we've never had enough time for Q&A. And even if we don't have questions from the audience, I've been working on this for 3 days, so I got questions coming out my ears here. So anyway, and then we're going to eat while this is going on, so that's why you're being served. Have at it. Here you go, sir.
All right. Well, good afternoon. How are y'all doing? Good? Great. Hungry? All right. Excited to be a part of this panel. First and foremost, I am not a subject matter expert on NIL. I am a subject matter expert on organizational culture and leadership, and that's really where my career has gone over the last 13 years since retiring from the NFL. Born and raised in Hastings, Minnesota. We've got some Hastings representatives. I saw my good friend Mr. Sieben in the back. So it's good to see some familiar faces. Very fortunate and blessed to play tight end at the University of Minnesota, go on to an NFL career. Again, blessed to be on a Super Bowl championship team in Indianapolis with the Colts and Tony Dungy and Peyton Manning and I think 5 other Hall of Fame players that have been a part of that program. And then my career transitioned into actually the area of HR. I became very passionate coming out of the Tony Dungy camp of servant leadership and being able to bring that leadership style into businesses. And so over the last 10 years, I've really dedicated my life towards helping companies build successful, healthy organizational culture and leadership development programming, which I do think is connected to NIL and what's happening and how the game is changing. So excited to be here and answer any questions that you have.
And I'm going to move around with the mics. Got questions so everybody can hear them. And Greg, we can hear if we got the mics, right? All right.
I have 2 questions. One is for me and one is for my 15-year-old. I'll take mine first. I didn't hear any information about the NIL exchange. If you could just explain that a little bit more. It's on the website, but...
So the NIL marketplace, the Minnesota marketplace, is essentially it's a spot that student athletes are able to have themselves on the website there. And it allows for secure transactions for either businesses or individuals. So you can sign up for an account as an individual or a business. And if you don't want to use Dinkytown athletes or you don't want to try and get a student athlete to email you back or whatever it may be, it's kind of just a centralized place for businesses or individuals to find University of Minnesota student athletes and enter into NIL deals.
Okay, thank you. Then the 15-year-old question was, did the Dinkytown Athletics have enough money to keep Farrell Payne, or was he going to leave no matter what?
Does taking the fifth apply? I don't know. Again, I'm a fake lawyer. I guess I'll give you a different example, right? A year ago, the Vikings moved on from Dalvin Cook, right? Because Dalvin Cook was a really expensive running back who they felt did not fit into their overall strategy of their salary cap and the amount of money they have. While the NCAA rules don't have a salary cap, Dinkytown Athletes has a natural salary cap of how much they have available, right? And so at a certain point, you need to make a decision, how will our team be best served for the following year? Is it going to be paying a specific individual the amount they are looking for, or maybe we can pay 2 or 3 individuals, with the same amount of money that we would that we'd give to one. Non-answer answer for you.
Joe, got one? But before you get to that, follow up on Farrell Payne. So does anybody sit down with these kids and say, look, Farrell, you played every minute you could have last year unless you're in foul trouble, which you usually were. Where do you think you're going to go and get more minutes, regardless of the money? How much money can there be for him? So 2 questions on that.
Okay. You promised you would not ask any hard questions. I think I should have got that in contract, get Taryn to review it. Yeah. So student athletes transfer for lots and lots of reasons. Students transfer for lots and lots of reasons. Playing time can be one of them, but I want to be completely honest with when we talk about this. The finances in the amounts in men's basketball and in football have gotten to the point where it is not. A pet peeve of mine is people talking about loyalty. Right? There's no loyalty anymore with student athletes. If somebody offered you 2 to 3 times the amount of money you are making today to do the same exact job somewhere else, I don't know. Raise your hand if you would say no, thank you. Right? I'm loyal. Okay. Do you own your own business? Is that the? Yeah. Okay. I've seen that trick before. Yeah. It just. I mean, the money has gotten to the point. NIL is absolutely a reason why student athletes choose to transfer. Playing time is absolutely a reason why student athletes choose to transfer. A combination of both of them are reasons that student athletes choose to transfer. But. Most of our sports, especially football and basketball, they are games of genetic outliers. Stand up, Ben. Okay. Ben and I are 6'6", 6'7", maybe? Okay, you might have me by a quarter inch. Okay. Statistically, we are taller than 99% of the people on planet Earth. That is a fact, right? You are not going to be able to go find many people that are like this, right? Farrell Payne is this tall, and he can run without falling over. There are not that many people that can do that, especially not ages 18 to 22, right? So money follows, money follows the market.
And we all got to see Randy Brewer learn not to fall over if we're Gopher fans. That wasn't my question. My question is actually a follow-up on that, I guess. Basically, right now, student athletes are all free agents with the NIL plus the open transfer, right? So we've got a crisis here because we all hate to see students just disappearing, entire teams just disappearing. There's no consistency. This isn't the first time this has happened, though. Every professional sport had free agent crises that they solved in a bunch of ways. Is there any, I assume people are thinking about this, is there any framework whereby contract or otherwise can be used to lock athletes in place or to provide them a good living kind of based on how they did in high school, I guess?
Yeah, I think that's a great question. And if you look at it from a professional sports aspect, those were antitrust violations as well that they had to then deal with. And so it's almost a reverse thing where they were struck down in court and then they collectively bargained something. And a union or any sort of collective bargaining unit can collectively bargain those rights away and avoid the antitrust violations. But in this case, that hasn't happened yet, but it still could. And Jeremiah brings up those settlement discussions. I think that's the first step because you deal with a lot of the retroactive things. And whether they're able to get a court to actually say in the settlement agreement, going forward, we're going to give safe harbor or recognize things to work a certain way, that remains to be seen. I would be interested to see what happens with that. But I think that it is possible, and I think that it's likely, because the current system is untenable. To hit up a mom and pop business owner and say that you have to pay the salaries of the players directly is untenable, in my opinion. And I think that eventually we'll get to a point where the revenue sharing allows for those TV dollars to be shared with the players whose labor is creating it.
I will say too that this starts to touch into the culture of NIL, okay? And the reality is in business, everything is driven by profit. One of the rules of organizational culture is you will always have a culture by design or default, period. You will always have a culture by design or default. If that's true, and if we can all accept that as truth, then why not design it? But the challenge is, especially in certain industries, like financial services, for example. I spend a lot of time in financial services, and they really struggle with developing culture because it's an industry driven by profit and driven by transaction. And the first thing to always compete against profit is people. And so within that kind of touches into your question, which is really leading into the care and the wellness of the athlete. Right, and so that's one of the things that I hope to see as NIL continues to grow is they're going to face this tension that exists between building a new industry and collectives. The reason why so many collectives all of a sudden were produced is because of money. Right, this is a very profitable platform, and so whenever you have a platform that's driven by profit, the people will always suffer. And so my hope in where I hope NIL goes is that they begin to really bring in that theme around the student-athlete wellness. How are we going to come alongside these kids and actually morally and ethically prepare them for the amount of success that they can have now that Jeremiah and I never had access to? Right, because I can tell you with the little money that I had, what I was spending on the weekends. Right? I mean, it's just a reality. And books, that's right, books. But there's a lot, man, and there's layers upon layers and layers in that. But we do have to consider, the culture of NIL and how are we, what do we believe about it? Why do we believe it? And how are we going to practice it in a way that puts the person first? Celebrates the profit, applies the profit, but thinking through all of the different unique strategies that are connected to developing great people for the future who have to enter the real world. And I can tell you, for guys like us, I mean, thankfully you knew where you wanted to go, and I kind of knew where I wanted to go, but being on the Mackey White Player Health and Safety Committee for the NFL Players Association, can you believe it's still true today that 70% of NFL players are bankrupt within 2 years after retirement? How is that possible? Wow. And now we're flooding the high schools and colleges with new profit potential, which I'm not against, but it's just a reality, and it's something that we should thoughtfully think through so that we're creating a culture that's sending these kids off to be successful human beings in the future.
I've got a two-part question. The first is directed to the genetic outliers in the room. I'd like for you to talk a little bit about and maybe reflect on what your student-athlete experience would have been like had NIL existed when you were both athletes. And second, I'd like to hear a little bit about what can be done to protect those kind of predatory click-through agreements that you mentioned as well, where they're snaring NIL deals basically without people being aware of them from a student's perspective.
You want to talk about what it would have been like for you?
Sure. You know, my first reaction when NIL started to be practiced was, shoot, I played in the wrong decade. I played in the wrong decade. You know, had a really strong career in Minnesota. My jersey was one of the handful of jersey numbers that were sold. And as a professional speaker, even in college, I was professionally speaking, but I couldn't make money for that, right? So, you know, my abilities as a communicator, my abilities as a brand ambassador would have set me up in a very significant way. And I would have really appreciated that, which is why I think we should make NIL alumni collectives. Is that happening?
Ben, you're allowed to do anything you want to.
No, yeah. But you know, I do think, you know, I do think that, you know, looking back, it would have been a positive. But at the same time, knowing my maturity level at that time, I know it would have been a challenge for me too, right? No understanding of asset wealth management, no relationships with financial advisors. Didn't grow up in a family that were business people. My dad was a pastor, right? So, you know, I would have had really no support system for how to handle that type of wealth at a young age. And so, you know, it's that tension. But I would have appreciated it. But at the same time, it would have created new challenges in my life that I would have had to overcome.
Ben and I had very different experiences at least coming into the university. Highly touted wide receiver, all state, all metro, all everything. I was a walk-on offensive lineman from St. Paul that was just happy that they let me have a helmet and a locker, and I got to show up every day without them locking the door. It was amazing. So I wouldn't have had NIL opportunities to start, for sure. Now, you know, I got to the point where I stuck it out and ended up, you know, being an all-conference player in the Big Ten and
earned a full scholarship.
Yes, eventually, yeah, I got there. Yeah, but you know, now we're at the point with everything with NIL. The challenge is separating somebody profiting from their name, image, and likeness from, you know, the grassroots NIL, from most of what is happening now, which is just weak rules that allow a workaround, you know, around the rules of pay for play. And I don't have a problem with it at all, because that allows, you know, one amazing thing that we saw in the last cycle is offensive linemen were very, very expensive because there just aren't that many good offensive linemen. And so we have, you know, the University of Minnesota has the top ranked returning offensive lineman by Pro Football Focus numbers. That was very expensive because it's really important and there aren't that many left tackles out there. So first half of my career would not have mattered. Second half, maybe. So second part of your question was predatory. Yeah. You want to answer?
Yeah, it's something that we've definitely been focused on. It is difficult, I think, to get a lot of these kids to, you know, send their contracts in, and that's one thing that has been a challenge to us to build this pipeline. Honestly, a lot of our best student-athlete clients are parent-driven, really well-meaning parents who are trying to use the system for really what I think is a major benefit of it is to give that experience managing money, to give that experience reading contracts and understanding what exactly you're signing. And so some of our best student-athlete clients have been driven by that. But otherwise, I think that it's so easy. Somebody hops in your DMs and they're like, hey, I'm going to give you $500 next week if you just sign this. Or even just don't sign anything. And you know, maybe they don't know what the implications of that are. There's a lot of that. Another thing that I'm particularly concerned with is the rise of, because there's no sort of certification body for the so-called agents. And there are a lot of kids who are fresh out of college who fancy themselves to be marketing agents, and they're going to get these kids in trouble because they don't know what they're doing. And so that's one thing that I've been concerned about more so in the last 12 months.
Only other thing I'll chime in there. So just with agents particularly, we've seen biggest hurdle we've had is actually getting student athletes to use the services that are free to them in a timely fashion, right? So we had one student athlete who sent me an agent agreement and said, "Hey, you had talked about that law school group that'll look at contracts a while ago. Can you get me in contact with them so they can look over this agent agreement?" I said, "Sure thing." I opened the agent agreement and the kid's already signed it, right? I'm like, "Hey, the time to do that was, have you already sent this back to them?" Yeah. Okay, it's too late, other than not using them, but quote unquote agents taking 20% of collective of a deal that a student athlete's got with a collective. Agent had nothing to do with that deal, and they're taking 20% of it. Things like that, the sooner we can get that nonsense out of there, the better off we are.
Thank you all for being here. Boy, that was loud. Just, I have a nephew who's a student athlete at the U. He gets NIL money, so I'm very pro NIL. But I do imagine trying to be a coach now with NIL money and transfer portal, just how challenging it would be. And I think if I had hair, I'd be pulling it out. But I was curious, maybe Ben and you too, Jeremiah, sorry to the other two, just culturally, if you're a coach, how do you deal with these issues with these young kids to try to get them to stick around, number one? And number two, Jeremiah, I'm curious if there is any sort of coaching for the coaches on these kind of issues, because I know at least in the kid that I know, he says they just don't really talk about it. So I'm just curious about that.
Well, we do see evidence in corporate culture that when organizations truly create systems around culture to build a thriving and healthy work environment where people actually feel like their value increases, like their purpose increases, they will actually choose to stay in those organizations than take a promotion, for a certain percentage to go elsewhere. And I think that's what PJ is really trying to accomplish. And I think he's done a better job than most coaches. You've spent a lot more time with him over the last handful of years. But the thing that PJ's created is a culture, strategy, and system that has a number of practices that we don't even hear about or see on a consistent basis that are happening behind the scenes to pour into the lives of these young kids. So, his challenge is always going to be his best players, right? His challenge is always going to be the 3-star who, within 2 years, is now playing like a 5-star. And there's always going to be that tension that exists with that level of athlete. But for the majority of that team, he's created a culture that is doing very unique things. Everything from he and his wife creating an event, which is a date night where players are encouraged to go and ask a partner out on a date, and they go downtown, and the entire night is about dating. It's about the dating experience and teaching these young men, how you treat a woman. Those are things that you do not see being practiced in most football programs across the country. That's just one, right? So I think, creating a culture that pours into the value and the purpose of the player will increase their loyalty and commitment to the team, minus that top 1-2% that are always going to, have the opportunity to leave and go on.
I greatly appreciate Coach Fleck, greatly appreciate his culture. You buy yourself about 10% difference with that in terms of what you're offering. right? And not, this isn't, again, this isn't cynicism for me or anything else, but look at the difference between last offseason for our football program, 22-23, when our collective had just started, had very little money. Look at the transfers that we lost and the transfers that we brought in, okay? We, last year, lost, I think it was 8 transfers to other Power 5 programs. And we brought in 2 transfers from Power 5 programs and then a bunch of mid-major programs, right? Fast forward to this offseason, this past offseason, when, you know, Dinkytown Athletes has had their feet under them for a while, and Coach has been very intentional about fundraising and speaking about it, and they've grown several 100% in what they have available for football. Outgoing transfers, we lost 3 total to Power 5s. 2 of them are brothers that went to another Power 5 team, but whether or not they had an opportunity to stay is a different question, right? But we've brought in 9 transfers from Power 5 programs. We brought in a transfer from Clemson. We brought in a transfer from LSU. We brought in a transfer from Penn State. We brought in a transfer from Michigan State. Find me a time that that has ever happened in the history of our program, right? It makes a difference. Now, they have to want to be at Minnesota. Student athletes, first and foremost, have to want to be at Minnesota, but it makes a difference.
That's great. So Jim Kirschbaum has a question. Okay. I was going to, Rich, just a second. I've just had a couple of follow-ups because A, I have the mic, and B, I spent like 3 days coming up with really good stuff that I need to have answered.
First, when you plan the event with the mic.
For Melissa, because I'm trying to get 2 ethics credits for everybody, for this segment, did you guys consider any ethical considerations when you were deciding whether to enter into an NIL deal with the women's basketball players? Or any consideration of advertising, and do you want to do that versus not do it, that sort of thing?
I would say yes, because that is the right answer.
Good.
And you know, we trusted that going through Dinkytown was a way to ensure that everything was on the up and up, as opposed to trying to send a DM on Instagram, which George and I would both be woefully terrible at, or otherwise, you know, reach out to these athletes individually and try to form a contract, especially as attorneys felt like we had a sophistication of the legal knowledge and an upper hand on that wouldn't feel fair at all in, you know, trying to negotiate with the athletes. I felt like having all of that communication directly with Dinkytown, and then Dinkytown presents the offer to the athletes, and then the athletes either accept or reject back to Dinkytown. Having that intermediary, I thought, was really valuable.
That was a really good answer, because that covered ethics and considerations like that. Taryn, are we unique in terms of having the law clinic at the university, or do other Big Ten schools have similar setups at their law schools?
Yeah, definitely unique in the way that ours functions. I don't think that there are any other large law firms that are supporting a clinic, so we're really lucky to have that with Frederickson. But when we founded the clinic, there was really not much of a proof of concept. Louisville had one where they had partnered their business school and law school, but that necessarily wasn't us, a major metro area. So ours, I think, is very unique in a lot of different ways.
And we really need to market that, seriously, because I had no idea. I teach over there as an adjunct, and I had no idea until I talked to your colleague, Mitch Zamoff, who couldn't say enough nice things about you, and he said, hey, you need to talk to Taryn about this. And I said, who is he? And then, so anyway, we need to market that. That's a good feature to have for the student athletes, too, to have that resource.
At the time, it was, in my opinion, it was the first one in the country that operated the way that they did in a pro bono fashion.
There were even some pretty cool platforms in 2003 when I was negotiating my NFL contracts, the University of Minnesota law team came alongside my sports agency and went through all of the agreements, and that was something that was available to us as athletes through the law firm that really nobody knows about. Right. So they've been really supporting student athletes for a long time.
My next question is, and I've been posing this one hypothetically to people for like a year, if I were to get a group, or if someone was to get a group of, let's say, 25 people together, and everybody threw in $20,000, that's $500,000, could you as a group go to an individual player and try to market that person?
Could you? Yes. I would make the suggestion that the best use of that money is not necessarily to go to a specific player, but to use Dinkytown. And the reason why I say that, right, is a number of things, right? Number one, all transfer portal windows are closed right now. Nobody else is going in the portal. Our teams for next year are our teams for next year. If you take $40,000 right now, if you have a business and you're going to go to a player and say, here's $40,000 to market my business, and my business is going to be at least $40,000 better off because you've marketed my business, go do that right away. If you are going to say, here's $40,000 to make sure that you're at the University of Minnesota, I would argue that that's not a wise investment because they're already at the University of Minnesota. There are certain periods of time when that's important from a retention standpoint. But, again, there are two types of NIL. The first type, the grassroots NIL, you're paying that person because they're going to make your business better, period. Go do it. If it's the second kind of NIL, we have a robust system set up to be able to make sure that those resources are used in the best possible way.
That's what I thought. Good answer. Next question is, so let's say because when we talked at our prelim meeting answer the question of what will it take for us to have available in men's basketball to be consistently a top 20 program, based on what other schools that we would be competing against have available?
Sure. Last year it would have been one number. This year it would have been another number. Next year I'm sure it'll be another number. So, this past off season, I would say mainly because of the Tennessee and Virginia injunction change that allowed offers to be sent, significantly increased the amount of money needed. The average, I would say, across, let's call Power 5 and mid-majors, so 100, 125 basketball schools. Across that group, the average is in the neighborhood of 1.5, 1.75 million for next year. Having said that, there are absolutely schools that are doing, Arkansas publicly said they have $6 million for their men's basketball roster for next year. So,
Muss still couldn't win there,
yeah.
did he? Didn't Muss leave? He's gone, isn't he, Musselman?
What's that? Yeah, Musselman's gone,
Yeah.
and that John Calipari went from Kentucky there, and again, it takes the amount of money it takes to get a player to your school.
All right, so Lindsay has said, share the mic, Brett, share the mic. So I'm going to give it to Rich now, except on my way back, I'm going to ask this question could someone go to a player and say, look, you'll get $1 million a year for 3 years, but contractually, we want a contract to say you won't go anywhere unless it's to the NBA or the NFL or whatever, not to another school. Could you contractually bind someone to stick around for the right amount of money?
Sure. I think the challenges, one, are NCAA rules currently, because you're not allowed to do pay for play. A contract cannot be tied to an individual's participation on a team. So you can't say you're signing a contract that says you are not going to play for any other team. So a lot of attorneys here. If you can come up with a contract that contractually binds somebody to participate in a sport at an institution without writing in that they are contractually obligated to participate at that institution, let's have a cup of coffee.
Could they maybe, maybe the workaround then is if a big company comes and puts up the money, could that contract be with that company, and that company says that they have to stay within the region for? It's like putting different. I don't know.
So there have been lots of things. There have been lots of different types of contracts that have been out there. I think that Dinkytown has done a tremendous job in the way that they have managed this, because they have both been ethical and fair with their contracts to student athletes, but they've also protected themselves. And that's, I think, the biggest challenge is, the collective has an obligation as a company to make sure that the people who are providing them money are ultimately able to be satisfied with what they have done. And if they are doing things like dumping a bunch of money into a player who can just go and leave with that money, and there's no clawback and there's nothing else there, then they really haven't served their purpose for the individuals entrusting them with their money. At the same time, I'm a firm believer that if you don't treat student athletes the right way, it's going to catch up with you eventually. Might not be right away. You might have the upper hand right away, but it's going to catch up with you. So it's a tricky balance.
Yeah, the structure that I've seen be successful as it relates to keeping a student athlete at a certain school is basically by having various dates that are triggered by not being in the portal in a certain window, and then also continuing to reside within certain amount of distance from a place.
So I'll say that last thing on this. So recent contract change that, again, I think at Minnesota we have to be really innovative, which is why we had the law school early. We had something to offer them. I think Dinkytown picks up on that as well. So as an example, if a recent student athlete signed a contract that paid them a lot of money up front, and then they subsequently decided to enter the transfer portal and leave, if the contract that they signed had signed them to the exclusive use of their name, image, and likeness for 365 days in exchange for an amount of money, if that student athlete were to then go in the portal, that contract requires them to repay that amount back to the collective if they want to buy back their NIL rights. Now, does that keep that student athlete at that school? Nope. But at least you're not losing a lot of money as a collective if that student athlete decides to transfer.
Maybe this is self-evident from everything you've said, but I'm not bogged down in the details. I want to write a check for $10,000 to help the football program. Is it just as simple as writing a check to Dinkytown athletes for 10 grand and saying use this for football?
www.dinkytownathletes.com. So put in your credit card. You put football down in the bottom.
That's all you got to do.
That's all you got to do.
Okay, is that tax deductible?
What's that?
Is that tax deductible?
So they are not a 501c3. Okay. So one challenge with the collective world, so a lot of collectives started off as 501c3s. The folks at Dinkytown looked at it and talked to us and said, hey, collecting money to make it tax deductible as a 501c3 and then just turning it around to paying people to go do charitable work doesn't seem like it's the right thing to do. So we're not going to do it ethically, right? Like that doesn't seem like the right thing to do, so they didn't do it. In May of last year, the IRS published a 12-page memo that said, hey, we see these things called collectives that are registered as 501c3s, and they are not fulfilling their charitable mission. So significant cooling on collectives being 501c3s since then.
And then the follow-up question is, can you make a donation and ask that it be directed to retaining or recruiting a specific player by Dinkytown athletes?
Yes.
So I could have spent money to persuade Logan Cooley.
Info at dinkytownathletes.com.
So if I'd done that last year, maybe Logan Cooley wouldn't have signed to go play before 5,000 people at Mullet Arena instead of 11,000 at Mariucci.
Sure, you're only competing with an NHL team there. You've got the
I don't know
money.
what your checkbook looks like. It wasn't like Logan Cooley, the very first hockey player at the University of Minnesota to sign an NIL contract, lasted 3 months and then he left. So that's something.
Rich is a really good defense attorney. His checkbook is limitless.
What was that website again?
Anyone?
So my question is directed to Melissa. Can you explain more about how you entered into the transaction, how you got the 4 women's basketball players that you got? Was there some methodology, and we want Minnesota growing athletes who want to stay in Minnesota and who will, continue their career at Minnesota? And what other stipulations are part of the, NIL deal that you constructed?
Yeah, good question, Sean. So as I mentioned earlier, it started out by just reaching out and saying we wanted female athletes. We were targeting volleyball and basketball because those were the sports that my partner and I had attended for years. The initial reaction was that none were pre-law or interested in the law as of now, mostly because they hadn't declared majors yet. And so then we just kind of looked at the rosters and weighed some of our options, and immediately these 4 local women on the women's basketball team just popped out as a natural fit because of the local ties. We wanted, part of this goes back to Brett's question too of, the ethical considerations. And we wanted to be reasonable, and we wanted to provide benefit to these athletes in a way that was meaningful to them. And also, obviously, make a good business decision for our law firm. And so there were lots of frank conversations with Derek at Dinkytown of, this is what we're thinking. Is that reasonable? We'd like them to come to our parties and talk with other lawyers and judges and clients and such. Is that reasonable? We didn't want to put the athletes in a position where they were uncomfortable or they were doing something that, was going to be just a huge drag for them. We realized we were asking something different than taking a picture and putting it on Instagram. And so we had a lot of those questions. For Derek, he was great. He gave us a lot of good feedback. And really, I don't know what happened on the back end. All of our communication with Derek was either on the phone or over email, and then he was going back to the athletes in whatever way that happens at the university. And they've been great. We wanted to meet them before we brought them to a firm event and meet everybody else. And so we said, tell us where you want to go out to dinner, and we'll take you out to dinner. And they wanted to go to Bar La Grassa downtown. So we had an awesome dinner at Bar La Grassa, and everybody's reading the menu and trying to figure out what all this food means. And it was a great introduction to them in that way, that we just kind of got to see how they were as people and athletes, and we were hooked from that moment on.
You can hold on to the microphone because this one's for the 2 lawyers, and not surprisingly, it's an ethics question. I noticed that one of the slides mentioned that the services to the athletes will be pro bono after financial qualification or something to that. My question is, can you tell us, can you explain the the ethical ramifications of making a decision on pro bono or a paying student? I assume some of the students, if they're millionaires, have to pay, or their parents are rich, they have to pay. What kind of procedure do you go through for that, accepting a student as pro bono or paying?
Yeah, so it's based off of just the federal poverty limits, whether they're going to qualify or not. And generally, a student athlete is not, especially if they're seeking out our services, they're not going to be above that limit. So we've not had many student athletes who are paying clients. Our paying clients are generally going to be brands in this space or collectives.
But don't all your students, after you do your work, don't they go way above the poverty limit?
That's right. Just because of our work, they're all millionaires.
Our deal wasn't putting anyone over the poverty limit, so there's a whole range.
The deals that you read about, the numbers that you read about, are the very, very top of the market. You know, the majority of NIL deals. Nationally, I would say the majority of NIL deals are probably more trade, free food, free gear, than they are actual money. Some of the collective deals, yeah, those start to get up a lot higher, but usually those are not necessarily, it's the collective working with them on the back end.
Generally, when you're at that level too, you're going to have an agent and an attorney and other people that are really invested in making sure that everything is tick and tied. And for us, it's really more like athletes that are doing deals with local institutions or entering into marketing services agreements where it's not a big deal up front. It's the possibility that they might find you some money.
Are NIL contracts, are they public? Is there a place you can go to, for instance, see how much Melissa has paid into the Dinkytown for their contribution? And the other question that I've asked a number of people, but never really get a satisfactory answer, is there any limit to the amount either a player can accept or a donor can give? Any monetary limit to that?
Sorry, that was on the donor part, no limit.
Yeah, there's no database of contracts. When we've reviewed contracts, it's either come from the client or we've reviewed some contracts as part of like a survey exercise for a client. But otherwise, there's not like a database where you can look. And that's something that's been proposed in a lot of these discussions that are going on, but there's nothing like that exists right now. But Melissa gave them $14 million each.
That's why they all came back. Thank you. So the University of Minnesota, our NIL policy, we require a student athlete to submit some basic information regarding their deal. That is not public data with names and sports attached because it's considered protected data. The contracts that they sign with Dinkytown are a deal between a private individual, a private citizen, and a company. Starting August 1st, the NCAA is going to require student athletes to submit all deals to their institution that are over $600. And the institution is then 2-3 times a year is going to be required to submit anonymized data to the NCAA. You know, I personally, it's none of our business, but that's where we're at. So there's no, theoretically, is there a limit to how much a student athlete could make? Sure. I mean, you know, at a certain point, they're supposed to be doing work. So it's hard to say, you know, $5 million is, you know, if you have a shoe contract bigger than LeBron and you're not getting shoes, right? Like you're not selling shoes. That would probably raise some questions, but there's no limit on what a student athlete can get or what a donor can give.
Somebody had a question, Melissa. Tell us some of the things your student athletes do with you or with your firm that you've found to be beneficial.
They have agreed as part of our deal that we can use their photos. And one thing I didn't appreciate until we entered into this deal was the logo, the Black M, the use of the term gophers requires then to loop in the university. And so you in the photos that we have up here, nobody's wearing a gopher sweatshirt. No, we don't, in our publications, we didn't advertise. We cleared that language through Dinkytown, who then I think cleared it through the university to make sure, to make sure that we weren't violating any of those rules. So they have agreed to be, that we can use these photos, we can put them on LinkedIn, we can put them on our website, we can email them out to clients, and et cetera. They agreed to come to an event and come to that party with us. And there was a third component
Did
that
you do
I'm
a
just
post-game
blanking on.
meet
Yes,
and greet?
thank
Yeah.
you. Yeah, we then worked jointly with the university and Dinkytown, where the firm bought a suite at women's basketball game. So that was all through the university. And so we had a suite and we had food and we invited clients and friends and colleagues to come to the game with us. And so that we worked directly through the university with. And then we had an opportunity to meet with the athletes after the game.
One other question from the back of the room was, are we happy with Dinkytown athletes as our, what do we call them again, our collective? And are they paid through the transactions, or how does that work?
I will say I was very happy with my transaction with Dinkytown, and they presented it to us for payment that we could either pay the Dinkytown fees on top of the amount that we had reached with the athletes, such that our entire commitment went to the athletes and then we paid the fees separately, or Dinkytown could take their fees out of the amount that we had reached, thus giving the athletes a little bit less. We opted to pay the fees separately, so the money that we had presented to the athletes actually went to the athletes, and then we paid their fees separately. It wasn't a huge amount.
But that's, what you're paying for there is all of the things she described, where she was going back and forth with Derek, trying to get get it arranged, make the request, do all of those things. All of that communication is what the fees go to. They have done a tremendous job with, there are. If you want to make a lot of money running a collective, you have to start. If you want to make a little money, screw that one up. If you want to make a little money running a collective, you have to start with a lot of money and work your way down, because you're not making money otherwise, right? Because any profit that goes out of there, if you take profit out, that's not going to student athletes. So they have worked tremendously hard to keep fees and costs really, really low, so that they can continue to operate and really do something that, frankly, the university can't do. And if fans wanted to do it individually, it would be a completely different place.
So, Ben, I wanted to ask you a question because back of the room kind of wants to know, you must feel like, darn, I missed out on a lot here, basically. And this, kind of the second part of that is, I don't think we ever did it at Minnesota, at least not that I can tell, but how's this different than back in the day when we heard all these stories about paying players, buying players, cash, money, cars, the whole package? So, and I don't think anyone ever approached you with that stuff, Ben, coming out of Hastings, but maybe they did back in the day.
No, I never experienced any of the under the table stuff. But maybe there was some I don't know. Let's not talk about that.
Not for offensive linemen.
Yeah. It's a really good question. Honestly, I've been very blessed. So I don't look back on my college career and have too much frustration about not being a part of something like this. And a lot of that had to do more with the incredible life lessons that I learned as a young man, what it meant to work really hard, to achieve my goals, and to follow a process that was really kind of developed by our academic institutions and our corporate workplaces. And the process that we all go through as humans in this journey of finding our identity. Middle school, high school, college, enter the workforce, right? That's something that's going to be continued on and on. And I really believe that the foundation of that, if we're not careful, can be at risk with a platform like this, which is why you have to bring the right culture into this that puts the people first. You know, when I walked into Interlachen today, and I walked through the doors, I was confronted by a plaque, and the plaque had a name, Bobby Jones. Some might argue the greatest golfer of all time. Bobby Jones was a lawyer, a very successful lawyer. He's also the one that eloquently defined amateurism as to play for the love of the game. Does that have any meaning to anybody in the room? It's not tied into contracts, and it's not tied into the wonderful things that are happening to sport kids, but it's something to talk about, right? It's something to actually lean into a little bit. Because you cannot control the ripple effects of human behavior. You throw a pebble in and it hits another ripple, and you can't control that, right? So the results of what certain student athletes do with the deals and the money they get will be yet to be seen. We'll learn from that, and hopefully, you know, it'll continue to grow and put systems in place to protect the kids. But there is something really powerful in that we have to consider, because to be an amateur doesn't exist anymore. And we can't really understand what the ripple effects of that will be over time. And it might be positive, we don't know. But I do think it's something that's connected to the answer to that question for my personal life is, you know, growing up in sports and never, at least through middle school, high school, and college, ever making a cent because of, makes me really appreciate what I was able to achieve in the NFL. And there was a lot of lessons that I learned in that process of having to grind in order to get to that end result, right? It's like I have 4 daughters. We started giving our daughters allowance. And we began to realize that new levels of entitlement were entering the UTEC household. And so we said, well, maybe we should change this, and we should actually apply a practice to the money. And so now they get an allowance, but they have to check off a priority list what chores they have to do or what they have to accomplish, because that's an important lesson to learn, right? So how do we continue having that conversation along with supporting the wonderful things that are happening, you know, through the collectives, in order to not only support the student athletes financially, but also support their development as human beings, so when they enter the workplace, they can thrive and build families or whatever it is that they're pursuing.
Mr. Utek, I swear this is not a question fed to me by Brett, but what lessons have you learned as a student athlete and then eventually a professional athlete that you employ in your business development and organizational leadership talks? And the shameless part of this question is that your Super Bowl ring, and can I
Yes.
touch it?
Yes, you could. Yes, absolutely. Get to wear it for fun events like this, because we don't have one in Minnesota. We don't have one yet in Minnesota, but we will. Maybe, we'll see. Man, that's a long list. That's a long list. I think one of the biggest differences that I try to bring into companies is the power of practice, right? The average NFL game consists of 65 to 75 plays on average. Each play, on average, is around 5.5 seconds. So if you're a starter and you never leave the field on an NFL platform, you only play somewhere between 5 and 6 minutes of actual football. Do you ever stop to think about that when you're watching a 3-hour NFL production, right? That's the amount of actual time that you're performing on a field. But as I did the math and looked back over our Colts practice schedules, we would spend upwards of 16 to 18 hours a week practicing on the field. And the reason why that's so powerful is because we love these games. We love watching these athletes because they are the best, right? They're the top 10% of high school that make it to any divisional level of college. They're the top 1% that make it from a Division I level to a professional level in any given sport. And it's so much fun, it's so engaging, but it's only because they spend the entirety of their career practicing. And in business, that's flipped upside down. We perform 98% of the time, and maybe we get 2% of practice into some of the culture and human development sides of what can actually make us thrive. So that's probably been one of the things I've taken the most out of transitioning from high school to college. And then how do we bring the practicing of chosen culture and leadership development into the workplace, so that we can continue to help people reach their potential, right? And that's been something that's been meaningful. Thank you.
Can I ask a question?
Yes.
But I have a question. Ben, you mentioning playing for the love of the game sparked this question. Has anybody looked at what NIL is doing in Division III? Where there are no scholarships and student athletes really are playing for the love of the game. And, as a former D3 athlete, we were playing at that level because we couldn't get paid. We weren't good enough to get paid to play at Division I or II. But are there NIL deals at D3 schools? I know that Carleton has a collective. I read that when I was, poking around on this. And what's that look like at that level?
Yeah, that's a great question. So I guess, not surprisingly, similar to Division I, there's really two types of NIL, right? So as a Division III student athlete, if you have 1 million followers on Instagram, yeah, you absolutely have NIL opportunities, right? Just like if you're a student at whatever Division III institution with 1 million followers. There are people that want to access that segment. Our first year of NIL, we had no collective, so 21-22, we had no collective whatsoever. We were not involved in arranging NIL deals in any way, and that just kind of left open natural NIL, right? And we are a place that has big time football, big time men's and women's basketball, big time men's and women's ice hockey. The #1 overall student athlete that year in terms of the number of NIL deals was a men's cross country student athlete. He had like 25,000 followers on Instagram, but the running community followed him very, very closely. And so you had brands say, I want to access that group. And so he was very good at marketing himself. So that was the #1 overall. There are those that have a collective are really in a place where the collective is being used to work around NCAA rules on scholarship limits, and whereas at the Division I level, sometimes collectives are being used to work around the pay-for-play restrictions. Division III level, it's working around the scholarship limits. Doesn't matter what level you play at. Division I, Division II, Division III, intramurals. If there is a way to gain a competitive advantage in some way in a competition, somebody is going to try and find a way to do it. And so it doesn't, it extends to all levels.
Well, we got to wrap it up because you're right, Jeremiah. I could keep going. I've got a half a page left. So and I took the mic away from all these folks too because that's the way I am. So I'd really like to thank you guys for all participating in this. It was really good, I thought. And Lindsay, your firm's going to do something with Cody Lindenberg, the linebacker from Anoka, right? Yep, because she's from Anoka. So I put that on the things to do list, right? I think what we can do as a group to help out is to do things like Melissa, right, Jeremiah? To step up and work a deal. What's the downside?
The only other thing I would say is, you've now had like an in-depth lesson and you understand generally how it works. 90% of even the fans out there do not have this level of information. We can't sit down in a room with everybody and do this. So I would just encourage you as you're out and about, if you think this is a good thing and you want to see the University of Minnesota be successful athletically, be an advocate for us out there, because right now, and even if we get to a point where revenue sharing's in or something else, like we're going to need community support. That's the biggest gap in collectives that have a lot of money, and a $6 million basketball collective and a $1 million basketball collective is community support. And if people think it's a bad thing, if people say it's ruining the game, and we have to fight against that narrative if we want to continue to have success.
You are the ambassadors, and you can either get mad or you can jump on board and be part of the solution. We definitely want to go back to the Final Four in men's basketball or women's. That would be great. We had a great run when Lindsay Whalen and that group played, so let's do it again. We want to go to the Rose Bowl. We want to play in the Rose Bowl, not against USC in a conference game, but in the Rose Bowl. So
Ben and I's coach was a guy by the name of Glenn Mason, and Glenn had a lot of good one-liners, but his best one was Jimmy's and Joe's matter more than X's and O's. You'd be the best coach on earth. If you don't have the players to compete, you're not going to compete. There's a tremendous opportunity for the University of Minnesota. I've said this before, but the last 50 years, 0 conference championships in football, men's basketball, and we've never won in women's basketball. NIL has turned college athletics and recruiting on its head. If we want the status quo, I don't know why. It hasn't been particularly good to us in those. This is an opportunity for disruption. If we do it the right way, we have as good a shot as anybody.
Amen. And the last thing I'll say before your reference, Ben, to Bobby Jones, that was pretty cool, actually, because I was thinking the same thing when we had our little meeting with you and I and Lindsay that morning. So this is the home to Bobby Jones, 1930 U.S. Open champion, right here, the greatest amateur of all time, possibly. Very good.
The 4 trophies, the real trophies are in the bar. Did you see them?
Unfortunately, Lindsay says we can't go down there and wander around, but I agree with that. Thank you very much.
All right, we can stand up, stretch a little bit. We're going to start in about 2 minutes. A reminder to go and check out the different vendors in the room adjacent. And then next up, we have Rich Scattergood. Okay, thanks.
Rich Scattergood, there he is. Rich Scattergood's going to start talking, and so get back to your seats. Well, Ben, hey Ben, the last thing I want Ben, come on back in here. You can just stop right there. But everyone here knows. Well, does anyone know where I'm from? Owatonna, there it is. The smartest thing Ben Utecht ever did was marry someone from Owatonna, and look where it got him. That guy. So anyway, right? All right. Let's take your seats, and Rich Scattergood is going to come up. Make sure you go in and talk to our sponsors in there. We've got a bunch of sponsors. Only 3 of them showed up in person, which is great. Sunbelt can sell your law firm for you. That is buy and sell your law firm. They can help you with that. The Robson people can help you with your experts. I know last time we did this, Bill Sieben ended up finding an expert for one of his cases through Robson. And Lexidus, Anthony, this guy sponsors everything. He's amazing. And he's got all kinds of really cool free stuff. So, all right, here we go. Rich, go ahead.
When I ran the MDLA conference, I brought my hockey coaching whistle to get people to pipe down. So, pipe down. I was really excited to hear from the NIL crowd. My daughter graduated from the University of Minnesota on Monday, as did her big brother before her, and her other big brother before her, and her mother before her, and her father before her. And my wife has her MBA from there. So my family has 6 degrees from Minnesota. So I was really excited to hear about the Dale presentation. I was not excited to find out that I'd be immediately following Ben Utecht. You guys collectively stole some of my thunder. So yes, Bobby Jones won the US Open here in 1931. Yes, it was one of the legs of the Grand Slam. So the only thing I can add to it is this little pond right out here. Lindsay, is this back to being the 18th green? Because it was the 9th green when I was, it's still the 9th, okay. But it was the 18th green back in 1931 when he won the US Open, and he actually duffed one of his shots and skipped it all the way across the pond and onto the then 18th green as part of his victory in the US Open in 1931. 30? Okay. Now you're wondering, why am I such a nerd? Why do I know this? Well, I grew up right here in the slums of Edina, attending Hopkins schools, and this is me now, but back in 1978, I was a caddy right here at Interlachen Country Club. And as a caddy, that is when I first started learning about relationships. I was 10 years old when I started caddying. At the end of that summer, right after I turned 11, one of my last loops of the year was for Carl Pohlad. So I was 11 years old, and I'm talking face-to-face with Carl Pohlad. So you learned how to deal with people. You also had to learn how to be an advocate, because if they didn't like you, you ended up in the pond behind the caddy shack, which used to be down at the northwest end of the parking lot. We also had some perks as caddies. No, we didn't actually get our 15-minute pool day like they did in Caddy Shack, but we did get to golf on Mondays. But I brought the pool reference because back in the 70s, before people could trespass, injure themselves, and then successfully sue the landowner, landowners used to be a lot more fun. And my neighborhood friends and I, we used to swim in the pool up here pretty much 3 nights a week in the summer, and the club didn't care as long as we didn't make too much noise. The lawyers have ruined those days. Later on, the other thing I learned about relationships was my first caddy master, his family moved here from Chicago, and he didn't care whether you went to Edina or Hopkins or anything like that, but the second caddy master did. And suddenly I stopped getting loops. So I took a job on the grounds crew, like Carl here, and in my last summer working here, my job was to prevent all of the greens on the back 9 and the putting green from burning, which on a hot day wasn't very easy because people were playing on the course, and I need to throw water on them about once an hour for every green. So I had about 6 minutes to go from green to green. I was paid $3.65 an hour to protect the real estate of Interlachen Country Club. You do the math. All right, on to the seminar. I will be shocked if I say anything you didn't already know in the next few minutes. And that's the bad news. I'm not going to tell you anything you don't know. The good news is it's not going to take me 20 minutes. Read the scheduling order. Keep in mind, they're not all uniform. They should be, but they're not. Judges have different things in them, and if you don't know what's in there, you're not going to know what the judge is expecting you to do. And it's really important to work with the other side to make sure that everyone's on board, because you should not assume, this is mostly plaintiff and defense injury attorneys in this room, not exclusively. And for the most part, we're a pretty collegial bar. We get along. We don't really have a lot of animosity toward each other, with obvious exceptions. You know who you are. But particularly now we have a lot of new judges to the bench, and they're sort of figuring it out too. The district court bench has turned over. And don't assume that they're going to care that you and opposing counsel have worked everything out and you've got it under control. It's really important to avoid wasting time being chastised by the judge instead of getting ready to try your case, that you've not only reached your agreements, but they're consistent with what the judge has ordered you to do. This is, I think, a really important thing in injury cases. Don't be scrapping the medical records together at the last minute, okay? You know what you need to put into evidence, both sides do. Get them organized, get them Bates labeled, get them exchanged before the first trial deposition, and everything's going to go a lot more smoothly. The other reason is, and for you youngsters this may not be a big deal, but this new Mendez thing, Mendez whatever, for old guys like me, the idea of submitting exhibits from my computer at counsel table is a very frightening proposition. Maybe for you youngsters it's not, but for people of my generation, we're having to get all those things filed ahead of time anyways, because we need our support staff to do it for us, because we just simply don't know how to do it ourselves. So that being the case, the other side's going to see all your exhibits before trial anyways. There's no reason to not just get this all done a couple weeks ahead of time. When you do what I'm encouraging you to do, which is to work together and reach agreements, reduce them to writing. It can just be an email. It doesn't need to be a formal stipulation. But when you're getting ready for trial, you're pretty busy. You got a lot going on. You got a lot of balls in the air. You might not remember what you agreed to yesterday. And then suddenly you're in a situation where you're arguing to the judge, well, counsel said that, we had an agreement that we would do this, and other lawyers saying, no, we didn't. What the hell is the judge supposed to do with that? Nothing. Just take the few seconds when you reach an agreement that's going to impact how you're going to be trying the case, shoot an email, reduce it to writing, so you don't have to, one, remember what you agreed to, and you don't have to fight about it. There's a pillar that's blocking my view of what's up there. The main point of what I wanted to be talking to you about today is doing what you can do to make trials go smoothly, efficiently, and as quickly as possible, because jurors know when their time is being wasted. They can tell when the court suddenly stops for the day at 4:05 because the next witness isn't ready or something. The jury knows that their time is being wasted, that they're going to have to come back on Thursday instead of being able to return to their lives on Thursday, because collectively the lawyers or the judge or somebody doesn't have their stuff together. And what none of us know as trial lawyers is who they're going to blame. They might think it's your fault. They might think it's your opponent's. You don't know. Why take the chance? Work together to make things go smoothly and quickly. And this is kind of more of the same. When we're fighting over evidentiary rulings, none of us can stop ourselves. We're going to take whatever the judge will give us. And that might be great in the moment, but when we're defending something on appeal, that might not be so great. So figure out what you can agree on, limit the amount that you're going to force the judge to rule on, because the more rulings the judge has to make, the more errors the judge may make, and it's also going to be constantly slowing the case down, particularly if you have a judge that doesn't like to make decisions. So you're taking early recesses so the judge can think about a simple objection over the lunch hour, and just sort out what you can and can't agree to and get it done ahead of time. Consider sharing technology. This is one way where you can, and Paul's probably laughing because we just tried a case together and I didn't want to do it at first and ended up having to do it because the court technology was so dog-do. I had to beg him to let me use his videographer's technology to play some key videos. So this is an area where you really can cut down the time in a trial because all of the put down and set up and take down time, again, the jury figures it out. They're annoyed. Work together to share technology where you can. I realize it's not always feasible. If you've got your theory of the case embedded in your video presentation, then maybe you can't. Coordinate and communicate. Don't hide the ball on who you're calling the next day. Let the other lawyer know who you're calling the next day. Work together to make sure that every day of trial goes till 4:30. You're using all of that time. And it might be really important to you at the back end because it might be the difference between you having to rush through your closing argument or having all the time you need to provide a more deliberate closing argument. Just continue to do these things to make the trial go smoothly. And it might include letting the other side call a witness out of order because the timing, the technology is already set up. You've got a witness you can't finish that day, but there's just enough time to play one of the medical experts from the other side. Just get it in and let the case go faster. And at the end of the day, what I'm saying is play nice in the sandbox and treat the opposing lawyer the way you would want to be treated by them. And, you may think, well, gee, first of all, who are you, Scattergood? I've had cases with you. You don't behave this way. Well, I'm older now. They call it the practice of law. We are supposed to get better over time. We are supposed to get more mature. We are supposed to learn how to behave better as we get older. But right. Well, no, I mean, not all of these things, we're busy. We make mistakes. Everything that you talk about at a CLE of whatever the topic is, it's really just about reminding yourself of best practices. This is what you want to aspire to do as high a percent of the time as you can. You're not going to achieve 100%. And you also may be thinking, well, I don't know. I don't want to be giving an unfair advantage to the other side. And I get that. When you're trying cases, you have to be yourself. If you're a bulldog, you need to be a bulldog. If you are by nature a kind, cooperative person, use that because you will kill the other side with your kindness and cooperation. It will be an effective form of advocacy for you as long as you're being you. But even if you're a bulldog, you can still employ some of these things to cooperate with the other side. And in doing so, you're not giving up an advantage. What you're doing is making sure that you yourself are organized and prepared, and you will present to the jury a more organized, focused, and concise presentation of your client's case, which usually leads to the best result. Thanks.
Next up, we have Lance Meyer, who's going to talk about Miller-Shugart agreements.
Thanks, everyone. Can you hear me all right? Thanks for sticking around after lunch. I was going to make the joke about following up Ben, but now I have to follow Ben and Rich, so here we go. Miller-Shugart agreements. So we've talked about a lot of things that are developing really quickly. NIL deals. We talked about AI, generative AI. Miller-Shugart's been along longer than I have. And it was kind of stuck based on that case from the 80s for a long time until just recently when we had a new Supreme Court case, a new standard for interpreting these agreements, looking at these agreements, and litigating these agreements. And so in the time I have, I just want to talk a little bit about the background of Miller-Shugart's, talk a little bit about the Kings Cove case that was decided more than 2 years ago now, and I just, in preparing for this, see that it's headed back up on appeal. So I think that'll be a common theme throughout this of be careful what you wish for and changing the rules for these agreements and litigating things after the fact. All right, so just a little bit on background. I'm sure anybody that's litigated these cases, I'm primarily an insurance coverage lawyer, so I deal with these Miller-Shugart agreements after the fact, after they've been entered into by a plaintiff and an insured, and then we deal with the coverage issues after the fact. So what is it? It's a plaintiff settles their case with the insured tortfeasor, and the tortfeasor stipulates to liability and damages, and then assigns the rights under the policy to the plaintiff so that it shifts the coverage case from being a case between the insured and the insurer to being a case between the plaintiff and the insurer. And then judgments entered against the policyholder, and either in that same case, the case proceeds as a garnishment proceeding, or in a separate, typically in a separate deck action is when you deal with the enforceability of those agreements. When are these agreements entered into? For a long time, even in my practice, I always thought you had to have a denial of coverage. If an insurer defended under reservation, I was under the impression for a while, I think, that the insured couldn't Miller-Shugart, didn't have that ability to do so. I think it's pretty clear from the case law now, especially if the reservation is to deny all coverage for the insured, then definitely the insured has the opportunity to protect themselves by entering into one of these agreements. And I think it's even an open question if there's a partial reservation of rights, because when you put yourself in the insured's position, if the insurer is saying, we're going to cover, damage to the interior drywall of this apartment building, but we're not going to cover the $5 million to replace the windows, can the insurer prevent the insured from entering into one of these settlements? And really this can happen any time, subject of course to the defenses that we're going to talk about. There are some notice requirements with Miller-Shugart's. If there's a straight out denial, the insured doesn't have a obligation to notify the insurer of entering into these agreements, but if there's a reservation, there is a notice requirement. And the main purpose for that, as someone that represents carriers, there's a determination at that point to say, would we rather litigate this and defend this on liability rather than coverage, or are we okay allowing the insured to enter into a Miller-Shugart and standing by our coverage positions? There's some cases where I've advised carriers that this isn't a good liability case. We have some issues as to coverage potentially. withdraw your reservation and defend the case rather than dealing with the coverage and whatever amount the insured stipulates to. The basics of a Miller-Shugart are pretty clear. It's a policyholder that likely doesn't have assets or wants to protect their assets above their coverage limits, or if they don't have coverage, it absolves the insured of personal liability and then shifts the burden of proving coverage to the plaintiff. And like I said, it puts the pressure on the insurer to decide whether to defend the case on the merits or to stand by the reservation and defend the coverage determination. There's three main defenses, and these have been the same defenses since the Miller-Shugart case was decided in the 1980s. The first and primary defense is always coverage. Is there coverage for the settlement? In the Kings Cove case, and I'm going to talk about, my partner Dale Thornsjoe and I had the privilege of writing one of the amicus briefs for the Insurance Federation, and our primary argument to the Supreme Court in that case was, this is really a coverage case. There's no coverage for this deal, and therefore you could decide the case on that, and you don't have to get into the weeds on all these other issues. If there's no coverage, the case ends at that point. The plaintiff took the risk of letting the tortfeasor off the hook, failed to prove coverage, and the case is over at that point. The second defense is reasonableness, and this is the issue that ultimately went up in the Kings Cove case. The plaintiff has the burden to prove that the settlement is reasonable. And I had a recent case where a carrier, their insured had notified them that they were talking about entering into a Miller-Shugart, and carriers that write policies in multiple states, Missouri, other states in which there's set up agreements, the insurer emailed and was very concerned about the risk of this type of agreement, the setup to the carrier, and was very happy to hear when I told her that in Minnesota, Miller-Shugart, there are defenses that insurers have to these agreements. There's obviously the coverage defense, but it's also reasonable. The policyholder and the plaintiff can't just stipulate to some amount, stipulate to the facts, and foist that onto the carrier. One of the key things with reasonableness is if a court finds that the Miller-Shugart agreement is unreasonable, the case goes back to the status quo and you pick up where it was at the time of the settlement, which is a risk to the policyholder who's trying to be done with the case. There are a lot of these agreements, though, and if I was negotiating one on behalf of an insured policyholder, I would advise them to put in a provision that says if it's unreasonable, if the agreement doesn't hold up, we're done with the case. That's the risk the plaintiff takes by taking on that case. Finally, the third defense is fraud and collusion. I think these agreements, to a certain extent, are collusive, not necessarily in a bad way in general. I don't think there's many cases where this defense has been raised and held up just because really it goes to reasonableness more than fraud and collusion, because the whole purpose of the agreement is to get the insured out of personal liability and shift the case to the coverage issue to the plaintiff to litigate. Again, though, if it's found to be fraudulent and collusive, the case goes back to the status quo. I think there could be an argument, though, on that point that if fraud and collusion is involved, the plaintiff and the insurer, or the plaintiff probably shouldn't have another shot at going back and starting over again. So allocation is the issue that has come up recently. Historically, parties have been required to allocate between multiple defendants that are settling on a Miller-Shugart or between multiple categories of damages. And so lump sum settlements, traditionally the Corn Plus case goes back a couple decades, I think, as well. The Eighth Circuit said if there's not coverage for a portion of the damages that are settled and you don't allocate in the Miller-Shugart, then it's unreasonable as a matter of law, per se unreasonable. All right, so I'm not going to do a bunch of background on this case. I will tell you, I talked about this a couple years ago now, right after the Supreme Court's decision. And then in prepping for this, I said, well, I'll see if anything's happened lately. It took me more than an hour to read through the docket and the proceedings post-Supreme Court case. And so this case is still working its way back up through the courts 2.5 years after the Supreme Court handed down its decision. So it's a construction case, multiple parties involved. A marina hired Lambert as the general contractor, as well as a concrete company, rail construction, to perform concrete work. There were issues with both roofing and siding that were on Lambert, as well as concrete that was on rails. So Kings Cove sued both of those parties, and Lambert's insurer, United Fire, they denied coverage but defended on a reservation for Lambert. Denied coverage as on the basis that Lambert's own work, the siding and roofing work that was damaged, was not covered by their policy. In this case, because United had defended under reservation, they had notice of the Miller-Shugart settlement discussions, but did not participate because their position was none of this is covered. And at that point, Kings Cove and Lambert entered into a Miller-Shugart for $2 million, which maybe this is the cynical defense coverage attorney in me, but that's the exact amount of the policy limit, which to me raises red flags right away. If it's based on the damages or what's going on in the case, how is that conveniently exactly the amount of the policy limit? So the basis for that, and actually another issue that was up on appeal, is in the Miller-Shugart agreement, they actually allocated the damages. They stated what the repair costs were for the siding. They accepted the repair costs for the concrete. Out of that, there were general construction damages, overhead profit, things like that, that they allocated between the two. The agreement allocated and said that because the estimated cost of work plus there was an ordinance involved that if the repairs cost more than 50% of the building, they would have to essentially rebuild the building to the tune of $4 to $5 million. And so that's the way the plaintiff justified the $2 million by saying the repair costs for Lambert's work are roughly $600,000 plus a percentage of that ordinance anticipated costs. You get above the $2 million limit. So I'll just skip through. The district court enforced the agreement, found it to be reasonable. There was extensive of litigation over that, and all of that litigation was following a decision that everything was covered. So the district court said that the your work exclusion didn't exclude coverage for Lambert's work, and then based on that said, all right, if everything's covered, then the $2 million is reasonable. The Court of Appeals reversed on the coverage issue, and that's really what triggered the litigation after that, is because if the roofing and siding work isn't covered, but maybe some interior drywall carpet damage is covered, we have an unallocated settlement amount, and what do you do with that? And at that point, the Court of Appeals followed the Corn Plus case from the 8th Circuit and said that the agreement's per se unreasonable because it doesn't allow the court after the fact to allocate between covered and uncovered. The Supreme Court affirmed the your work exclusion applied, but remanded with instructions for how to analyze the reasonableness of the agreement, essentially rejecting the per se rule that the insurer and its amicus advocated for, and said that, and this is similar to how other coverage, anybody that practices in the coverage realm, similar to how other cases are handled following a verdict or a settlement, and said the burden is on the plaintiff in this case to allocate after the fact. And so remanded it and established a two-step process for determining reasonableness. So the Supreme Court said you first look at the overall settlement amount. So in this case, it would be the $2 million, and is that reasonable based on the facts of the case? And then the next step is the burden shifting of the plaintiff in a case like this to establish what a reasonable person at the time of the settlement would have allocated between the covered and uncovered categories of damages. And essentially left it up to, it went down to the Court of Appeals, and the Court of Appeals said, we don't want to touch this until the district court gets another shot at it, and went down for the district court to kind of decide how to deal with this. Do you allow more evidence in? Is it just based on is it briefing? Is there a new trial? Do you allow for experts to testify to the different damages? And fast forward to it. Fast forward 2.5 years, they are still now litigating what the district court's allowed to do. They're still litigating the allocation, and it's going up an appeal, I think, just last week, if I'm doing my math correctly, is headed back up to the Court of Appeals on various issues in that case. It's one of the things that was discussed as the case went up the first time is the per se rule forced the parties at the front end to allocate between covered and uncovered damages such that after the coverage determination was made, the parties had already made the decision as to the damages that the coverage decision could be applied to. And without that allocation, the per se rule said it's unreasonable, you got to send it back, it's not enforceable. Now we have a situation where in the course of this case, just in monitoring, and I haven't been directly involved obviously in the facts, but monitoring it, the damages categories and the arguments have evolved over time as to what they settled on probably 5 years ago now is different than what they're now arguing they settled on and what the numbers were based on. And that's I think the new world that we live in is that we're going to be dealing with these after the fact of trying to go back and unscramble the egg after the fact with new experts and new information that the parties could have done in the first place. So there's a new appeal. We'll probably find out a little bit more about what evidence is allowed. There's evidentiary issues that are going up, as well as in that particular case, and then what happens if it's then found to be unreasonable based on the additional information that comes in. Does it go back? Do you allow it to go forward? So one of the biggest takeaways for me is the increased cost litigation uncertainty. And so, as a carrier, I see these after the fact, but I think the litigation and the cost of this has been cautionary to those that are exploring these agreements. And even if you're not required to allocate it up front and can just settle for a lump sum, I think it's advisable to do so. And when it comes to allocation, you don't have to say, we determine that these damages are covered and these are uncovered. It's just, here's what we're settling. Here's the categories of damages. Here's where we're coming up with the amount so that there's something that you can establish an allocation after the fact. And I think another takeaway is just the overall reasonableness has to be for all claims. So in this case, one of the difficulties is that the settlement amount was $2 million, but the court has now determined that a large portion of the damages aren't covered. So is the $2 million overall amount reasonable when it was based on everything being covered? And I think that's something to keep in mind, that a lot of these agreements I see, it's for the amount of the coverage, and not the amount of the determined damages. And I think that's something that to keep in mind. And just at the end, I would just say I'm seeing more opportunities to be creative with these agreements, especially as a coverage lawyer. I think traditionally they've been just straight Miller-Shugart agreements between a plaintiff and a insured, but I think there's ways for coverage for carriers to be involved in these agreements in certain situations. You know, maybe it's a Drake Ryan by a primary carrier along with a Miller-Shugart that allows the plaintiff to get at the excess layer of coverage. Or the first example is a Perringer and a Miller-Shugart, which was essentially King's Cove, is that you're settling against one party on a Miller-Shugart, but the rest of the case goes forward. All right, that's all I have. Thank you.
Thank you, Lance. So, question is, have I just woken myself up? Yes, I have. Not because of Lance, of course, but because it's been a long day. No, I'm thinking out loud here because you guys don't know this, but Lance was my former law student. Right, Lance? And gosh, I should probably tell this story because Greg Cooter's here too. What the heck? More information that you probably don't need to hear, but you're going to hear it anyway. So it goes like this. So Lance was a really good student, the best of the best. And is Tom Brock still with you guys, Greg? Okay, Tommy Brock was also in our class. Lance, did you know Tom? Okay, well, so the Callie Award, which is the top student in the class, came down to Tom and Lance. Lance, you probably, do you know this? Have I told you this story before? Okay, well, this will make you feel good. And so I took the final exams in my office, and I had one of my colleagues read them, and they thought, God, these are both really good. You know, what are you going to do? But they did truly, and you can tell Tom this, I think I've told him this story, Greg, they liked yours better. However, Tommy Brock, he's a crafty guy, calls me up one day and he goes, Professor Olander, have you given the Callie Award yet? And I said, no, but I'm getting close. And he goes, well, I could really use that for a job. I knew Lance already had a job at the Court of Appeals. Tommy Brock gets it, right? Lobbying pays off. That's a true story. All right, next up, Nate Caribou. Nate is with American Family. He's worked his way up the echelon there, and now we don't really know what he does, but we know that he oversees things, so that's important. American Family's done a really good job of taking that role you currently have, making it very mysterious. We just know you have power now. So anyway, Nate's going to give us the rest of the story from the insurer's perspective. Go ahead.
All right, thanks, Brett. Can everybody hear me okay? All right, this is my first time doing any public speaking in person since before time, so go easy on me, please, everybody. Let's see if I still got it. All right, I got the clicker. All right, what are we doing today with this one? We're pulling back the curtain, but not just on the insurance side, on the plaintiff side too, looking at what is going on in either room during a mediation, what the other side might be doing that you might not have thought of. Oops. Yeah, why am I the guy talking to you about that? Currently at AmFam, I've been there for 9 to 10 years. On the defense side, before that, I spent 4 years as a plaintiff's attorney. So I've been in both rooms, represented parties on both sides. The other reason I think I was invited, Brett finds it impressive. Before I went back to law school, I spent a little bit of time as an airline pilot. So I think that's why he likes me. He thinks it's interesting. So I think that's mainly why I'm here. All right, when I was first asked to present on this topic, I kind of thought, I didn't know how exciting it might be. I thought it was just me getting on a soapbox, maybe giving out opinions and kind of 20 minutes of filler. But the more I thought about it, I thought it made more sense to learn about what the other side might be doing, because the obstacles each room has during a mediation are a lot different. And if you've only practiced on, some of you have practiced on both sides, some of you have only represented one side. So to learn what other obstacles the other side might have that you might not have thought about, I thought was worthwhile. In addition to that, if you can find a very philosophical quote that supports your idea, that's when you know you're onto something. So to paraphrase Sun Tzu here from The Art of War, if you know your enemy and you know yourself, you're living your best life. If you know yourself but not the enemy, you're the blind leading the blind. And if you don't know yourself or the enemy, you're a full-blown idiot, and may God have mercy on your soul. So we're going to try not to do that and learn what the other side is doing. So first part is for the plaintiffs, attorneys in the room, what's happening in the defense attorney's room or the defense room during mediation. So to start out with, first things first, who is in the room? Or more importantly, who is not in the room? So who's there is who you'd expect to be there, the defense attorney you've been dealing with, and then whoever on the side, on the other side has authority for the case. That will be different depending on the insurance company you're dealing with. Sometimes it's a litigation adjuster. Sometimes they're called a claims representative. Sometimes it's in-house counsel. But generally, it's not going to be the same adjuster that you were negotiating with pre-suit. Most insurance carriers, once the case goes into litigation, it gets transferred to somebody else, either a litigation adjuster, somebody with more experience, in-house counsel, something to that effect. So the frontline adjuster who was previously making offers that you might have had disagreements with is usually not going to be there and has no idea what's going on at the mediation because the file is no longer theirs and they're no longer doing anything on it. Also, who's usually not there is the defendant. There's sometimes an exception to the rule if there is a case where there might be some excess exposure, where there might be a demand above the policy limits on larger cases, or sometimes if the defendant has some kind of personal investment in the case and wants to attend. But generally, they're not there at all. So take away from that part of it, there is really no sending a message during a mediation to either the initial adjuster or the defendant because they aren't present. All right, what are they doing in the defense room during a mediation? They're reviewing a bunch of documentation and kind of crunching numbers based on that documentation. I listed off up there. It's all stuff, this is kind of part of it that I didn't know if it'd be that interesting because everybody knows this. This is what everybody's going over. But that's kind of what they're doing is reviewing the case, nerding out over the documentation and number crunching, doing risk analysis, and drinking a lot of coffee and talking about whatever's going on with NIL and with the mediator, things like that. So the main thing, though, is this the first time they're reviewing any of this? No, it's already been reviewed and all done before the day of the mediation. And why has it been done beforehand? They have to ask, the defense attorney you're working with has to ask for authority from whoever has authority at the insurance carrier you're dealing with. So either the litigation adjuster, claims representative, in-house counsel. And they need to know this information, this documentation, number crunching, so they know the right number to ask for, or they can ask for the number they think will get the case settled. How it's done on the defense side is basically the same way when I was a plaintiff's attorney, that plaintiff's attorneys valued their cases. It's looking at the settlement value on a case-by-case basis, figuring out what do these kinds of cases settle for, what's the range, and coming up with what range the case might settle within for that particular type of case in that particular area in that particular jurisdiction. So it's the defense attorney has to send an authority request to somebody, whoever's in charge of the, directly in contact with them to give them authority. And they have to get it. That person has to get it sometimes from other people. So that's the biggest obstacle I would say in the defense room, is the defense attorney getting the authority to settle the case that they're asking for from the insurance company. So what's the insurance company? Sometimes I think plaintiff's attorneys might kind of portray it as like an evil conspiracy going on, but I'm here to tell you it's not some kind of AI conspiracy to go back in time and kill John Connor. It's not like the evil Galactic Empire trying to persuade Luke Skywalker to turn to the dark side. It's something else, and I don't know if it's better or worse. Here you go. Here's what it is. It's a bureaucracy. So how well do bureaucracies work? How efficient has any bureaucracy you've ever been a part of? How well has it ever functioned? That's what you're dealing with, and I think that's what's causing the frustrations. Okay, getting into how settlement authority more specifically works. I had a colleague who told me very specifically, hey, don't be giving away any of our trade secrets here. We don't want the other side to know how it works. So it's not me saying this. I found a spot in the Colorado practice series that pretty much says pretty well how it works, but it's the same thing. So it's not me saying this, it's the Colorado practice series laying it out for you. But the main thing is, and I think this is pretty well understood, is the first adjuster has a certain level of authority. If the case is at a higher value, or the defense attorney is asking for, the demand is either higher, or the defense attorney is asking for money above that, they have to go to somebody else more senior in the company, and then it might have to go to a committee. So the main thing I'm going to focus on next is what do those higher ups need to review, and it's all the boring documentation, nerding out, and number crunching we were talking about before. All right. Timing of when to send all this information, early and often, well in advance of the mediation. If you send it the day of or like the day before, the defense attorney you're working with is going to have a much more difficult time, or an impossible time, trying to get authority from the insurance company compared to if it had been sent well in advance. The two biggest things that will create an obstacle for the defense attorney is if they don't have the special damages or they don't have lien information. All right, special damages, kind of a no-brainer, but I just wanted to reiterate it because it's directly impacts the value of the case, what amount of authority the defense attorney will be able to get. The higher the special damages, the more authority they'll be able to get. Juries want to award the hard economic damages, and the insurance companies know that. There's really no incentive to drop it on somebody on the day of the mediation or on the eve of mediation. The liens are the next thing. They're required to evaluate the case so that you know what the collateral source offset is. They can increase the value of the case as well, but in addition to that, they're required to be turned over in discovery. I've seen recently a lot of objections that the health insurance lien information is not discoverable. Either it's outside the scope of discovery or it's post-trial discovery, so therefore we're not going to give it to you. A lot of times it gets turned over like right on the day of the mediation anyways, but I think that if you look at Rule 26.02C, that information is in the scope of discovery. Here's what I'm looking at. Basically, it says in any action in which there is an insurance policy that may afford coverage, any party may require any other party to disclose the coverage limits, amounts paid and payable. I'd submit to you that does include the health insurance information just by reading the rule. But you don't have to take my word for it. That's also included in the annotations to Rule 26, where it basically says in the annotation, It includes health insurance or medical insurance information, and it notes in the annotation the reason that the insurance information, the amounts paid and payable, is supposed to be turned over so that cases can be evaluated to settle the case. All right, so to sum up from the defense room, the defense attorney and the adjuster are in there nerding out, analyzing numbers and documentation, send it early and often. If the information isn't sent in advance, the defense attorney is going to have a lot harder time getting authority from the insurance company. The case might not settle that day. To give you an example, I went into, sometime in the last year or two, went into mediation. I thought workers' comp had paid about $13,000. I had a plaintiff's attorney drop a work comp lien on me. No, it's $100,000. And it was like, well, I don't know how we're going to try to settle the case today. I would have asked for a lot more money. We're going to have to kick this down the road and come back later. So that's an example of something like that being counterproductive. All right, moving on to the plaintiff's room. This is for the defense attorneys. You have to hear me get up on a soapbox too about what you might not know about what it's like for the plaintiff's attorneys. Starting out, who's in there, who you would think, the plaintiff's attorney and the plaintiff, but sometimes there's a lot more baggage than just the plaintiff. Family members, friends, spouses, the people that want to tell the plaintiff what to do, above and beyond their attorney and the mediator. What are they looking at? All the same stuff as the defense attorney and the insurance adjuster, but with additional considerations and complications. Usually the plaintiff's attorney, what the defense attorneys might not know, the plaintiff's attorney, the way I view it, they're generally conducting multiple negotiations at the same time, not just negotiating with the defense attorney and the insurance company. So who are they negotiating with that you might not know about? Or you might know about it, but might not think it's as big of a deal. It's health insurers. Unreasonable, I think, is the polite term, family members, and then the emotions and expectations of the plaintiffs themselves. So the Morpheus there, that's my impression of a health insurance company, the Arrested Development relatives, and the Joker meme there is, I think, how every attorney feels kind of after talking to a client. All right, health insurance liens. I think there's I hear a common misconception on the defense side, kind of quote like, oh, the plaintiff can always get the lien reduced way, way down, or they can always get it by some amount, a half or a third or whatever. I think there's the claims adjusters and defense attorneys might have a preconceived notion it's always the same reduction, always, the time, all of the time. And I'm saying that's not the case. My information's dated. I was a plaintiff's attorney about 10 years ago, so it's old news, but I found that it was always different depending on what type of health insurance lien it is. Private health insurance would be a certain percentage. Medicare and work comp, they run it through a formula. Medicaid was usually a pretty good deal. ERISA was like the worst case scenario and just terrible to talk to those folks. So the bottom line, you can't always assume they can always get it reduced by the same amount. Fee negotiations come up sometimes. When I was a plaintiff's attorney, it happened like a lot of the time, more than half, I would say. Sometimes it's happening at the mediation. Sometimes it's after the mediation's done and you've already gotten the settlement check. But might get the call then at that point. Oh, I need more of the settlement. You're taking too much. And it's like, well, you read the contract when you signed it, knew what it was, right? But that can come into play during the mediation sometimes and be an obstacle for the plaintiff's attorney as well. I think every plaintiff's attorney has had a mediation torpedoed by this one, a family member that's actually the one, a lot of times a spouse, but it could be a parent or an adult child of an older plaintiff. but they have done their internet research or based on pulling numbers out of thin air, they know better than the plaintiff's attorney and the mediator what the value of the case is. And they can completely mess up the plaintiff's expectations, even though the plaintiff's attorney could have done a really good job going into that day of communicating, hey, here's the reasonable settlement value. And then the last thing is the emotions of the emotional attachment to the case and client expectations of the plaintiffs themselves. The plaintiffs are in a glass case of emotion. The reason that it's different, I think for the plaintiff's room, it's an emotional decision as opposed to a business decision. It's not just risk analysis. It's what amount of money that goes into the plaintiff's pocket that they can live with at the end of the day. I think a lot of time it's they want to have their story heard and told and have their day in court, even if it's just by the mediator or the plaintiff's attorney hearing their side of the story. And the number they come up with is more of an emotional decision based on pure numbers or analytical decision. All right, I got like 1 minute left, so takeaways. For the plaintiff's attorneys, please don't just dump information on the defense attorneys at last minute. Defense attorneys, please realize that plaintiff's attorneys have a lot of obstacles that are probably worse than, I don't know if they're worse than dealing with claims adjusters, but you know, they probably are. So that's going on. The whole point of my presentation was, you know, if you know how things work, there's a term in aviation called situational awareness. It's kind of knowing what is going on all around you in every part of the environment. You know, where's the airplane going? Where are you going to be 5 steps down the road? So if you're going to understand, you know, what's happening from a large point of view and know what the other side's doing, maybe you'll have more success. Be curious, not judgmental. Thanks, everybody.
Thank you, Nate. For those of you that didn't know, if you happen to get trapped in an airplane that's going down, and Nate happens to be on your flight, he's a former commercial airline pilot, so bring him up to the cockpit. Anyone know that besides Nate? And oh, did I tell you that earlier?
No, he told us that.
Oh, good. He was bragging. Okay, all right. That's what I do. All right. Next up is Eric Palmer. Eric's been a frequent speaker at my events. He used to talk about autonomous vehicles. Now we're just hoping that those truckers become autonomous so there won't be so doggone many cases for you guys to pursue. But until such time, here we go. So I have some update on trucking law. Eric Palmer.
So a quick story. I don't know if he's still here. Aaron Aiken, Nate Caribou, and I ran into each other at a bar before a Pearl Jam concert, and in my mind's eye, all three of us were wearing flannel t-shirts, backwards hats. We're in our mid-40s, and we realized, oh my God, we're the old suburban guys at a rock concert right now. So I'm pleased that I got to go right after Nate. I'm gonna wander, and if you think I wander, wait until you see Nate Bjerke. He's gonna jump all over the place. All right, so I'm here to talk about truck law. There's some updates, there's some things that are going on around the nation and locally that I want to talk about. And I've made a promise to Lindsay Keller that I would make this the exceptionally neutralized version of it. So if by the end of this you know my slant on things, Jim, I'll do my best. But that said, by the end of this, maybe we'll take a vote and you can figure out what side of each of these issues I'm on. All right, so I want to start by talking about CRIT. This is, I don't think anyone that was involved in this case is here, but this is Jeffrey Christensen. He was a man that was killed in a fatal truck collision in 2020 in Wright County. He was a wonderful man. He had the belly laugh that I've heard about from all of his family members. He was involved in a horrible collision that involved a semi-truck driver that had made the same poor maneuver multiple times, and unfortunately this time it resulted in the fatality of Jeff. He goes by Crit, though, to his kids and to everyone else that he knows. I got to meet his family, unfortunately, in the circumstances after this, and his family was not only really curious about what they could do to solve this issue and sort out the wrongful death claim and the civil claims that come from that, but also, and more importantly, in their eyes, they wanted to know what they could do to impact the broader context of things, help other family members, help other individuals, and really it was kind of an eye-opening process for me to really meet these folks, because they weren't just involved in their own little microcosm of their issue. Not that it was a little issue, it was a huge issue, it was the biggest issue their families ever faced, but they wanted to help others. So in March of 2024, just a few months ago, I actually got to go out to DC with these guys and do an AAJ Diplomacy Day, where we were out meeting with representatives and talking about the active trucking law that's out there. So I thought it was really impressive to see Jason Christensen, who's a South St. Paul police officer, and his sister Kelsey Lee, who is, I think, the most empathetic and engaging person I've ever met in my entire life, and watch them turn their pain into persuasion. They were using their dad's story as a way to speak to people and inform our representatives out in DC about what impact these trucking bills that are being bounced around at this moment could have on real life, real people that have gone through tragedy like this. So with that in mind, that's where these two bills are that we're looking at, both coming out of the House of Representatives. The first is the Fair Compensation for Truck Crash Victims Act of 2024. This was sponsored by Representative Jesus Garcia out of Illinois, a Democrat, and there's a co-sponsor of Hank Aaron, excuse me, I almost said Hank Aaron, I'm thinking baseball and sports. Hank Johnson. I actually got to meet with him in his office out in DC to talk about this process while we were out there alongside Jason and Kelsey. There are 5 co-sponsors of this, but they're all Democratic, in consideration at the Transportation and Infrastructure Committee. What's really most important is that this bill is taking a look at the federal minimum standard for interstate commerce, or for trucks that are involved in interstate commerce. Right now, it's set at $750,000, and that was established in 1980, trivia, the year before I was born. Obviously, inflation has had a lot of impact since that time, and they're pushing to move the minimum to $5 million. That would be a huge increase, but it would be catching up with the last 40 some odd years of lack of change in that. And I think we see that so often in our minimum standards when they're set statutorily or when they're set by a legislature. Things don't get updated all that often. The no-fault benefits, $20,000 doesn't go very far anymore these days in today's day and age. Just to keep up with medical inflation, I think it turns out to be about $5.2 million to go from 1980 to present in terms of the 750 to 5 million. So rounding down in some regards there. Nope, I hit all those bullet points right. The other side of the coin is that the trucking industry is already a very hyper-competitive industry. Thin margins, and it's very expensive to run these trucks across the nation. They're often paid by mile, and oftentimes it's super competitive with other trucking companies, and an increase in the premiums an increase in the minimum amounts would make a significant impact on what would be the premiums paid to insure and drive those trucks across the country. So obviously, whenever we're dealing with a single limit coverage of $1 million, now granted, whether it's 750 or $1 million, we typically see $1 million nowadays. But with that said, single limit coverages can have their issues, especially when you have multiple parties and you have catastrophic impacts and catastrophic damages that are so often, unfortunately, involved in fatal collisions or catastrophic collisions, or sometimes collisions that involve multiple vehicles, multiple parties. I'm working on a case right now that has multiple parties involved, including a dental clinic. It's mind-boggling to think of the amount and the size of damages that we can often see when these 80,000-pound trucks are involved in these collisions. All right, that's one. Second is that of H.R. 915, which is another House of Representatives bill that's actually getting a little bit more traction right now. It was sponsored originally by Mike Gallagher, a Republican out of, I think, Washington, and has a couple of Minnesota representatives, Pete Stauber and Brad Finstead, are both co-sponsors of this. There is some bipartisan support of this, 15 Republican and 5 Democrats. This is one, I'll just be upfront and not be neutral on this one. This is one that we are opposing, or that we were opposing when we were out there. It passed from committee into the full House review in May of 2023. There it sat. It hasn't really been voted on yet. It's in some works. But here's what the goal is, because the districts across the United States have been a little bit in conflict about whether or not brokers and shippers can have culpability and responsibility for damages when a truck collision occurs. Usually it's coming down to the issue of control. What kind of control is there over the load, over the direction, over the trajectory of the package that's being delivered and all that? And oftentimes I think corporations and businesses and people that have interests in these things often like to find rather bright line rules. That's what this is trying to establish, but there's some downfalls in this one there. One of the requirements, basically what it states is, if you satisfy the standard of care, the reasonable and prudent selection of motor carriers will be considered to be established, and you've met your standard of care, and you cannot be culpable, essentially immune from damages, so long as the truck is registered under Section 13902 of Title 49 of the Fed Regs, carries at least a minimum coverage of the federal and state laws, which at 750, really $1 million is what we often see. If that other one were to pass, other bill were to pass, then obviously the $5 million would apply in that case. And that it's not been deemed unfit by Section 3114 of Title 49. Essentially, that's where there has to be an investigation of the company. They have to be deemed unfit. It is something that is very rare for it to happen. It is something that takes a lot of time for that to happen in the first place. And couple that with the registration requirement, and these three being the only three items built in within this bright line rule of what's reasonable and prudent, is the issue of the fact that people can build a trucking company or organize a trucking company and register it in a day. You can literally, I could start a trucking company this afternoon and be carrying a load without any kind of safety training, any kind of safety background whatsoever. And the concern would be that there would never be time for me to be considered unfit. And then whoever has hired me willy-nilly with burying their head in the sand or maybe just taking my cheapest bid approach to them, meanwhile, I could be causing devastating results to individuals out there with an 80,000-pound load coming across the highway. So, sorry, not neutral, but that said, that's one of the issues that we're dealing with, and obviously one of the things that we're really looking at over the course of time here is this issue of broker-shipper immunity. It's not an issue that's going to go away. Just checking my time there. Okay, I'm going to pull into a little more local Minnesota case law, because here we don't have much in terms of trucking legislation that's going on, but Mike Tomsky is very involved in a case that we're going to talk about, which is the Pedro Alonso versus Richard Menholt case. Again, not my case. We have James Hoy, Kellen Bubik out of Maring Williams. They're out of the Fargo, North Dakota. They are handling the plaintiff's side of this case. And Mike Tomsky of Tomsky, Sonish, and Tomsky, to my left over here. I'm going to do the bold and daring topic of talking about a case that he's involved in so he can heckle me and he can tell me that I'm wrong when I'm misquoting and misciting, by all means. Maybe I'll just give you another microphone, Mike. So also to piggyback off of what Christy Paulson was talking about earlier today, I threw a command into ChatGPT late last night as I was finishing this. And I said, give me a image of a dangerous sugar beet truck. This is what ChatGPT thought. And I'm like, yeah, let's go for it. And so Mike, is this what it looked like? All right, pretty much that. All right. So the short of it is, and for the record, you agreed it's dangerous, right? Yep, okay. All right, so the case is an interesting one. The case involves a farmer. He's in his 80s. He's a farmer that doesn't really use the internet, doesn't really do the whole tech-savvy investigation of people. He turns on 830 and gets the weather forecast in the morning, and then he farms sugar beets. That's what he gets after. He's done this all his life. This is what he knows. This is what he's good at. This is what his family's done. This is the family farm. There's no other way but sugar beets. This is it. And that's fantastic because that's what he's been doing all his life. So he hires a driver to drive sugar beets in a farm implement truck around harvest time. What happens there is the driver had been driving for the farmer, that same farmer and that same driver, same truck too?
Yeah, well, it's the neighbor. He hires his neighbor who's driving the neighbor's truck.
Got it, okay.
Nothing to do with the truck.
Got it, so no involvement in the truck. But that said, what happened was this guy's been working for this same farmer for about 30 some odd years. So he knows this guy, he's been doing this same activity, he's been driving these, presumably different sugar beets, but same truck over the course of many, many, many years to come, or leading up to this issue. So same thing happens. That same truck driver, or that same driver drives sugar beets around, had a suspended license at the time of this incident. And that's where there's been a whole area of dispute that's really stemmed out of this. The driver caused, or there is a catastrophic collision with Pedro Alonso. Side note to this, Pedro Alonso passed away, I think it was 2 weeks before the Supreme Court argument, which was about a month ago or so, for unrelated purposes. He succumbed to cancer, but he never got to see this come to its final conclusion. But this case has marched its way from the district court to the Court of Appeals and up.
Wait a minute, is this turned on? I've been set up with a fake mic. You're trying to...
Yeah, we turned it off when you were talking to Ben.
Hello?
Do you just want to...
Testing.
There you go.
Is it working? Perfect. So in fairness, I want to make sure Tom, she's got a mic. 'Cause
Yeah.
This is both sides. Here you go.
All right, so that's, oh, this is even worse now. All right, so that said, catastrophic collision occurs. The dangerous sugar beet truck is involved in the collision. And what ends up happening is there's marginal limits relative to the catastrophic injuries sustained by Mr. Alonso. With that said, that portion handled, settled, but the issue that remains is whether or not there can be a claim against the farmer for negligent selection of an independent contractor. Minnesota District Court and the Court of Appeals both agreed there is no such thing as negligent selection of an independent contractor here in the state of Minnesota. The Supreme Court is taking a firm look at that. So Mike rather masterfully argued in front of the Supreme Court, was dodging bullets left and right, as we all know. Once we get up to that level, they're throwing questions at him, as was James Hoy that was receiving these. I think one of the rather pointed questions came from Barry Anderson, who I guess he's retiring now. So is he off the panel, or will he be writing?
I was told that there will be no dissent because he is now off the court. So any decision he would have dissented on would have been issued before his retirement.
Got it. Okay. And that buries the lead a little bit in that it sounded like, based on the questions of the Supreme Court, that they're very interested in adopting some degree of the restatement of torts when it deals with the negligent selection of an independent contractor. The question from Barry Anderson was, so if I hire Timmy from down the street to mow my lawn and he causes horrible injuries to other people, he's just an independent contractor. That's what an independent contractor does. We don't have culpability for that in Minnesota. So that's where the court started to launch into an analysis of whether the activity itself is dangerous. And what they were asking for, I think, in the questions, correct me if I'm wrong, was some guide points and some guidance on what it could be to be determined to be a dangerous activity. We're looking at carpentry, putting a nail in some boards and building a fence, versus driving a truck, versus hauling ultra-hazardous materials, and where does that land? There was a lot of questions about sugar beets, so no one looked at this picture, but I'm not so much concerned about sugar beets being ultra-hazardous, but it's more so about the weight of the truck, size of the truck, amount of the load, potential for catastrophic damages, as we were talking about earlier on. So with that said, it sounds like we may have a new tort coming down the pike, and that could have some serious impacts on truck litigation. And I mean, I don't know if it could reach as far into the rideshare Uber situations or other situations like that. Could be definitely pretty interesting to see how this pans out. I think Mike said it well when he said, I'm a lawyer, and everyone else here that handles these types of things, if this becomes the tort, we're going to be very, very busy. With that said, I think we're going to see a lot of adoption, or if we do see the adoption, we're going to see some interesting elements that need to be added to all our claims and our pre-litigation investigations that go deeply into all the different layers of the different entities that we look at when we're talking about truck litigation and the like. So really, what's the issue? Does the farmer have a responsibility to check the license status or other safety regulations or safety capabilities of the independent contractor? And that is where we enter into the negligent selection of an independent contractor issue. Now, all this could be managed or handled by this federal bill, perhaps, if the person hiring someone to drive for them becomes a broker shipper in that situation, and they've done bang, 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 one of these three things, and it's not just a local travel, local farm implement, or that type of vehicle. then we could have an immunity issue or a standard of care that's been met and then have no damages flow through that upper entity there. So we're seeing our state laws develop on the case law level. We're seeing the federal regulations and the federal legislation continue to develop, and there may be some interplay between those two. Did I butcher any portion of your case, and you wish to chastise me for it?
No, you got it right. We're going to have a new tort in Minnesota. The question is, what are the benchmarks and whether the judge will play a gatekeeping function, because the appellant was advocating in our case that it is 100% a jury issue. Just let the jury know everything that's out there, that the driver didn't have a license, he had an arrest warrant against him, etc. But my argument was that was going to require me to vet employees of an independent contractor I hired, which is, completely ridiculous. But anyway, that's
right. And for whatever it's worth, as we're playing back and forth, which is the best thing about these types of events, by the way, is that we've got the people in the room that are involved in the cases, and we're on the opposite sides of these things and able to have this discourse. I mean, I think the fact that he's been hired for 30 plus years to do the same activity probably wins that case in terms of the fact dispute as to whether or not he should have known that the license had changed and whether that even had nexus with respect to the cause of the collision as well.
100%. But I mean, to me, even more fundamental was the negligence is whether you're hiring the contractor. The contractor is the farmer. Who the farmer hires to drive his trucks that's the farmer's issue, not the hiring contractor. Because there's case law in other states that say you don't have a duty to vet the employees of an independent contractor.
Right.
And so I thought this was good facts. We know the court's going to accept this new tort, but I thought this was the best facts we could come up with. And it wasn't the regulated trucking industry. It was a smaller farm truck.
Right.
So
this one.
Yeah.
That one right there.
Yeah, well, something like that.
In that ballpark.
Is the court looking at it only in the scope of truck accidents, or are they looking at it as this being a situation with any independent contractor?
Any independent contractor.
For the webcast, let me just repeat that. The question from Jim Kirschbaum was, is this just trucking specific, or is this looking at a broader basis of the independent contractors?
Yeah, and what I kept doing in this argument was distancing myself from the trucking industry because mine wasn't regulated. And it was, you didn't even need a CDL license to operate this truck. But that was, Anderson and I were talking about if my mom, who's 90, hires a neighbor boy to haul a couch down the street and he runs someone over and kills her, my mom's getting sued. And that's just, that's the facts now. If that's what, I don't think they'll go that far, but that's what they were advocating.
Does your mom still need help moving that couch?
No. We just made sure she's got a lot more insurance.
Perfect. Get that umbrella. All right, that's all I've got, folks. I just wanted to briefly say, Brett and Lindsay, for putting this cast of characters and these speakers together, and this NIL discussion was fantastic. So thanks for putting this together, you guys.
Does it still work? Yeah, because I just got a text from one of our listening audience just telling me that my laptop screen's been open the whole day and they could see what I was doing on my computer. So good news is nothing bad. So here we go.
All right, next we have Tammy Reno. Tammy is at Nyland Johnson Lewis. She is the current president of MDLA and handles product liability and insurance defense. And despite what Brett might allege later, Tammy is the strongest Pelotoner I've ever met. So she is upset.
I did make Brett prove at my house at a barbecue how fast and hard he could go on a Peloton because I didn't believe him, and he achieved it, so I was very impressed. I'm here. Where's the clicker? it's sort of fitting to go after Eric's topic because the trucking industry is being hit pretty hard and companies are going bankrupt. I'm not here to talk about kind of the ramifications of it all, but I think everyone can kind of guess what we'll see kind of in the future. Also, I would say that Eric and I did text about what we were going to wear. We said we were going to wear purple suits. He did not comply. So what is a nuclear verdict? It's verdicts over $10 million. We had at our firm, our trial group had a jury consultant come in and talk to us about nuclear verdicts, and I think he kind of confirmed to me what I've sort of believed over the last couple years is that there are people in our country who have literally lost their minds. He showed videos of, deliberations during mock juries, and so you could see what the jurors were saying. And one thing that stood out to me is they were asked who believes that the government can control climate, and there were several of them who raised their hands. So that's what kind of what we're dealing with. So I'm kind of looking first at, and I'm reading a lot of numbers, and I can't memorize all of these, so I'm sorry if I have to look at my notes, but so kind of focusing on up to 2022, and then I'll talk about 2023. So the average of the top 100 verdicts has tripled since 2015, going from 64 million in 2015 to 214 million in 2022. And then in 2023, you will not be surprised to learn that the nuclear verdicts reached a 15-year high of 14.5 billion, which was an increase in the number of them by 27% from 2022. So that's a substantial increase. 27 of those now we're talking about thermonuclear. And if I was clever enough, I'd have a big explosion on the screen, but I didn't do that. But, and so, thermonuclear verdicts are those where, they're basically most of them are against corporations, and they're so high that people now necessitate the term thermonuclear. So thinking of that, of being over $100 million in verdicts. And also, a part of this, my topic, just so you know, these are just the verdicts themselves. They're not taking into account what actual net verdicts were after post-trial motions, appeals, and other things, so just the verdicts themselves. So since 2019, 191 over 100 million, 48 over 500 million, and 23 over $1 billion. In 2022, 20 of them were over 500 million, and 4 were over 1 billion. And here's kind of a chart that you can look at to kind of see, like, the number of them didn't substantially increase, but you can see when it kind of all started is 2020, when I think the pandemic is kind of one of the main reasons people think verdicts are going up for a number of reasons, which I'll talk about in a bit. But looking at the sum of them, so when you look at the sum, look at the increase from 2020 to 2022. Like, I literally had to sit and count the zeros to think about how high those numbers were. So that's the sum of all these verdicts. In 2022, that's the number, which I think is striking. So who is getting hit? Product liability cases account for about 35% of the nuclear verdicts. Intellectual property, 23%. And so when you look at the various kinds of cases, in some of these, there's overlap. So there could be, a wrongful death case involving a product, so some of them, or worker, so there's like overlap, but, so 211 products verdicts since 2009 at a tune of $63 billion. IP verdicts, 41 billion, going down. Breach of contract, breach of fiduciary duty are the next category, 105 of them for 175 billion. 6 wrongful deaths for 8.2 billion. Worker negligence claims 4.6 billion, and then fraud, 47 of them at a tune of $4.9 billion. So now you're probably not paying attention to me and thinking about how you could get one of these cases and retire, and I understand that. Or else, when I talk next, you're gonna be like calling your family, like, how can we move to these other states where these cases are very lucrative. So there are certain states that have kind of the bulk of the nuclear verdicts. Texas, Florida, California, Pennsylvania. My practice, since I switched to Nyland, I focus primarily on micromobility products. So I do a lot of like electric scooters, one wheels, that sort of thing. So you can imagine the bulk of my cases are not in Minnesota, where it's cold and snowy for most of the year. So I have a lot of cases in Texas, Florida, and California. So the topic's particularly interesting to me. And another thing to think about is, I'm sure you're not surprised to see the state court verdicts accounted for 108 billion of the corporate nuclear verdicts, compared to 61 billion in federal courts. So, I mean, there's a reason, we all know, why plaintiffs typically want to be in state court. It can be a lot more favorable, particularly in certain jurisdictions. And state court verdicts dominated in Florida, California, Georgia, and Pennsylvania, while federal verdicts dominated in Louisiana and Delaware. And the, what you see a lot, and I don't know if others who have kind of more national practice, where I have a lot of cases where the, particularly when there's a retailer involved, well, they'll add the retailer on to kind of make it so that we can't remove it to federal court. And I've had a lot of success lately, particularly with a big, large firm. You've probably seen advertisements in Florida where I've gotten them removed due to fraudulent joinder, or basically kind of them just naming the retailer, never serving them, prohibiting me from getting to federal court, and then I tell the court, nope, look it, they didn't serve them, the trial is in 3 months, let's get this into federal court, and which has worked. In 2023, Missouri actually had the highest verdicts. They had the $1.5 billion Roundup verdict, I'm sure many have heard of, that was slashed to a measly $600 million at the end of the day. There was also a $1.8 billion antitrust in Missouri. And so here's the state we're gonna move to, Texas. Texas, since 2009, has had the most nuclear verdicts. They've had 207 of them, totaling $45 billion. So you might ask, like, why these states? Many of them have local laws which encourage certain types of cases that are prone to larger verdicts, the presence or absence of caps on punitive damages, and then court procedures, a lot of state court procedures that favor plaintiffs. When you're looking at these verdicts, if you've kind of analyze them. I don't have time, I have 20 minutes to go over all of them, but when you look at them, the non-economic damages are completely disproportionate to the economic damages, and that's where you see the large, disparity, but the large numbers come from those. So when you're thinking about, like, why is that? Why, since 2020, are these verdicts so substantial? And, if you're a plaintiff's lawyer, it's exciting. If you have one, you have one case and get $20 million and you can retire, that's great. But if you're a defense attorney, it's scary as hell to tell your client, if you represent corporations, manufacturers, hey, let's try this case, when you do have concerns about what could happen. I was talking to one of my former partners the other day at an event and mentioned, we were talking about, having a claims adjuster say, well, should I change how I've evaluated cases for the last 30 years? And the answer was, yes, you should, because times are certainly different. Juries are different now. I mean, it's not a lot of baby boomers. We have a lot of youngsters, and I can say that as someone who's not so young anymore, but a lot of the millennials and Gen Xers are on these verdicts, and they have just a completely different mentality than a lot of us, or most of us. And there's, the social unrest and we need to hold people accountable is big. The jury consultant said, people will sometimes think, well, sorry to you, ABC Corporation, but we're going to send a message, we're going to send this message to you in hopes that there's a broader impact because of that, so that other companies will not do that. when you look at, how many of you play the lottery, you're playing Powerball, and the numbers are so high, these jackpots get so high, so people just have no concept of money. Like, money is not that big of a deal anymore, so, pinning someone with a $500 million verdict is not that big of a deal. And then other things like the reptile theory, the jury consultant we just had talked about anchoring, and that's a big topic of whether defense attorneys should anchor, and his response was no. And people who kind of joinder link lawsuits and plaintiffs so they can get to the best venue, so you see that happening a lot. I think my time is already up. I had cases, 9 minutes, okay. So I didn't, sorry, I'm old and I can't read that far. Thanks. So, when you look at, and looking at other reasons, one of the things that for, product manufacturers, for example, safety is a big thing. And when these companies look at, they think they're doing like the safest thing. Here's what I'm doing. Like, even the best practices aren't enough anymore. Like, you have to go above and beyond to make sure that you're doing what a jury will see as being the safest thing you can do for consumers. I'm just going to go kind of high level, go through a few of the cases. I'm sure most of you are familiar with the Minnesota ones, but Ahmed Mal, leg surgery, there was a zero offer. Plaintiff asked for $4.3 million, and the verdict was $111 million. A hot water burn in Minnesota was a $56 million verdict. A bank should have stopped fraud in Minnesota was a $565 million verdict. I'd say, as a side, the founders of Nyland Johnson Lewis, like in the 80s, whenever the firm was founded, they lost a huge verdict. It was like, I don't want to say $2 million or something. So in the 80s, like $2 million, was a lot. And then now when you look at the verdicts are like just so substantially higher than back then. In Texas, an internet technician killed an 86-year-old woman. It was a $7 billion verdict that was reduced to $1.3 billion. In Texas, a soft tissue pickup versus semi, $101 million verdict reduced to $32 million. In Florida, a security guard assaulted a 14-year-old girl, and that verdict was $1 billion. In Iowa, a misdiagnosis of the flu, but it was actually meningitis, $27 million. California, surgery delayed because of opioid addiction, $14.4 million. Missouri, hotel security sexual assault, $177 million. I'm sure you've all heard of the talcum powder mesothelioma cases, a $52.1 million verdict. Exposure to a light fixture at a school in Washington, $82 million. Race discrimination at FedEx was $366 million. California, defective brakes on the motorcycle, and this one I know one of the defense lawyers, and it was originally an $8 million verdict, and they appealed it and got a new trial, and the verdict was $161 million on retrial. So you can imagine how devastating that must have been. Louisiana, a death of a 4-year-old in a car crash, $409 million. And so the thing about these verdicts, and it is impacting certain industries obviously more than others, and I mentioned the trucking industry because in doing my research I read about it, and trucking companies, there are some going out of business, and then the concern is how do we transport goods across our country. There are real estate management company, there was a $2.7 billion in total verdicts in 2023, and it was an antitrust, most of them from an antitrust case. And so real estate industry is being hit really hard. And then chemicals, obviously, we know that chemicals are a big part of these verdicts. And then automobiles, oil and gas, home furnishings, food, beverage, and tobacco. And so the implication is, I don't know, and I think we all want, if someone is at fault, for them to be held accountable. And it's like, what does that look like? Like, how much money is enough, and what's going to happen? Do you necessarily, as a company, so bad that we want them to go out of business and go bankrupt? You know, maybe some people feel that way. Is there an amount that is lucrative and that everyone can live with that doesn't do that? Like, maybe that's the answer. I got my my insurance premium bills, and I was shocked at how much my insurance went up this year, and my homeowner's insurance and my car insurance. And so if you're the one lawyer who gets the, $1 billion case, bring me along on your vacation. But, it's the rest of the people in the country who are paying these increased premiums, and other things are going up. And so I say that to, good for you and good for your client. I think, that would be obviously a life-changing verdict, but they're certainly a lot higher than I think we've ever seen them. And the defense side, we have to be really careful in making sure that we tell our clients and the insurers, if we're dealing with an insurance company, what the real risks are to go to trial these days. And there are people, you want to go to trial, but you don't want to be the person who is hit with these verdicts, because we're all talking about it, and if it's local, we're all talking about it too. But they're out there, and they keep changing, and they're going to be more, and there will be more and more, I'm sure, kind of seminars about them. But if anyone's interested in the jury consultant that I just listened to, let me know, and I can give you his contact information. I think he did, if you're on the defense side, he did have some great tips for kind of combating this, which I won't share here today, and I'm almost out of time, surprise, surprise. But there are things that can be done to combat it.
Thank you, Tammy. Good job. Next up, Nate Bierke. The great thing about Nate is that you might not know, you can take him on the golf course anywhere, anytime, even though he doesn't play very often. The guy can get it around quickly and efficiently. What's that worth? Well, depending if you bring someone somewhere, that's what you want. So anyway, I golfed with Nate last summer, and I had him out, and you don't really play much, but he's got a lot of natural athleticism. Another valuable thing that no one cares about. But anyway, Nate Bierke.
The green light's on. There we go. Appreciate that. Lying. Yeah. Clicker?
Clicker should be up there.
Okay. Thank you. All right, Eric was not joking when he said I walk around a lot, so I hate podiums, so I hope this isn't distracting. I'm going to talk about using jury instructions in closing argument, but really kind of throughout your entire trial. It's ironic that I'm talking to you guys about this, because I can tell you 20 years ago, I met one of my legal heroes who was a phenomenal trial lawyer. And what they told me was, I view the law as an impediment to me doing what I want to do in front of a jury. I think somebody in here knows who I'm talking about. And I used to think that way. I was like, screw it, let's go out in the parking lot, let's go try the case, just mano a mano, let's go at it, right? I have changed my thinking on this. And part of this is, honestly, when we walk into a courtroom, I know that I have zero credibility. In fact, I have negative credibility on the plaintiff's side. I tried defense cases for 12 years, so I know that I also didn't come in with a ton of credibility there. Jurors look at us as people who are trying to trick them in large part, or trying to pull them over, or even if they don't think we're dishonest, they think, what? We're going to try to manipulate them, we're going to try to persuade them, kind of hide the bad stuff and emphasize the good stuff, right? Who do they think is the most credible person in the room? Judge, right? And who do they think is the smartest person in the room? The judge, right? So if we're fighting with the judge, that ain't helping. You know, I thought for a long time, trying cases, that I need to be the most likable person in the courtroom. I don't think that anymore. I think I need to be the most believable person in the courtroom. And if I'm fighting with the person who the jury is looking at as this is the person in charge, this is the smartest person, this is the most credible person, it's killing me. So I've kind of had a shift in thinking about this. So what I want to talk about is just the credibility we talked about. This whole process of sort of using the law as our friend starts in voir dire, right? And the judges help us with this because they are the ones who are always asking when they start their voir dire, hey, can you be fair? And if I instruct you on the law, will you follow it even if you don't agree with it, right? And what the hell are you going to say if a judge asks that to you? No, Judge, I don't think. I mean, I've never had a juror do that, but we need to adopt that. And so when we're talking to our panel in voir dire, I think we need to get into some of these issues. And, you know, depending on your judge, they may let you, they may not let you. But it's a good idea, I think, no matter what side you're on, to discuss things like burden of proof. That's important, that the jury understands that the plaintiff has the burden. If I'm a defense lawyer, when I was trying defense cases, I wanted to make it real clear. I don't have to prove anything. They're the ones who have to prove it. I'm just here, you know, to kind of open your eyes to the rest of the story. So it starts there. Then we need to enforce it in our opening statement and in our testimony. And I'm going to talk about some ways to do that as we're going through here. I think it's really important, although all those jurors take an oath that they're going to follow the law even if they don't agree with it, we need to let them know that the law is fair, right? I mean, we can have debates about minutia, I think, on the fringes, but everybody in here, we're all looking for justice. And that looks different to different people, but we all want the jury to do the right thing, right? And I think the law in general is fair, and I think juries do a good job of coming to fair results. But we need to help them understand this. So when we're talking about these legal theories, and in our civ jigs, they're better than they were 20 years ago or whenever we went to the quote-unquote plain language, but they're still confusing as hell, I think. I mean, take something as simple as direct cause, right? A direct cause is one that has a substantial factor in bringing about an event or an injury. Anybody know what that means? I mean, I don't know, right? So we need to break it down, and we need to make it explainable, and I think analogies are a great way to do this. For example, you know, in closing, what I'll do when we're talking about causation is I've got a stock image that I use, and it's a picture of a bunch of dominoes that are starting to fall. And so we talk about causation is like a domino. The first one starts the others going down the path and starts for them to fall, but it's that first one. Whatever knocks over that first domino is a substantial factor in bringing about the event or the injury. Little things like that. I do think it's really important for us as we're going through opening statement, I like to do it in, and then certainly in closing, to emphasize to the jurors, remember, you guys took an oath that even if you don't like the law, it's your obligation to follow it. And all of us rose our right hand and swore that we were going to do that. So then, and I'll do that pretty early on in a closing. And then I'll talk about one of my favorite instructions is the one that talks about how you can't consider things that were not raised in this courtroom when you're rendering your verdict. And the reason we do that is everybody sat through focus groups and watched mock jurors. Have we all, or most of us, done this? It scares the hell out of you, doesn't it? Because the stuff that they talk about and the stuff that you start hearing in these groups has nothing to do with what we're talking about, and they're just making these logical leaps, and they're coming to these conclusions based on things that have nothing to do with what we've told them or what the evidence is. You know, I have an uncle who's a surgeon, and he says that nobody should ever do a back surgery. And so, you know, I don't care what the evidence is. I don't think we can ever compensate this person for a back surgery. You know, whatever it is. But we hear crazy stuff like that all the time. So I think it's super important to explain to the jurors not only that this is the law, but why it makes sense, right? So you can't consider things outside this courtroom, not just because the judge told you to, but if we think about it, that makes sense, right? The judge's job is to make sure that this is a fair process, that everybody's on an equal playing field. And if we're bringing things that are outside of this courtroom, there's a good chance that it's not going to be correct, or a good chance that it's not going to apply. And so that's why the judge limited the evidence to what you heard. So we need to stick to that. So that's usually how I kind of do the introduction into when I start talking about the evidence with the verdict form up on some sort of an image. So I'm just going to go through a few things that I think come up a lot, that I think are really confusing potentially to jurors, and just some ideas about how to describe them. And by the way, you know, I do plaintiff's work now, but I hope my plaintiff brothers and sisters don't get mad at me for saying this. There are cases that we should lose. There are. There are cases that we should lose. There are cases that I know I'm guilty of this. I've put on blinders and I've gone into courtrooms and said, well, by God, we should win because of this, this, and this. And I've overlooked things, or I've gotten too close to my client, whatever it is. So I'm going to try to do this as neutrally as I can, because I am a big believer that we can't have a system of justice that is so one-sided. So, aggravation of a pre-existing condition. This is one that comes up in our injury cases almost all the time, unless we're representing 15-year-old kids who don't have any degeneration, particularly if we're talking about cases with neck or back injuries, right? Everybody who's over 25, 30 years old has a degenerated spine. It just happens. I used to be 5'10". I know. Yeah, now I'm 6'5". I was just thinking about, you guys were thinking like when we had Ben and Jeremiah up here, you know, man. But we all know this. So how do we explain this to juries, and how do we let them know that this law is okay, right? So one idea for, the instruction is too long and the words are too small. I'm not going to read it to you because you guys all know it. But one way to talk about this with jurors is to just say, listen, the law recognizes, because again, the law is fair. The law recognizes that we're not all 18 years old. And we all come into this world, and we live in this world with life experiences, and as we get older, things break down a little bit. But the law provides protection for us. So here's what that means. When the judge read you this instruction, it means that, okay, if this is my physical capability when I'm 18 years old, I'm 53 now, it ain't up here anymore, it's down here, right? So this is my baseline. And the law recognizes that for this space up here, the defendant, no matter what they did, they're not responsible for that because that was already there. But what they are responsible for is I go from here to here. This, folks, this area in the middle, that's what we're talking about. And if somebody hurts one of us, that's what they owe us for, is this right here. And I think that's just a simple way to kind of break down a bunch of legal mumbo-jumbo that gets compounded by medical mumbo-jumbo from doctors who don't know how to talk like human beings, as hard as we try to get them to talk like human beings when we're going through our direct examinations with them. Another thing this is going to be much more plaintiff-sided, but when we're talking about general damages, and we're all seeking our nuclear verdicts, the way that I like to do this and the way that we actually work up our cases is we start early on asking our clients and just tell them, hey, listen, these are the categories of damages that the jury's going to be looking at if we have to try your case, okay? So let's talk about these things. And so we're developing evidence on, okay, what pain? You know, if there are procedures, if we have somebody who's gone through, you know, burns and had skin grafting, or, you know, that nasty thing where they take out the cheese grater and get rid of the necrotic tissue on burns, things like that. Disability. And this is one that I think needs explanations for our clients, for jurors, that this doesn't mean that you're confined to your bed or a wheelchair. It just means that you can't do all the stuff that you used to do. Disfigurement, embarrassment, emotional distress, we all know those. But what I like to do is, as we're going through trial, start making lists, and I'll telegraph all this stuff, right? So if we're going through a trial, and so Mike, pretend your brother was my client at an MDLA event where we did a mock voir dire like 5 years ago, so you can be my client for this. If you're up on the stand, I would say maybe something to you like, so Mike, one of the things our jury's gonna have to decide is what amount of money is gonna reasonably compensate you for the embarrassment that you've gone through, okay? And now that you have this scar across your forehead here, tell us, have there been situations where you felt embarrassed by that? You know, so we'll do things like that, just to kind of telegraph where we're going. And then at the end, in closing argument, what I'll do is stand up, and I do a little bit of PowerPoint, but a little bit of, you know, just getting the old school butcher paper up, and I'll just have one page for pain. And we'll go through and we'll talk about that, and then I'll suggest a number for each one of these categories, rather than trying to lump it all together, which I think is an effective way to do it. And the other thing that it allows me to do, giving away a secret here maybe, but is at the end, if the defense lawyer just gets up and they just kind of say, well, I don't know, what's this worth? You know, 30,000, 50,000, I don't know. Then that allows us, or if you're a defense lawyer and the plaintiff's lawyer is doing that to you, you can get up and say, listen, the law says we have specific categories we need to go through, and so we need to talk about all of these. And it's obviously not going to be this if you're a defense lawyer, but you know, whether there are different elements to your tort, whatever it is, right? But going through it specifically and saying, this is what the judge is going to instruct you on, so we need to talk about all these things. Again, that helps our credibility. Burden of proof. This is one that, thanks. This is one that I think needs a little bit of explanation and closing argument. Obviously, if you're a defense lawyer, you want to get up and talk about, listen, I didn't need to prove anything to you, but we proved a lot. You know, we brought in Dr. So-and-so, we brought in our engineer, we brought in whatever experts, and here's what we showed you. And, you know, there's always these, you can use whatever analogy you want to use, you can use the scales, you can use a 50-yard line, whatever you want to use. But from our perspective as plaintiffs, one thing that I get really concerned about is, particularly when we're asking for big dollars, you know, stuff with 2 commas up in the millions, that my burden of proof is not more likely than not. It turns into, Nate, if you're asking us for $3 million, you'd better show us a hell of a lot more than 51%, right? So one thing we like to do with juries that we've kind of come up with over the years, and I know Eric's done this too, is we start talking about burden of proof and say, okay, so when you're deciding damages, the same burden of proof applies as it would for all the liability questions, all the yes-no questions on the verdict forms. And what that means, like the judge instructed you, is that we have to show you that these are the correct numbers on a more likely than not basis. That's the 51% kind of rule. And if we're thinking about this from our position in the courtroom, that's right here. This isn't like a criminal case where we got to tip it way over here to be the beyond a reasonable doubt. Now, my concern is that if you get back in that deliberation room and everybody's supposed to be standing over here. Somebody is probably going to say something like, $3 million? That's a lot of money. And I'm just not convinced. I'm not convinced. Folks, convinced is beyond a reasonable doubt. So if somebody says that, and that's human nature, it's probably something I would say. We need to bring them back. So please, when somebody brings that up in the jury room, tell them, hey, you're creeping. You're creeping over here. We need to bring it back and follow the law because that's what we swore to do. Does that make sense? Earning capacity is another one that I think is really, really hard for folks to understand. I got about 2 minutes left, something like that. 2 minutes. Okay. This one I think is a real challenge, right? There are great analogies out there, and I think we can talk about different ways to approach this. One approach that I heard over the years was, somebody may have a diamond ring that's worth $15,000 that they keep in a safe. If somebody were to come and steal that ring from them, we wouldn't say, well, you never wore it anyway. You don't get your 15 grand back or your ring back. That's like this case. My client decided to stay home so he could be a stay-at-home dad, and mom went off and made the money. Now, he was an accountant, and he had the ability to make $80,000 a year. That's like that ring in the safe. We wouldn't turn anybody away if somebody stole that ring just because he wasn't wearing it or she wasn't wearing it. It's the same thing. He's lost the ability to make that money. A couple of graphical depictions that we've used, and we focus group this, and this one seemed like it worked okay. But think about earning capacity as your glass of ice water, and your capacity has all these things, and the words that are up there, they say things like occupation, training, experience, skill, and talents. Those are all straight out of the jigs. And the glass is your health, because the glass is what holds it all together. And if your health goes, all this stuff doesn't mean anything because you can't use it. So that's just another analogy. I was trying to get through quick, and I think I maybe even have a minute to spare. So unless we have any questions, I'll sit down and let Paul entertain us. Yeah.
What were the modifications to the one jury instruction, which is
thanks.
just the 2 lines long?
Yeah. So this is, so what this is the burden of proof damages. There's a hole in the jury instructions because the jury instructions just talk about burden of proof and saying that to have a yes answer on questions 1 and 2 on your verdict form require a burden of proof that is more likely than not, and there just isn't one for damages. So I usually propose this. I usually don't get any objection to it. I mean, this is the law. It's just a hole in the standards. So this just basically repeats the instruction. It says the greater weight of the evidence must support your damages assessment, et cetera, et cetera. If you want it, I'll email you a copy. Any other questions? Okay. Thanks, everybody.
So you guys all know what this is, right? That's a short timeout, 20? We're going to take a 20 and give away some liquor. Ashley has proven to be a worthy recipient of vodka because I know she likes it. So Ashley, rather than... Greg Cooterer, because he'd prefer to have the vodka, but I already gave it to Ashley, he said, I'm all for the gin. So that's Greg Cooterer's. Spiced rum. Who wants it? There it is. Whoop. Where? No. You. All right. Not giving it. He's getting paid a lot to be here today. We don't need to give him any spiced rum. So, looks like the cooter for takes two. That's good. Mike LaFontaine has proven over the years that he retired, quote unquote, doing the ADR stuff, but he needs help in mixing a drink, so he's going to get the pre-mixed Manhattans from Tattersall. There it is. Not many more here. All right, this one's going to O'Connor because I know he drinks the whiskey I give him, but he's sitting out. Is Tim O'Connor still out there? Here he comes, out of the bullpen. We're going to the right-hander. Yep, there it is, right here for you. You don't have to come up. Just want to make sure you know you got it. You want me to come up? No. Yeah. Why not? Here, take it. Here. I wasn't sure whether you were yelling at me. Thank you, sir. Here you go, John. What? Don't drink it all. Last but not least is something I have no idea what it even is. Well, and by the way, Tattersall is our sponsor. So this is all donated by Tattersall, which you should definitely, I'm a big fan of that vodka, Tightline, that's good. And I found out at Thomas Liquor in a little dog and pony show they were running a couple weeks ago that Tightline actually isn't very good vodka. It's there, but I like it better actually because it doesn't taste like anything and it's 80 proof, so that's good. This is some kind of orange crema liqueur. Who wants that? Got to go to a female, though. Probably. Anyone? Raise your hands. Shane's taking it. Don't be bashful, Shane. Get it up there. All right. There you go. All right, that's it. You always lead in with the liquor when Paul Peterson's coming up next because he's up next and we're nearing the end here. And just for those of you that are still here, where it says we're going to go on for 40 more minutes, Lindsay and I, that will not be the case. So, but when, and we'll make this announcement too, but make sure when you leave, you grab, if there's wine and coffee left, make sure you grab it on the way out. The game plan is always to give it out during the day, but it never works because there's no time to do it. And so make sure you do that. We don't want to take any home. Prejudgment interest, it's a great topic, frankly. Mr. Peterson came up with it on his own, and I thought, that's it, because it comes up all the time, but nobody really thinks about it. So, Paul Peterson.
Thanks, Brett. Oh, thank you all. I just have to give a shout out. I'm going to move around. I do not have a PowerPoint, so you can take that down so you're not subject to me and twice, double me. There you go. Rich was kind enough to not mention that he kicked my ass in that trial we had, but I want to echo, he walks the walk on being a true professional, very cooperative to work with. We worked out a lot of different things. The video thing was funny because I said to him, yeah, we can work that out. I'll have him charge you separate. And now because he beat me, I got to fight that taxable cost. So, be careful what you cooperate on at all times. But I just wanted to say that. And one thing, Lance, you were bringing up the reasonableness on the Miller Shoe Guards. Years ago, Billy Harper and I started doing something where and first one we had a Miller Shoe Guard, and we had Chief Justice Douglas Amdahl, retired, be our neutral. And so we just gave the amount of the settlement to a neutral, third party. And Tim Tobin was the coverage lawyer. He beat us on coverage. But he said, I was racking my brain and losing sleep trying to figure out how I was going to say Chief Justice Amdahl was unreasonable. So anyway, there's ways you can get at that. One last little thing. That picture that you saw up there a little bit ago was taken in preparation for me getting in the magazine as I was becoming president of the State Bar Association. And it was a great honor to serve as president. And if anyone has an interest in the Bar Association, if you're not a member and thinking about being a member, if you're a member but wondering, hey, are there ways I can become more involved and maybe round out my practice and my professional activities with maybe something related to the bar, we've got lots of ways to lead, lots of ways to participate, and I am more than happy to take a phone call, grab a cup of coffee, go to lunch, dinner, and if you're interested, I'm more than happy to help you. I think the civil litigation and the civil trial bar is a very important part of our bar association, and we are so involved in court rules and so involved in all the different committees the Supreme Court runs that I really encourage you to think about getting involved. It was a wonderful ride for me, but I've been telling everybody, don't expect to see me at too many more meetings, but I will be staying active, much lesser role. So. The prejudgment interest was changed a few years ago, and it said anything over $50,000, we're gonna raise it up to 10%. This is back when interest rates were scrubbing along, and you get a third of a percent at a bank for a savings account, you'd be lucky, And so that change happened, and one of the primary movers at the legislature, reasons for that move at the legislature, was to encourage the settlement of cases earlier. The idea is if you got a clock running or a tab running, like with a taxi, you want to shut that off if you can. And the other one was to discourage appeals when it was just to hang on to the money. And the Exxon, the case for years that Fager and Benson was involved in, I mean, the math on that ended up working out that by hanging on to the money, they did much better than if they'd have settled the case. And so the courts and the legislature were encouraging this. And so, but one of the things that I realized in my own practice was I was overlooking it until I was trying the case. And since I don't try every case, what am I overlooking here? And that's what Brett and I got talking about that one day when we were actually working on a case, and we settled it. He was our mediator, and we got it settled. But we were talking about the 10% interest. And so I'm going to touch on a couple concepts in the statute, but I know you all know the statute, and it's the 54909. There's a companion statute for first-party coverage at 60A.0811, and of course, Rule 68 kind of dives in and out of this whole thing as well. So those would be kind of the three rules, and I'm just going to touch on a couple concepts, but then I want to talk about some experiences I've had to get you thinking about when and how should I be talking about it. From the plaintiff's standpoint, I think it can be a really effective negotiation tool and can raise your damages, and it's a fair thing in negotiation because taking a page out of our Brewster and now exceptions to Brewster for Medicare, Medicaid, things like that, when I go into a negotiation, back before Brewster, we would talk about that gap and we'd negotiate it down and work with it. And now I'll have a Medicare case and the defense will be saying, well, we want to know what you owe Medicare. And I'll say, until we're talking about paying Medicare, that doesn't matter at all to your evaluation, and I'm not going to do anything to hurt you in your earnest effort to do a good faith job of evaluating the case. And in order to do a good faith job of evaluating any case, you have to, thank you for all those who caught that, you have to know what is the jury deciding. Because what we're doing in settlement is it's like, Vikings and Packers are playing on a given Sunday. You look at the point spread, you look at the lines, you look at what is going to be the outcome of the trial. And so when I get this question on, I want to know the Medicare lien, and I want you to negotiate down off that gap, I said, if you promise me to stop using Brewster, we can talk. But until then, you're going to settle this case, because it's a Medicare case, based on what the law says. And right now, this is what the law says. So with that in mind, that this discussion of this is, in my mind, necessary. And I'm surprised both by myself and then I think generally all of us, it's kind of still an afterthought, and maybe it's because it didn't go in all that long ago. But that's what I'm here to talk about. So I kind of want to just hit a couple of concepts. Notice of the claim, all right? There was a case a couple years ago out of the Court of Appeals, Blair, B-L-E-H-R, that really sort of watered down what you need. They interpreted the statute to say you don't need to have every single factor and every single damage claim in there. With a reasonable notice of the claim, you can use that. Now, notice of the claim only comes into play if you sue it out within 2 years. Otherwise, your complaint is going to drive the time you can go back and start collecting interest. So I am very aware of when I'm giving the notice of the claim and what I'm going to be doing with it with respect to the complaint. And one example I had is I had a case where it was a very serious car crash case, but the wife was the one injured, and they tried to sort of do it. They're both professionals, but not lawyers, and they kind of were thinking they could try to work this out themselves. And when they realized they couldn't, they ended up on my doorstep. But they were 2 years into it, 3 years into it. So what I did was I just put together. I gave a notice of representation right away, but then I followed it up as quickly as I could with a settlement demand letter. And I pulled the case together quick, put the settlement demand letter in because that was pre-Blair, so I wasn't sure if my initial letter would count. But the point is I could choose, and so I did it off the complaint and did 2 years. And when I presented my interest calculations at the conclusion of the trial, I told the judge, this is my notice of claim, and I was very cognizant that I started the case within 2 years, and here we are. Because there was arguments that whether or not, when did we start the clock running on that 10%. So notice of the claim is something to keep track of and be careful about. There is that 2-year look back. The offers and counteroffers must be qualifying. And so that answers a couple of concepts. One, it has to be in writing. And when I'm sending an email or I always put it in writing, and I always will reference, consider this an offer under 549.09. That sets a 30-day clock on it. And, it's interesting because under Rule 68, we've got a different clock. So when I do a Rule 68 offer and it references 549.09, as a lot of our forms do, I think I say instead of saying you have so many days, I say you have the time periods prescribed in the above statutes and rules, or something along those lines. So, and then I mentioned the statutes, and then one last thing, it applies only to the past damages because the whole concept is we're taking a loss that happened in 2019 and we're bringing it up to $2023 or $2024. That's the basic concept behind it. So how do we kind of strategically, how do you use this? So I'm going to just use a couple of examples of where it has come up for me in different cases. So I'm going to start with that case that they were arguing about the notice of claim. I actually tried that case twice. Tried it the first time. There was determined by the judge to be misconduct on the part of the defense lawyer. Nobody here. And then it got a new trial order. And I went to the trial a second time, and I think as proof that the misconduct did have an impact, I got about another 35% on the verdict. So it was a pretty big verdict the first time. I thought much more appropriate. Still a little light. I needed that nuclear, where's Tammy? I needed to get the nuclear or thermonuclear going, but that didn't happen. We are in Minnesota after all. So, but what happened is there was an appeal. So the judge makes all his decisions. There's an appeal, and one of the questions was, well, they appealed everything. They appealed the new trial order that had been given, but that was based not on a rule of law. It was based on the judge's discretion and misconduct, which you don't get an appeal from that. So I brought a motion. I knocked out about 80% of what could be appealed, and then they were going forward, and my next letter to defense counsel's firm was, I've done the calculations for you. If you win your appeal, you will owe me $15,000 more than you do right now. Then that you're gonna. So my worst day at the Court of Appeals is $15,000 in my pocket. My best day is whatever it was, 150 or something. So the case surprisingly settled not long after that. But this is so that's kind of, it came up late. All right, where's the time when I brought it up early? Recently, I sent a letter, and this I've done a lot of I've been involved in a lot of cases involving insurance bad faith, or as I say, the breach of good faith, fiduciary duty. And I always think when I'm writing certain letters that I'm writing an exhibit for the court, because it may be used as an exhibit at a later time. I have a case going like that now with a first party situation where I think 604.18 is going to come into play. And I wrote a letter that did the interest calculations to date. So the current offer is, what I showed them is when you took it's a UIM claim, when I took the underlying settlement, the no-fault offsets, and the medical that is Medicare, and there's no dispute. There's clear liability against the at-fault driver, 100%, and there is no doubt, it was all hospitalization early on. So the bulk of the medical, there's no, are we arguing about how many chiropractic trips? These are medical that's going to get awarded. We all know it. And what I pointed out to them was they are no longer, their offer, when you took into account those offsets, but then added in prejudgment interest, their offer is barely covering the past medical at the current time, not considering that medical's ongoing, not considering substantial pain, suffering, disability, et cetera. I don't know what the effect, I just wrote that letter. But so there are times when I'm putting it in as a part of the demand letter, and I'm doing that more and more and more. Any demand letter, I look and say, what is the status of the 10%? And you got to look at ones where they really can't wiggle on it. You know, if they've got a good causation defense on medical, this 10% is something to talk about, but it's not quite as impactful as when you sort of look at it like in that case I just wrote, and they say, you know, oh man, that's right. So what I basically said to them, the damages you thought were X amount are now Y. And you need to account for that. And every day you delay, that goes up. I will tell you, I've had a couple of instances where I've gotten a big verdict, the 10% is going in, and I will admit, I maybe shouldn't, but I will admit that I get kind of giddy at those times because every day I kind of wake up, I have my cup of coffee, and I look and I go, oh, another 1,200 got added today. This is a good day. I'm having fun. I haven't even had my coffee yet, and I'm going. It is, I think it's a pressure that I'm starting to use more and more because it's real. It's the reality. And I think I want to encourage you on that. One time that I used it, I thought really effectively, was in a mediation. And what the case was very unique, and I won't get into too many details, but really the one item of damage that was known and there was going to be really solid liability was the past medical on that. And so as we got into the mediation and negotiating, I didn't plan on this to happen, but it sort of became, Brett, you're the mediator, right? So you come into the room and you go, well, they're willing to pay this much. And I say, well, how are they coming to that? And he'd go back and come back in the room. You weren't involved in this one. It was a different, but, you know, well, they're yeah. So what ended up happening is the negotiation became the medical plus. The medical plus. And early on in the day, that became the conversation. The past, because they were basically conceding they owed the past medical. So I made a decision in the midst of that. I thought, I'm going to talk about 10%, but I'm going to wait. And so what ended up happening is, at the end of the day, the settlement agreement was, and they presented it this way, we will pay you past medical plus fill in a number, who cares, $50,000. And I said, we may have a deal, but here's the reality. That past medical is not what they think it is. Because as of today, that past medical is actually $90,000 more dollars based on the calculations. Here are the calculations. Here you go. Here's the rule. Boom, boom, boom. Mediator went back in the other room. We settled the case for the past medical plus $50,000. That $90,000 was in it. And so that was one that just kind of happened that way, and it worked out really well. But I know the people in this room are great. And I always get intimidated trying to talk to a room of really, really good lawyers who know what the hell they're talking about, because I'm like, God damn it, they're going to find me out. They're going to find me out. They're going to figure it out. But the thing is that I love sharing these ideas, not because I think I'm wonderful or that I've done something great. I share it because I know if I get creative once, you guys are capable of doing it 10 times more than me. But I'm trying to get the juices flowing on this. And from the defense side, you know, I think it's incumbent upon you to get this issue in there when they're doing, Nate was around here, when you're doing the claims committees and you're doing the evaluations, you're getting all the input, especially on a big damage case, you better have that on your radar. Even if you're kind of, let's say the plaintiff's not paying attention to it, okay? You know this might be a case to get done now in mediation before they start adding that into their calculation. So I think the creativity part is not just one-sided, and I think there's ways to do things. For instance, State Farm is a company that pays partial damages, right, on a UIM claim. They have been in some cases. It's not been quite as routine in my experience. I don't know what you all are experiencing. But it was appropriate in a case for me to say to them, hey, you're usually paying this amount as kind of your evaluation. You've offered this much, and I asked you, and here's the other thing. If you've got a plaintiff making an offer, defense, ask them to break it down if they can, but if the defense is usually willing to kind of tell me how they're breaking it down so I can see how they're looking at it, where they'll say, we're conceding the meds, but we don't think it's going to be this much here, or we don't think you're going to get all the meds, you're going to get 80% of them. Whatever that discussion is, it's important if you can get it going. It's a good discussion to have. And, so from that standpoint, I actually have at times gotten partial payments based on, hey, you want to argue about pain and suffering, we got time to do that. We can figure that out, but why don't you pay this medical now? Why don't you pay this much now? That way you shut off 10% at least on that amount. And the statute does have intricate ways. If you go back to the statute, every case you have, that's the best advice. I didn't want to do a PowerPoint and go through the statute and do all that. You have to, that thing, first of all, is not the easiest to work through, and it's important to have your specific case facts in mind. Because, for example, a qualifying offer, we mentioned that earlier. If I've got multiple defendants, I have to be careful how I'm making an offer if I wanted to qualify under 54909. Right? Am I making Behringer offers? Am I making a global offer? If I'm making a global offer and maybe, I end up doing Behringers later and I try to use that offer as a notice of claim or as that demand as a notice of claim, it might not qualify because it's too vague as to what each individual defendant was supposed to do with it. So these are all the things to kind of think about, look at, and I always say, I just think it's something that's been a little bit underutilized, and I've been using it more and more routinely. Maybe I'm the one that's late to the party, and you guys are all going, what the hell are you talking about, Peterson, So I am going to wrap it up with that, but I'll just open up any questions or thoughts. I told you, smartest group in the Twin Cities. All right, thank you.
We're running short on time, Brett.
No, we're not. We're never running short on time. We're nearing wrap up here. Security alert. Oh, that's good. Yep.
All right.
Okay, so what do you want to start with?
Yeah, I'll start. So Brett and I are both really involved in the community outside of the legal realm, which I think is really important. I know we talked about, a lot of people in this room are involved in whether it's MSBA or MDLA or MAJ, which is great. But I think also getting involved outside of anything legal is important. Getting lawyers out, doing whatever work that is. Both Brett and I are members on different nonprofit boards, and we both have donated money and time to Ballet Collaboratory. So on the very back, I think it's important, arts are dying, and it's really also specifically dance in Minnesota, which is near and dear to my heart. I danced growing up and through college, but with the closing of the Kohl Center, downtown Minneapolis was really detrimental. I've been the chair of the board for about a year and a half. So I just wanted to bring this 1 minute kind of free advertising to them. It is the largest nonprofit professional dance company and school in Minnesota. It's in St. Paul. They have a performance this weekend. If you're interested, I do have some tickets, so come and talk to me. I have 4 tickets. It's at Concordia St. Paul, a ballet original work of Little Prince. But also, if you're interested, there is a place to donate. Any amount is great for them. And then also the annual report if you're interested in what they're doing. But they really focus on bringing equality to ballet, which is extremely important. It's been very kind of male-dominated dance choreography throughout the years. It's always like the Nutcracker or, things of that nature. But so it's really innovative and new choreography. So just wanted to talk about that for 1 second. Thank you. Oh, and then segueing into golf. So if you've noticed, no one is golfing today. Beautiful day. The golf course here has been closed since last May. Only 9 holes were open. It's not going to open until July, and then no guests until next year as they let the kind of turf grow in. But Brett usually gives a round of golf out at Town and Country. We thought we would do the same here, but it's going to be in 2025. So if you're interested in golfing with a great golfer and a really poor but very fast golfer in 2025, let me know or email Brett or me by 5.
Leave your card.
Leave your card with one of us, and we'll do a random drawing, and we will email the winners. And next year, we'll go out. All right.
And I'm not I'm a really fast golfer. Not as fast as Josh Tookshire, who was here, but I'm pretty fast. So.
Ready for the slide?
Oh, no, we're not ready
Not
for
yet.
that.
Okay.
Make sure, if you stick around, great. If you don't, grab beer, or excuse me, grab wine or coffee on your way out. We've said that like 20 times, but we still have a lot of it there. That would be good if you grabbed it. We really thank you for coming. This has been a great seminar in terms of attendance. The presentations have been second to none. 20-minute pops works really well because keeps things flowing and no one has to spend an eternity preparing. So we really appreciate everyone's attendance. And we actually had to turn people away for in-person this week because of the numbers. And then, so there's a lot of folks on live stream today. We thank everyone for coming. We thank our speakers for all the great work they did and the time they invested. And
our sponsors.
And our sponsors, too. Make sure you use them. I've said it before, but just looking back, I would have liked to have had them be a little more in the middle out there, but that's the way it was set up, so it's the way it is.
But that's where social hour will be when we wrap up, so make sure that you visit them.
So use your sponsors. They all have great services that we all use anyway. Let's see, what else do we want?
Thank you, too.
Yep. Yeah, thank you. Oh, and I did a ton of work putting this together, leading up to the last 2 weeks. But the last 2 weeks, Lindsay has done frickin' like putting this agenda together and getting all those emails out to people, the stuff that I hate doing. So the last 2 weeks have been like, I was very thankful for her efforts on that front. I know that people were thinking, why doesn't he quit talking? But God, I love being in front of a group. And our closing PowerPoint is abbreviated. So we're shaving 4 or 3 out of 5 slides off, which are movie clips. But we are going to end with the last minute and a half of an event that always makes everyone leave a seminar thinking, that was the best damn seminar I've ever been to. So, we'll, ready to go on this?
Ready to go.
All right, first clip.
Well, it's a slide.
Slide. Okay, so I had a movie slip that it's about 4 minutes, and I think Nate had it earlier. If Nate's still here, he pulled the quote out, but that is really critical to success in this world we live in and in life in general. So keep your friends close, keep your enemies closer. And The Godfather's always worthy of a watch. It's on Apple right now, as is Godfather 2. So tune in and watch it again. I'm on my 32nd viewing. This is the clip from Wedding Crashers, the mediation scene. It's 6 minutes long. It's really raunchy, but it's a great movie clip. We will not show it, but it is the best. Mediation scene. That one that Shane showed earlier is also one of my favorites with on the, right? Was that Shane on that?
Yeah, with my cousin Vinny?
Yes. With, what's his name? George Clooney. Great. This is a great scene, too. I've used this one in how I always use it. Is Ralph still here? Oh, yes! So this is how to really make your mediator mad. It's to go into the other room and think you can negotiate better than the mediator. And this is the slide I use for that, but we won't watch it today. Ralph's been known to do that to me a couple times, but he enjoys that process because he knows how much it aggravates me. All right. One more? Okay. So, and it's more than 20, so you have to do that one thing again, accepting the, it was that thing you did at the beginning where you accepted the, Is Pat Conlon still here? That's too bad, because one of the people in this video, he played some high school hockey with at Mounds View. This is the PowerPoint creators problem, not mine. That'd be Lindsay.
Pretty sure you emailed it to me at about
It worked
11
earlier
p.m.
on my computer. When you did that, when he did that thing that says about accepting the.
I don't know. Just talk about it.
No, it's going to happen.
I don't think
We're
it's
sitting here until it plays, and if I have to use mine. Yeah. I just played it on mine earlier. Worked like fine.
I know, it's not gonna work.
That's it. We're not on the internet.
That's probably why.
Boom.
Losing it to Silk. Now Petrov controls. Back to Varlamov. Skating in on the left side. Into the American end. 55 seconds. But Mikhailov has the puck. Mikhailov sweeping in. Out in front. Backhander goes wide. I think Creighton might have got just a piece of it. Mikhailov back out to Ilya Leonov. 43 seconds remaining. Morrow checked into the boards. It comes back to center ice. 37 seconds left in the game. Petrov with it. The Americans on top 4-3. Long shot. Craig able to get a piece of it to sweep it away. 28 seconds. The crowd going insane. Varlamov shooting it into the American end again. Morrow is back there. Now Johnson, 19 seconds. Johnson over to Ramsey. Ilya Leonov gets checked by Ramsey. McClanahan is there. The puck is still loose. 11 seconds. You've got 10 seconds. The countdown going on right now. Morrow up to Silk. 5 seconds left in the game. Do you believe in miracles? Yes! Unbelievable.
See? When you walk out of here, you got to be happy, right?